ಕೋರ್ಟ್ ಆಫೀಸರ್ ನಾವು ಆಡಿಬಲ್ ಇದ್ದೀವಾ?
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಆಡಿಬಲ್ ಇದೆನಾ? ಕೋರ್ಟ್ ಆಫೀಸರ್
ಕೋರ್ಟ್ ಆಫೀಸರ್ ದಯವಿಟ್ಟು ಕನ್ಫರ್ಮ್ ಮಾಡಿ, ಆಮೇಲೆ ಪ್ರಾಬ್ಲಮ್ ಆಗೋದು ಬೇಡ ಅಂತಷ್ಟೇ.
ಕೋರ್ಟ್ ಆಫೀಸರ್
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಆಮ್ ಐ ಆಡಿಬಲ್?
ಸರ್ ನನಗೆ ಕೇಳಿಸ್ತಾ ಇದೆ, ಬಹುಶಃ ನೀವು ಆಡಿಬಲ್ ಇರದೆ. ನಾನು ಕೇಳಿಸ್ತಿದ್ದೇನೆ ಸರ್ ನಿಮ್ಗೆ?
ಮಾತಾಡೋದು ಕೇಳಿಸಿದೆ ಸರ್.
ನಾನು ತಾವು ಮಾತಾಡೋದು ಕೇಳಿಸ್ತಾ ಇದೆ, ಆಡಿಬಲ್ ಇದೆ ಸರ್, ಪರವಾಗಿಲ್ಲ.
ಓಕೆ,
ಮ್ಯೂಚುವಲ್ ಕೇಳಿಸಿದ್ರೆ ಆಡಿಬಲ್ ಇರುತ್ತೆ ಸರ್.
ಹೌದು ಸರ್, ಹೌದು.
ಥ್ಯಾಂಕ್ ಯು ಸರ್.
So 2:30, wait. One Bangalore matter for tomorrow minutes. Tomorrow minutes. ಗೊತ್ತಿಲ್ಲ, ಗೊತ್ತಾಗ್ತದೆ.
ಸಿಸ್ಟಮ್ ಸರಿ ಮೇಡಮ್, ಸಿಸ್ಟಮ್ ಕ್ರಾಸ್ ಇದೆ ಸರಿ. ಅಲ್ಲ ಹೈಟ್ ಅಲೈನ್ಮೆಂಟ್ ಸರಿ. 2:30 ಏನಿದೆ ಎಲ್ಲ ಕೊಡಿ, ಅರ್ಜೆನ್ಸಿ ಇದೆ ಮಾತ್ರ ಕೊಡಿ. ಫೈನಲ್ ಹಿಯರಿಂಗ್ 2:30 ಮಾಡಿ.
2:30 lordship, 2 matters.
One election
matters are listed.
Kodi,
please.
I presume that there is urgency and take it.
Election matter, my lord.
Straight. Sir, don't stuck.
Connected matter, adjute. Lordship, one matter for
2:30 ಎಲ್ಲ ಕೊಡಿ.
Lordships, one matter for 2:30. The Milords, interim order is already.
ಮುಂಚೆ ಬೇಕಾ?
ಇಲ್ಲ. Lords, interim order is already granted in my petition. Petitioners who had sought for voting rights from the very same society. Another matter is listed today, my lords. It can be disposed of along with that, my lords. I'm moving for disposal. That's the reason why I mentioned.
Kodi. Yes.
Grateful.
Tomorrow matter on Friday, lords. Tomorrow announcement.
Kodi. ಯಾವಾಗ ಬೇಕು ಕೊಡ್ತಾ ಇರಿ. No problem. ಅಲ್ಲ Bangalore matters ಬರೀ 65 ಇದೆ ಅಂತ.
Kind permission. Lords, sir.
Cause list.
Serial number 137, my lords.
Yes.
Oh, ಇಲ್ಲ, sorry sir, it's here.
That's one humble submission. That's 148 serial number, my sorry.
ಅಲ್ಲ 137.
137, my lord, submitting on behalf of CS Setter, I am filing memo for withdrawal, my lord.
Thank you, sir. Good. Yes. In terms of memo.
That's 148 minutes. I request only 2 days time not to comply with the office objection. There are minor
ಅದು-
office objection.
ಒಂದು ನಿಮಿಷ.
148 minutes.
ಕಾಮನ್ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡ್ಬಿಡ್ಲಾ?
Please.
ಮೇಡಮ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ತಗೊಂಡ್ಬಿಡಿ ಈಗಲೇ. ಎಲ್ಲಿದೆ?
ಆಫೀಸ್ 129. serial
Weeks, ಒಂದು ನಿಮಿಷ. ಏನು ಓವರ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ತುಂಬಾ ಇದೆಯಾ? ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಷನ್ ಇಲ್ಲ, ಎಲ್ಲ ಹಾಕಿದ್ದೀರಾ? ಇಲ್ಲ ಆಯ್ತು, ಬಟ್ ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಷನ್ ಅಂತ ಬರ್ಬೇಕು ತಾನೆ. ಆಲ್ ರೈಟ್. 132 ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಓವರ್ ರೂಲ್ಡ್. 133 ಅಲ್ಲಿ ನಾವು ಪ್ರಶಾಂತ್ ಮಠಪತಿ ಮೇಡಮ್ ಒಂದೊಂದೇ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇದ್ರೆ ಓವರ್ ರೂಲ್ ದೆಮ್, ಲಿಸ್ಟ್ ದೆಮ್ ಆಲ್ ಆನ್ 6th in the fresh matters list. 6th fresh matter. ಇವತ್ತಾಯ್ತು 53 ಅದನ್ನ ನೋಡ್ತೀನಿ, ಬಟ್ ಇನ್ ಮಿಕ್ಕಿದ್ದೆಲ್ಲ ಅದೇ ಮಾಡಿ. week's time is granted to comply with the office objections. ಅಲ್ಲ, week's time is granted to comply with the compliable office objections. In the event they stand complied, list them all on the fresh matters list on 6th. ಆಗ್ಬೋದಾ?
Obliged.
One matter at 2:30. The lodge.
ಕೊಡಿ ಸರ್,
ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ತಾವು ಪೊಲೀಸ್ ಪ್ರೊಟೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ರಿ.
ಕೊಡಿ ಸರ್. ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ ಆದ್ರೆ AGAಗೆ ಹೇಳಿರಿ.
ಆಯ್ತು, ಹೇಳ್ತೇನೆ.
ಯಾವ್ದು
Small
date
submission.
time ಅಲ್ಲಿ ಹೇಳಿದ್ನಲ್ಲ ಅದಾ?
ಅದು ಪೊಲೀಸ್ ಪ್ರೊಟೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ರಿ ತಾವು.
ಹೌದು.
Now what they interpret is respondents. It is only for harvesting. You are not permitted to flow the water or do the not any work.
ಸೆಕ್ಯೂರಿಟಿ ಬೇಕಾ?
ಇಲ್ಲ, ನಾನು ಅವರು ಪ್ರೈವೇಟ್ ಪ್ರಾಪರ್ಟೀಸ್ ಅಗೇನ್ಸ್ಟ್ ಇಂಜೆಕ್ಷನ್ ಕೇಳಿದ್ದೀನಿ ಅಷ್ಟೇ.
ಆಯ್ತು, ಮೂವ್ ಮಾಡಿ
ಎಲ್ಲದಕ್ಕಲ್ಲ ನಾನು ಕೇಳಿದ್ದು.
Submission, my lord.
ಅಂತ ಹೇಳ್ಬಿಡಿ. ನೀವು ಕರ್ನಾಟಕ ಪೊಲೀಸ್ ಶುಡ್ ಪ್ರೊಟೆಕ್ಟ್ ಯುವರ್ ಹೌಸ್.
No, my lord.
All right.
Whenever it is required, we are before your lordship.
ಯಾರು ಬೇಡ ಅಂತಾರೆ ಪ್ರೊಟೆಕ್ಷನ್?
Submission, my lord.
Difficulty, my lord.
Huh?
May be taken tomorrow.
tomorrow ಕೊಡಿ, ಡೋಂಟ್ ಇವನ್ ಮೆನ್ಷನ್. ತಗೊಂಬಿಡಿ ಮೇಡಮ್ ಎಲ್ಲ.
Serial number 109, my lord.
ಇಲ್ಲಿ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಪ್ರಿಲಿಮಿನರಿ ಎರಡೇ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಲಿಸ್ಟ್ ಇದೆ ಅಷ್ಟೆಲ್ಲ.
Small submission, my lord.
ಥರ್ಡ್ ಟೈಮ್ ಅದು ಅಷ್ಟೇ. week's time in the event they stand complied, list them on 12th February in the fresh matters list. ಆಮೇಲೆ fourth time peremptory order ಮಾಡಿ 2 days. 148. The council seeks 2 days time to comply with the office objections. Finally, 2 days granted. In the event they stand complied, list the matter on 6th in the fresh matter.
serial number 129, my lord. Taken up on 12th, my lord. Connected matters are coming up on 12th, my lord.
Guest lecturer.
ಅಲ್ಲ, it is my arrears of salary.
Arrears of salary.
ಅವ್ರು ಕೇಳ್ತಾ ಇದಾರೆ, ಆನ್ ಪ್ರಮೋಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಆನ್ ಪ್ರಮೋಷನ್ ಕೊಡ್ತಾ ಇಲ್ಲ ಅಂತ.
All right.
On 12th, it's my lord, matters are coming up, my lord.
ಆಯ್ತು.
129.
Okay.
One writ petition, stoppage of pension tomorrow. B group ಅಲ್ಲಿ ಇದೆ ಅದು ಮರಡಿ.
ಆಯ್ತು, ಕೊಡಿ.
ಫೈಲ್ ಸಿಕ್ಕಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾ ಇದ್ರು. I moved it earlier.
ಈಗ ಫೈಲ್ ಸಿಗುತ್ತೆ.
ಅದಕ್ಕೆ
ಯಾಕೆ ಫೈಲ್ ಸಿಕ್ಕಿಲ್ಲ ಕೇಳಿ?
sorry, my lord, serial number 75. And for the respondent KIDB, my lords, I request weeks time.
That I will grant, sir.
Please.
When it reaches.
Serial number 109, my lord.
ಹೋಗ್ತಾ ಇದ್ದೀರಾ? ಇರೋ 6 ಕೋರ್ಟ್ ಇಲ್ಲೇ, 10 ಕೋರ್ಟ್
The
ಇಲ್ಲೇ.
only matter, my lords, I have some personal income.
Don't worry. That is grant.
Serial number 109, my lord.
Petitioner is.
2011 ಇಂದ ಯಾಕೆ ಪೆಂಡಿಂಗ್ ಇದೆ ಸರ್ ಇದು?
But what happened is, but during pendency of the writ petition, the earlier chairman died, therefore the application is pending. But what happened is, in view of not coming.
ಮೈಕ್ ಯೂಸ್ ಮಾಡಿ, ಆನ್ ಮಾಡಿ, ಮೈಕ್ ಯೂಸ್ ಮಾಡಿ.
Sorry. But in view of repealing of Bombay Trust Act, the earlier trust came to be dissolved. And under the provisions of the Karnataka Society Registration Act, the society came to be registered. The third respondent here, now he is no more, his legal representatives are there, but had claimed that he is the chairman of the earlier trust. He filed a suit that came to be dismissed, 2 suits. He preferred RA that came to be dismissed. Even he challenged the registration of the society itself before this honorable court. Writ petition came to be dismissed. Writ appeal preferred dismissed. But thereafter he approached the district registrar, questioning the registration that came to be dismissed. Reached finality. But in the meanwhile, the teaching post became vacant. Therefore, the petitioner herein had filed a writ petition before this honorable court. That came to be allowed. The government is directed to permit the petitioner society to fill up the teaching post. He challenged it before this honorable court by way of writ appeal. That came to be dismissed. Thereafter, but the permission accorded by the commissioner also challenged before the secretary, education department. That came to be dismissed, rectified. That came to be dismissed. And now, in the meanwhile, as per Annexure J, page number 86, absolutely there is no direction issued by this honorable court in the writ appeal that the second respondent has passed an order saying that the trust registered under the Bombay Trust Act is different and the society registered under the Karnataka Societies Registration Act is different. So this is what challenged before this honorable court.
Intermodal, yeah? Intermodal, yeah.
Yes.
Who is the answering respondent?
Pardon?
Who has to answer this?
That is respond number 3, my lord.
Who is respondent number 3?
Respond number 3 is the chairman.
ಯಾರು
of the-
appear ಆಗ್ತಾರೆ ನೀವಾ?
Please.
ಹೇಳಿ, yes.
Just the respond number 3 is the chairman of the trust registered under the Bombay Public Trust Act. After abolition of the Bombay Public Trust Act, that the government has directed that the provisions of section 1920 is applicable to the trust registered under the Bombay Public Trust Act. But provisions of Society Registration Act is not applicable to the Bombay trust registered under the Bombay Public Trust Act. Whereas the petitioner herein and some other persons who are having ill will against the present respond number 3, and they have formed a society and registered it under the Karnataka Society Registration Act. And that it is a different matter. The provisions of Karnataka Societies Registration Act are not applicable to the trust registered under the Bombay Public Trust Act. The registrar, that district registrar, has clearly opined that, and he has clearly stated that both the trusts are different.
When was the registration done?
It is 2000, that in the year 1967, Bombay Public Trust Act under
Registration under the Societies Registration Act.
2004, my lord. 2004.
You challenge this?
Once I
Did you
challenge,
challenge this?
I have filed a application before the district registrar to cancel that registration.
What happened to that challenge?
That he stated that the trust registered, trust or society registered under the Karnataka Society Registration Act is different. And trust registered under the Bombay Public Trust Act is different.
Where is the order?
That is, they have challenged that order itself.
No, I am not talking of today, sir. I am talking of 2004, after the registration. What are the litigations that you generated?
That I have produced, Your Honor, that along with my objections, I have also produced.
ಯಾಜಿ ಅವರೇ, first petition ಯಾವ್ದು ಹಾಕಿದ್ದು?
Yes.
2004 registration challenge ಮಾಡಿ first petition.
Yes. I also produced it. But page number 75, annexure F.
First petition ಯಾವ್ದು ಹೇಳಿ ನೀವೇ?
WP number.
Page 75.
Oh, 75.
ಎಲ್ಲ ಹಳೆ ಮ್ಯಾಟರ್ ನೋಟ್ ಮಾಡ್ಕೊಂಡ್ ಬರ್ಬೇಕು.
22897 of 2005.
22897
of 2005 was challenged.
ಒಂದ್ ನಿಮಿಷ ಸರ್,
Please.
ಹೇಳಿದ್ದೇನು?
I produced the writ appeal copy.
Where is the writ petition? What happened in the writ petition?
Writ petition came to be dismissed on merit.
On, that is challenged by him.
How? Page number 75, the writ appeal order copy.
Why writ petition ಹಾಕ್ಬಿಟ್ರೆ ಏನ್ ತೊಂದರೆ ಆಗುತ್ತೆ ನಿಮ್ಗೆ? Sir, 14 years in the pending ಇದೆ, we are all accountable to the public. If this is the way, then ಹೆಂಗೆ? ಒಂದು writ petition copy ಹಾಕ್ಬಿಟ್ರೆ ಏನ್ ತೊಂದರೆ?
Sorry.
What, sir? Yes.
75 is the writ appeal copy.
1 minute.
Please.
22897 of 2005. 11005. All right. Writ appeal ಏನಾಯ್ತು?
Writ appeal dismissed.
Who was the petitioner there?
But the petitioner,
The writ petitioner
but
was
he-
the appellant.
but he claimed himself as the chairman and filed a writ appeal.
ಒಂದ್ ನಿಮಿಷ sir.
ವಿಜಯ ವಿದ್ಯಾವರ್ಧಕ ಸಂಘ, ನಿಂಗಪ್ಪ ಭೀಮಪ್ಪ ಹೂಗಾರ್.
ನಿಂಗಪ್ಪ ಭೀಮಪ್ಪ ಹುಗಾರ್.
Third respondent will present rate petition.
All right, 1 minute, yes, yes. Writ appeal is dismissed.
Yes.
No, however, appellant may seek appropriate relief in pending matters before the competent forum.
Yes.
All right. So WA, WP, error dismissed.
Dismiss ಆಯ್ತು.
What was the contention taken there in the writ petition?
Same contention which was.
Same ಅಂದ್ರೆ ಏನಾದ್ರು ನೋಡ್ಬೇಕಲ್ಲ?
ಅಲ್ಲ, suit ಅಲ್ಲಿ ಏನ್ contention ತಗೊಂಡಿದ್ರು ಅದೇ ತಗೊಂಡಿದ್ದು. I produced not the judgment.
Writ petition copy ಇದೆಯಾ?
Yes, judgment and decree.
ಆಯ್ತು. ಈಗ ಫಸ್ಟ್ ಸೂಟ್ ಫೈಲ್ ಮಾಡಿದ್ಯಾ ಅವಾಗ?
ಅವರೇ ಮಾಡಿದ್ದು.
ಇದಾದ್ಮೇಲೆ
ಹೌದು, ಅವರೇ ಮಾಡಿದ್ದು.
where is the plaint in the suit? ಇಲ್ಲಿ ಹಾಕಿಲ್ಲ ಅದು as usual.
Number 36 annexure E.
Where is the order in OS?
Yes.
Yes.
Page number 36 note.
OS 12 of 2004,
ಎರಡು ಹಾಕಿದ್ದಾರೆ.
17 of 2004.
Yes, both are came to be dismissed.
Both dismissed.
Yes.
Regular appeal,
Regular appeal page number 54. RA 109 of.
RA dismissed.
Yes.
Against the RA?
No.
ಏನು ಇಲ್ಲ.
Reached
Final.
finality.
What is the finding there?
Finding is that Malad, he is not the chairman, has not, he could not Malad prove before the trial court.
No, 1 minute. What was the prayer? Suit for declaration?
Yes.
Suit for
Suit is-
declaration, the suit has been dismissed on the ground of jurisdiction.
Anyway,
it
that
is
has
not
become final.
maintainable.
Yes.
On the
RA
ground-
lo dismissed.
Dismiss ಆಗಿದೆ.
All right. Next is writ petition.
Next.
Writ petition dismissed, writ appeal dismissed.
Yes.
Writ appeal dismissed for non-prosecution.
Non-prosecution.
Yes.
ಯಾವ writ appeal? Non-prosecution ಗೆ.
Writ appeal,
There is a detailed order, sir.
writ petition.
Writ petition may be anything. Writ appeal is dismissed on merits, not on non-prosecution.
But since annexure J may can be seen for.
Page ಹೇಳಿ.
Page number not 86.
What is that?
Yes. This is the impugned order. ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಸಂಚಾರಿ ಪೀಠ ಧಾರವಾಡ ಇವರ ರಿಟ್ ಅಪೀಲ್ ನಂಬರ್ 502 of 2008. ಅರ್ಜಿದಾರ ಸೋ ಸಲ್ಲಿಸಿದ್ರಿಂದ ಸದರಿ ಅಪೀಲ್ ಮೇಲೆ ವಿಚಾರಣೆ ನಡೆಸಿದ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಸಂಚಾರಿ ಪೀಠ ಧಾರವಾಡ ಇವರು 21/2/2011 ಅರ್ಜಿದಾರರ ಬಾಕಿ ಇರುವ ಪ್ರಕರಣಗಳಿಗೆ ಸಂಬಂಧಿಸಿದ ಸಕ್ಷಮ ಪ್ರಾಧಿಕಾರದ ಮುಖಾಂತರ ಸೂಕ್ತ ಪರಿಹಾರ ಪಡೆಯಲು ಆದೇಶಿಸಿದ್ದರಿಂದ ಅರ್ಜಿದಾರರು ಹಾಗೂ ಎದುರು ಅರ್ಜಿದಾರರಿಗೆ ಈ ನ್ಯಾಯಾಲಯದಿಂದ ದಿನಾಂಕ 25/2/2011 ವಿಚಾರಣೆ ನಡೆಸಲು ಸಮ್ಮತಿ ನೀಡಲಾಯಿತು. Absolutely, there was no murder case was pending as on the date of disposal of the rejection of the writ appeal.
Annexure H ಏನು?
Annexure H my lord.
Writ appeal ಯಾವ್ದದು?
What? 32.
So no court
Yes.
has considered on merits. ಎಲ್ಲ non-prosecution jurisdiction ಅಷ್ಟು.
Request reconsideration.
ಹೇಳಿ.
Your Honor,
But
please.
annexure,
Wait.
but annexure C, he was earlier was the member of the committee constituted under the provisions of the Bombay Trust Act, in which he made a mischief that I also produced before this honorable court.
No, his argument is that society cannot be registered under the Societies Registration Act. It has to be under the Bombay Trust. That is what is to be decided. Now this order is passed against you saying what?
Two societies registered, my lords, on the same name.
Huh.
So this order is passed, my lords, saying that not to interfere.
Which is,
Here, I have filed objections, my lord. Along with the objections I have produced, annexure R2. Annexure R2 may please be looked. Page 17.
yes, ಹೇಳಿ.
ಮೇಲಿನ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಪತ್ರವನ್ನು ಬರೆದು ಮುಂಬೈ ಸಾರ್ವಜನಿಕ ಜಿಲ್ಲೆಗಳ 19 ನಡೆಸಿಕೊಂಡಿದ್ದು ದಿನಾಂಕ 1/5/2003 ಜಾರಿಗೆ ಬಂದಿರುವ ಕರ್ನಾಟಕ ಹಿಂದೂ ಧಾರ್ಮಿಕ ಸಂಸ್ಥೆ ಧರ್ಮಾದಾಯ 1997 ಅನ್ವಯ ಕಾಯ್ದೆ ವ್ಯಾಪ್ತಿಗೆ ಒಳಪಡದ ಶಿಕ್ಷಣ ಸಂಸ್ಥೆಗಳು ಹಾಗೂ ಇತರೆ ಸಂಸ್ಥೆಗಳಿಗೆ ಚಾರಿಟೇಬಲ್ ಅಂಡ್ ರಿಲಿಜಿಯಸ್ ಟ್ರಸ್ಟ್ ಆಕ್ಟ್ 1920 ಅನ್ವಯವಾಗುತ್ತದೆಂದು ಸರ್ಕಾರದ ಸುತ್ತೋಲೆ ಸಂಖ್ಯೆ ಸೋ ರಲ್ಲಿ ಸ್ಪಷ್ಟಪಡಿಸಲಾಗಿರುತ್ತದೆ.
You have created the problem.
The order itself, my lords, they ought to have considered in accordance with law. The order itself is, my lords,
And
requires reconsideration as, my lords,
thereafter,
he has passed the order, my lords, not to interfere with the, my lords, the business of each other. Instead of, my lords, looking into the, my lords, whether the society registered under the, my lords, the old act and.
That requires an answer.
And another submission, my lord, that annexure R4, annexure R4 may please be looked into. The order passed by this district registrar. Detailed order has been passed. Annexure R4, page 26 in objections.
Page 26.
26, my lord. And detailed order has been passed, giving both the opportunity to both the parties. He has passed detailed order. In that case, in that order, he has clearly mentioned, he has in the order, the operative order that pay at page 33, my lord. Operative portion of the order at page 33.
That we'll see, we'll answer it. Order reserved.
May I request on next week, my lord?
What's the matter?
Other days matter, my lord, so please to hear for some time.
2013, sir. Yes.
My lord, request for training program, my lord, that is an appointment. Yes, for the land loser. Family member of the land loser, my lord. Their contention was that, my lords may kindly recollect, sister of the, my lord, person who lost the land. But their contention for rejection of my application is that the name of the, you are the sister's son, therefore not a member of the family, and therefore you can't be granted the employment program. On that basis, my application rejected.
Employment program ಇಂದ ಏನಾಗುತ್ತೆ ನಿಮಗೆ?
ಅವ್ರು ಫಸ್ಟ್ ಟ್ರೈನಿಂಗ್ ಕೊಡ್ತಾರೆ, ಆಮೇಲೆ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಮಾಡ್ಕೊಳ್ತಾರೆ.
ಟ್ರೈನಿಂಗ್ ಮಾಡಕ್ಕೆ
ಅಂದ್ರೆ ಇದು ಸಿಗ್ತದೆ, ಐ ವಿಲ್ ಗೆಟ್ ಎಂಪ್ಲಾಯ್ಮೆಂಟ್. One more thing I missed submitting on the last occasion in my senior, that now in this some facts, what happened is, my lord, in the notification, name of my uncle is there, that is my mother's brother. When the first notification was issued and before it was published, there was a, my lord, Vardi wherein there was a partition and half portion was given to my mother. Thereafter, she has been recognized as the owner and all the documents have been executed in her favor, giving her compensation and other benefits. And that was kottidare. And one more thing, important aspect is, most of the villagers had been opposing this acquisition. Since it was assured by the, my lord, authorities that your family members will be given the benefit of employment also. ಈಗ ಅವ್ರು ಏನ್ ಹೇಳ್ತಾ ಇದಾರೆ, ಇಲ್ಲ ನಿಮ್ಮ ಅಂಕಲ್ ಮಗನಿಗೆ ಕೊಟ್ಟು ಬಿಟ್ಟಿದ್ದೇವೆ, ಅದಕ್ಕೆ ನಿಮಗೆ ಕೊಡ್ಲಿಕ್ಕೆ ಬರೋದಿಲ್ಲ. That was the argument by learned senior on the other day.
See, you partition a land.
Yes.
Land is acquired.
Yes.
The partition, persons who come in possession pursuant to a partition become separate owners.
Yes, yes.
So you mean to say that land is acquired, every owner should be given employment?
Not every owner, whoever is the land loser.
Partition ನೀವು ಮಾಡ್ಕೊಂಡ್ಬಿಡ್ತೀರಾ? Partition ಮಾಡ್ಕೊಂಡು 4 ಭಾಗ, so 4 ಜನಕ್ಕೂ ಕೊಡಬೇಕು.
Peculiar facts, my lord. Recognition of the right of my mother in paying her the compensation, and that was a consent award. My lords may kindly appreciate this aspect. Our indemnity bond ಎಲ್ಲ ಮಾಡ್ಕೊಂಡು limited compensation.
May I request on 4th or 5th, my lord? May I request on 4th or 5th, my lord? My senior is arguing the matter. ನಾಗರಾಜ್ ಸನ್ ಆಫ್ ನಿತ್ಯಾನಂದ ಅವರಿಗೆ 10/11/2011 ಎಂಪ್ಲಾಯ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಹೆಲ್ಪರ್ ಅಂತೇಳಿ ತಗೊಂಡಿದ್ದಾರೆ. ಮತ್ತೆ
ನೋಡಿ reconsider.
ಇದೇ ಕೋಟಲ್ ತಾವರ್ಗೇರಿ
Can't give positive direction in the light of your rights emerging from the partition.
No, I showed my lords one document last time.
ತಾವರ್ಗೇರಿ
Their own
ಪಾಂಡುರಂಗ
document, my lord, mine, the worthy had taken place prior to issuance of the final notification. Now their contention is, since your name is not appearing, you are not a member of the family ಅಂತ ಹೇಳ್ತಾರೆ.
Name was appearing, right?
Name was not appearing in the official gazette when it was, my lord, published. At that time, it was in the name of Narayanappa.
Partition ಆಗಿರ್ಲಿಲ್ಲ.
ಆಗಿತ್ತು, but ಖಾತಾ ಆಗಿರ್ಲಿಲ್ಲ. Only because khata was not, my lord, effected, my name was not reflected. Whether that itself would, my lord, deprive me the right.
Now you give all the necessary documents. ಈಗ ಎಷ್ಟು ಏಜ್ ಆಗಿದೆ ನಿಮಗೆ?
ಅಲ್ಲ, ಏಜು ಆಗ್ತಾ ಬಂದಿದೆ, my lord.
I will direct in 2 months to decide.
ಅಲ್ಲ, one more round they will reject it. Once again I have to be before this honorable.
I will record everything. I can't give a positive direction that you should be given.
The fact that my only the persuasion would be this fact that, my lord, they agreed and accepted my mother's right.
That will see.
ಅದೇ ಸರ್ವ ನಂಬರ್ ಅಲ್ಲಿ ತಾವರ್ಗೇರಿ ಪಾಂಡುರಂಗ
Annexure A, B and C, all are the documents. Indemnity bond ಅವ್ರಿಗೆ ಕೊಟ್ಟಿರೋ.
Even if he argues or you submit, I will only direct consideration. I can't give a positive direction to a point. They will have to look into everything and consider.
No, I have challenged, my lord, the rejection. ಅಲ್ಲ, ಅದೇ ಪಾಯಿಂಟ್ ಮೇಲೆ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ, ಅದನ್ನೇ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀನಿ. That's why, my lord, it's not that, my lord.
I'll quash this and direct them to consider. That's all that can be. Otherwise, I'll have to hear him complete.
Please.
ಇದೇ ಕೋರ್ಟಲ್ಲಿ 14 WP 14104834/22 ಮಾಡ್ಯಾರ. dispose on 14/3/2024. ಅದನ್ನು ಕನ್ಸಿಡರ್ ಇದೇ ಸರ್ವರ್ ಮೇಲೆ ನಂಬರ್ ಮೇಲೆ ಕನ್ಸಿಡರ್ ಮಾಡ್ರಿ ಅಂತ ಆರ್ಡರ್ ಮಾಡಿದ್ರು. ದಿಸ್ ಕೋರ್ಟ್ ಓನ್ಲಿ.
ಯಾವ್ದು ಗಿರೀಶ್?
ನನಗೂ ಒಂದು ಕೊಟ್ಟಿಲ್ಲ, copy ಕೊಟ್ರೆ I can also look into and make submission.
104834/2022 ಮೇಲೆ
20
22 dispose on 14/3/2024.
Tag the petition along with it. Tag the subject petition along with so and so. ಅಲ್ಲಿ dispose ಆಗಿದೆಯಾ?
ಅಲ್ಲ dispose ಆಗಿದೆ.
ಕನ್ಸಿಡರ್ ಮಾಡ್ರಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ ಸಾಹೇಬ್ರು.
ಆರ್ಡರ್ ಕೊಡಿ. ಆರ್ಡರ್ ತರಿಸಿ ಅದು next time. List on 6th in the fresh matters list at the request of the council appearing for the respondent. It is made clear no further adjournment on whatsoever ground would be granted. Yes.
Please.
Hearing for the respondent.
My lord, the grievance is, my lord, petitioner was appointed as a helper B, my lord, on 14/11/81. Under the same notification, my lord, one Mr. Sunkad was appointed. We have reported to duty, my lord,
On the same day.
on the one day, my lord, difference. Then, my lord, the first promotion from helper B to A was granted to me on, my lord, 14/11/1987 as helper A. That is first promotion in the ladder of helper. Then, my lord, the Sunkad who was appointed, he was given the promotion as helper A on 8/12/2019, 2 years after my promotion. Then, my lord, my next promotion as an assistant artisan came on 24/10/1989. And similarly, it was given to, my lord, one Mr. Sunkad on 23/1990.
Retire ಆಗಿ 10 ವರ್ಷ ಆಗಿದೆಯಾ?
ಈಗ ರಿಟೈರ್ಡ್ ಆಗಿ 10 ವರ್ಷ ಆಗಿಲ್ಲ. 2017 October, my lord, I got retired.
Before that you have filed the petition.
Before that, I have filed the petition. Then, my lord,
Sunkad is also retired?
Sunkad is also, my lord, he was given 3 promotions.
Only notional.
My lord, as per the, my lord, the endorsement, my lord, his seniority is stood at the, my lord, serial number 31.
Whose seniority?
My lord, the petitioner seniority is stood at the serial number 31.
All right.
And the Sunkad, my lord, seniority stood at the 15, my lord, as per annexure.
Why
See
15?
page number 35.
15? He was SC, is it?
No, my lord.
No.
Then? As on the date of appointment, why these 2 seniorities?
No, my lord,
It is two
the
gap.
petitioner was appointed on, my lord, 14/11/1981, my lord.
14/11,
1981.
Sunkad?
Sunkad, my lord, 13/11/1981.
One day before.
One day
that.
before the, my lord, the.
So, yes, same cadre.
Same case.
When was the first seniority list drawn?
Lord, that.
ಇವೆಲ್ಲ 10 ವರ್ಷ ಆದ್ಮೇಲೆ that this ಹೇಳಂಗೇ ಇಲ್ಲ. When was the first seniority list drawn after the appointment?
ಅದೇನು, my lord, records, my lord, not, my lord.
50 ವರ್ಷ ಆದ್ಮೇಲೆ ರೆಕಾರ್ಡ್ ಎಲ್ಲಿರುತ್ತೆ? Yes, sir. When was the first seniority list drawn?
Lord, seniority list first drawn was 1989.
In that,
After-
what was the ranking?
Ranking, my lord, as per the ranking only, my lord, I have given. I don't know the, my lord, exact ranking as on the date
He
of.
says you were at 31, he was at 15. Why? Where is
That-
the seniority list?
That was given in 2013, in the endorsement after my request.
Seniority list. Which seniority list have you produced to stake your claim on par with Sunkad? If he seniority, he'll get it. Material documents ಹಾಕ್ಬೇಕು ಸರ್ ಎಲ್ಲರೂ. ಹಿಂಗೆ this is why cases are not decided. ಏನಾದ್ರು ಸುಮ್ಮನೆ 4 ಪೇಪರ್ ಹಾಕ್ಬಿಟ್ಟು ಬಿಟ್ಬಿಟ್ಟು ಇಲ್ಲಿ ಆರ್ಡರ್ ತಗೊಳಕ್ಕಾಗುತ್ತೆ. Should you not produce? He is saying 15 ranks, Sunkad is above you. How? And why? Should you not produce one seniority list to show that?
Lord, it was.
Endorsement ಕೊಡ್ತಾರೆ, ತಗೊಂಡ್ರು ಇಲ್ಲಿ ಹಾಕಿದ್ರು. Your claim is based on seniority. Produce a seniority list. And this is 12 years old. ಇಷ್ಟು ದಿನ seniority list ಬಗ್ಗೆ ಗೊತ್ತೇ ಆಗ್ಲಿಲ್ವಾ? ಇದು ಮೇಲ್ ಹಾಕಿಸ್ತಾ ಇರೋದಕ್ಕೆ ಇದು ತಗೊಂಡ್ರದು. ಇಲ್ಲ ಅಂದ್ರೆ ಅದು ಅಲ್ಲೇ ಕೋಲ್ಡ್ ಸ್ಟೋರೇಜ್ ಐತಿ. ಯಾಕೆ ನಿಮ್ಗೂ ಏನಿಲ್ಲ ಇದ್ರಲ್ಲಿ ಏನ್ ಬರಲ್ಲ, ರಿಟೈರ್ ಆಗ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಎಲ್ಲ haphazard information, slipshod. This is not the way, sir. Whatever the year, whatever the matter, you should have the same conviction.
Yes, exactly.
ಮತ್ತೆ?
I understand.
These are the people who have given you succor at the beginning. You can't forget them. Now saying 12 ವರ್ಷ ಆಯ್ತು ಬೇರೆ ಕೇಸ್ಗಳು.
But the fact remains, my lord, one thing, that I exactly, my lord, what my lord has said. 2 promotions given to me 3 years prior to him.
ಅದೆಲ್ಲ ಡಾಕ್ಯುಮೆಂಟ್ ಬೇಕು. ಸುಮ್ಮನೆ ಹೇಳ್ಬಿಟ್ರ
ಅಲ್ಲ, ಅದು SR ಬುಕ್ ನಾನು ಹಾಜರ್ ಮಾಡಿದ್ದೀನಿ ಇಬ್ಬರದ್ದು.
ಆರ್ಡರ್ ಬರೀಬೇಕಲ್ಲ. There should be some reasons in the order. How do I write it without any material?
I have produced, my lord, SR books of both.
What have you produced?
My lord, SR book of both parties.
Okay, when there is no material, we direct them to consider one more round of litigation.
Exactly.
ಎಲ್ಲ material ಇದ್ ಬರೆದ್ರೆ they will not do that. They will not deny your rights if everything is written. ಸುಮ್ಮನೆ ಕನ್ಸಿಡರ್ ಅಂದ್ರೆ ಇನ್ನೊಂದು ಅವ್ರು ರಿಜೆಕ್ಟೇ ಮಾಡೋದು. ಅವ್ರಿಗೇನಾಗಬೇಕಾಗಿದೆ? That is why you should produce all the material to your claim and be rest assured every material will be considered here. Oh, they cannot deny you anything. It's not correct. Produce seniority list, whatever document you have to show that you had a right over and above Sunkad. All right?
ನಮ್ಮವನಿಗೆ ಸ್ವಲ್ಪ ಆರಾಮಿಲ್ಲ, my lord, therefore, my lord,
ಕೇಸಿಗೂ ಆರಾಮಿಲ್ಲ.
they are having custody of it, my lord, they can at least.
Since
I will direct you to do everything. Artisan promotion ಕೊಡಕ್ಕೆ ಹೇಳ್ತೀನಿ. Because no document is produced by you saying that justification of Sunkad's appointment, I will allow the petition.
Not
You also can't be like this. Get everything, get the records.
Please.
The respondent corporation is directed to secure and produce the records concerning promotion of one Sunkad, who is said to be a junior to the petitioner and is now wanting promotion to the post of artisan, which Sunkad had been granted. Therefore, the respondent corporation shall produce the same by the next date, list on 7th in the fresh matters list.
10 days.
10 days ಕೊಟ್ಟಿರೋದು 7th February.
ಹಳೆ ರೆಕಾರ್ಡ್ಸ್ ನೋಡ್ಬೇಕು. ಹಳೆ ರೆಕಾರ್ಡ್ಸ್ ನೋಡು ಟು ಸರ್ಚ್ ದಿ ಓಲ್ಡ್ ರೆಕಾರ್ಡ್ಸ್.
ಗೊತ್ತಾಯ್ತು ಹಳೆ ರೆಕಾರ್ಡ್ಸ್. Then 17th.
Really?
17th in the fresh matters list. It made clear if no records are produced, the order would be passed on the submission of the counsel for the petition. Yes.
17, please.
Before Ravi Hegde, Shivkumar is Badwadi?
That's it. ಇದೇನು?
My lord, here they have issued a notice saying that I have overstayed in the quarters and therefore he is required to pay the damages.
ಎಷ್ಟು ಡ್ಯಾಮೇಜ್?
My lord, 2,72,000 and odd amount.
When did you?
My lord,
When were you to vacate the quarters?
My lord, here they have issued a notice on 6/5/2016. First notice, my lord, was issued immediately. I have handed over. Annexure C, page 13 is the notice issued.
Date ಹೇಳಿ.
24/2/2016. And I have vacated on 30/3/2016, Annexure D.
Yes, sir.
No, my lords, I will make two dates, my lords. On 24/2/2016, my lords, the corporation has issued notice to him, asking him to, my lords,
Vacate.
because he has not vacated immediately. Because in the year 2013, my lords, he was kept under suspension. After suspension was revoked, he was posted to some other depot. So from that day onwards, my lords, he would have vacated the quarters, but he has not vacated. On 28/3/2016, again a notice came to be issued to him, my lords, intimating, my lords, how we are going to, my lords, compute the penalties for overstaying in the quarters. Plus that is dated 28/3/2016. Plus after that, plus he vacated the premises on 30th of that month.
There.
On 6/5/2016, we passed.
Within 1 month he vacated.
Yes, he vacated. Plus on 6/5/2016, by virtue of the notification issued by the state government dated plus 22/1/1999, we computed plus the penalties and plus we have issued the notice.
Then what? Vacate ಮಾಡಿದಾರಲ್ಲ notice issue ಮಾಡಿದ್ದಾರೆ.
Subsequently, plus he vacated. He would have vacated in the year 2013.
Sell ಕೊಟ್ರಿ ಮುಂಚೆ. Eviction notice ಕೊಟ್ಟಿದ್ದು ಯಾವಾಗ?
Plus it is only in the year 2016.
ತಕ್ಷಣ vacate ಮಾಡಿದ್ದಾರೆ. Anything else? Yes. The petitioner.
Now, my lord, one
ಮತ್ತೇನು?
thing. Allala. ಈಗ now he has retired. The amount has been withheld by them despite the interim order.
The petitioner is before this court calling in question an order dated 6/5/2016, whereby an amount of rupees esto
Plus 2,77,520.
2,77,500 has been withheld from the terminal benefits of the petitioner on account of his overstaying in the official quarters towards damages and rent from 2014 till 31/3/2016. Heard so and so. The petitioner is a driver in the corporation, in the respondent so and so corporation for short. On his capacity of being a corporation servant was allotted a quarters, allotted in official quarters on 7/12/2010. The petitioner then, on certain omissions and commissions, had been placed under suspension, and the suspension then comes to be revoked. He is posted to another depot outside. He is posted to Koppal depot on deputation until further orders. It is that the petitioner did not vacate the premises or the official quarters that was allotted to him on 7/12/2010. For the first time, a notice comes to be issued by the corporation on 24/2/2016 asking the petitioner to vacate the official quarters, and failing which they will charge damages or rent that is applicable. Immediately thereafter, on 30th March 2016, the petitioner vacates the premises, hands over the keys. The impugned order is passed on 6/5/2016. Retire ಆಗಿದ್ರಾ?
Retire ಆಗಿದೆ.
He retired in the year 2017.
6/5/2016, determining the damages and rent payable at rupees 2,77,000. It is now the said amount is now withheld from the terminal benefits of the petition.
Yes.
The learned counsel Ravi Hegde, appearing for the petitioner, would submit that no proceeding in the eye of law is initiated to evict the petitioner. He was for the first time given a notice on 24/2/2016. He has immediately vacated the premises after the receipt of the notice, and therefore there was no warrant for determining damages or penal rent as the case would be. The order passed determining the amount is contrary to the Karnataka Public Premises Eviction of Unauthorized Occupants Act 1974, is the submission of the learned counsel appearing for the petitioner. Per contra, the learned counsel Shivakumar Badavadigi, representing the corporation, would vehemently refute the submission, contending that once he was posted out on 20th February 2014 to Koppal, he ought to have vacated the official quarters that was allotted to him on 7/12/2010. He squats over the property for 2 years, and noticing the fact that the petitioner has not vacated the premises, the notice was caused upon him, and only after causing of the notice he has vacated. Therefore, he is bound to pay the penal rent or damages as is determined. I have given my, the aforenarrated facts are not in dispute. The allotment of official quarters to the petitioner is a matter of record. That having been done on 7/12/2010 is again a matter of record on a particular rent. The petitioner after about 10 years, 14 years, on 24 to, after about 10 years incurs an order of suspension on certain misconduct and it is later revoked. On revocation, he is transferred to Koppal depot from
It is Kukunur depot.
Kukunur depot. Kukunur depot and again on 22/2014 to Koppal depot.
On deputation.
On deputation. It is the case of the corporation that once he was sent on deputation, he was bound to vacate the official quarters. The official quarters and therefore the penal rent is correctly imposed. The submission is noted only to be rejected. The petitioner did not vacate the premises, yes, but the corporation has not done anything until 24/2/2016. The first notice that the petitioner was issued on 24/2/2016 reads as follows. It is for the first time the corporation issues a notice and directs the petitioner to vacate the premises, failing which damages, penal rent, all would be imposed upon him. The petitioner then immediately vacates the premises on 30th March 2016. This is an admitted fact. Therefore, the petitioner on immediate receipt of notice has vacated the premises. Notwithstanding the same, the penal rent and damages is imposed in terms of the impugned order. The order reads as follows. This determination is not on the, order reads as follows, page 21-22. This determination does not bear any proceeding instituted in accordance with law. Nonetheless, it transpires that from out of the terminal benefits of the petitioner, an amount of rupees 2,77,000 is withheld. The withholding of the said amount is on the face of it arbitrary and unsustainable. For the aforesaid reason that the corporation did not act till 24/2/2016, and the moment they have acted, the petitioner has vacated the premises, damages or penal rent could not have been imposed. Could not have been imposed, that too without holding any proceeding in accordance with law. Therefore, the petition deserves to succeed. For the aforesaid reasons, the following order allowed, quashed. The amount that is withheld from the terminal benefits of the petitioner shall be released to the petitioner within
4 weeks.
Within 4 weeks from the date of receipt of the copy of the order. In the event it is not released within 4 weeks, the petitioner becomes entitled to interest at 6% per annum from the date it fell due till the date of its payment.
Bill number 5, Hemant Kumar L. Hawargi.
Lordship, as per instruction of the petitioner number 1 is died.
18 in the FC Act pending ಇದೆ ಏನಿದೆ?
The petitioner, serial number 5, my lordship.
ಏನಿದೆ?
The petitioner number 1 is died, my lordship.
Petition number 1 is no more.
No more, my lordship. Petition number 2 and 3 is concerned, my
2
lordship.
and 3 ಏನು? Matter ಏನು?
Matter, my lordship, the petitioners working as a manual scavenger, my lordship. After abolition of manual scavenger, my lordship. Scavenger. After abolition of manual scavenger, my lordship, they have given a representation to the 7th respondent to appoint as a poro karmika.
Rehabilitation.
My lordship, they have not appointed, my lordship. Thereafter, my lordship, given a case before the National Commission, my lordship, of the manual scavenger, my lordship. My lordship, as per annexure F, my lordship, page number F, my lordship. ವಿಚಾರಣೆ ಒಂದು ಹಂತದಲ್ಲಿ my lordship, the
You are children of whom?
manual scavenger.
ನಿಮಿಷ. ಈಗ first petitioner ಇಲ್ವಾ?
First petitioner.
2 and 3 are manual scavengers.
Please.
All right. Under the act, you are entitled to certain benefit.
Please.
They have not afforded that.
Lordship. Thereafter, my lordship, they have appointed another person's, my lordship, who is the respondent number 8 to 10, my lordship.
ಅವರು ಅದೇ ಅಲ್ವಾ?
ಅಂದ್ರೆ ಅವ್ರು ವರ್ಕ್ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ. ಇವ್ರು ವರ್ಕ್ ಮಾಡಿದವರು, ಅವ್ರು ವರ್ಕ್ ಮಾಡಿಲ್ಲ.
ಎಲ್ಲಿಂದ ಎಲ್ಲಿಗೆ ವರ್ಕ್ ಮಾಡಿದ್ರು?
ಸೊ ಮ್ಯಾನುವಲ್ ಸ್ಕೆಂಜರ್ ಅಂತೇಳಿ ಅವ್ರು ವರ್ಕ್ ಮಾಡಿದವರು, ದೇ ಹಾವ್ ಗಿವನ್, ಇವ್ರು ವರ್ಕ್ ಮಾಡಿದವರಲ್ಲ, ಬೇರೆ ವರ್ಕ್ ಮಾಡಿದವರು ಇವರು. ಸೊ ಇವ್ರನ್ನ ಅಪಾಯಿಂಟ್ ಮಾಡಿದ್ರು.
They have participated in the proceedings before respondent number 3, my lords, wherein We are also conducted, we are in that proceedings, we are before the respondent number 3, my lord. There's such contention they raised before this honorable court, they have not raised before the commission, my lord. Furthermore, we are working in we are working in the same, my lords, but
all of your scavengers, not rehabilitation, ಎಲ್ಲರಿಗೂ ಆಗ್ಬೇಕು. ಇವ್ರು ಮುಂಚೆನೆ ವರ್ಕ್ ಮಾಡಿದ್ರೆ they should have had precedence ಅಷ್ಟೇ.
as for me, because of by virtue of interim order, my lords.
I am appealing for the municipality. I have no instruction. My lord, date may kindly be given, short date.
No
My lord,
dates.
I will get an instruction.
No instruction.
Yes.
My lords,
Very well.
after obtaining
ಈ
the,
ಕೇಸಲ್ಲಿ ಯಾವ ಇನ್ಸ್ಟ್ರಕ್ಷನ್
Yes.
ಮಾಡಿ?
after obtaining the interim order,
ಮೆಟೀರಿಯಲ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಬಂದಿಲ್ಲ ಅಂದ್ರೆ ತಗೊಳ್ಳಿ, ಅದು ಆಮೇಲೆ ತಾನೇ ಬರೋದು. ಮುನ್ಸಿಪಾಲಿಟಿ ಆದ್ರೆ ಪೋಸ್ಟ್ ಪೇಡ್, ಪ್ರೀಪೇಡ್ ಅಲ್ಲ.
it's a temporary job, my lords. After obtaining the interim order from this honorable court, since 2017, they are working in the same.
ಮಾಡ್ತಿದ್ದೀರಲ್ಲ ಕೆಲಸ.
They are working, my lords.
No, my lords.
Now,
ಬೇರೆ
they
ಅವ್ರು
are
ಅಲ್ಲ ಇವ್ರು ಅಪಾಯಿಂಟ್ ಮಾಡಿದ್ಮೇಲೆ ಅವ್ರನ್ನ
ನೀವೇ ಹೇಳಿ, ಅವ್ರು ನಿಮ್ ತರಾನೇ ಅವರು ಅಲ್ವಾ?
ಅಲ್ಲ ಕಮಿಷನ್ ಏನ್ ಮಾಡಿದೆ ಹಂತ ಹಂತವಾಗಿ ಅವ್ರನ್ನ ತಗೋ ಅಂತ ಹೇಳಿದಾರೆ ಸ್ವಾಮಿ, ಇಲ್ಲ ಅಂತಲ್ಲ. ಬಟ್ ನಮ್ಮನ್ನ ನಮ್ಮನ್ನ ತಗೊಂಡಿಲ್ಲ ಸ್ವಾಮಿ.
7 years ಇಂದ ಕಂಟಿನ್ಯೂ ಆಗಿಲ್ವಾ ನೀವು?
ಇಲ್ಲ ನಮ್ಮನ್ನ
ಕೆಲಸ
ತಗೊಂಡಿಲ್ಲ.
ಮಾಡೇ ಇಲ್ವಾ?
ಅಲ್ಲ ಇದರಲ್ಲಿ ತಗೊಂಡಿಲ್ಲ ನೋಡಿ ಸ್ವಾಮಿ.
ಈಗ ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಏನು ಕೊಟ್ಟರದ್ ಮತ್ತೆ?
they are working.
ಎಸ್ಪರೇಟ್ ಫಾರ್ ಅಂತ
ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಸ್ಪ್ರೆಡ್ ಫಾರ್ ಅಂದ್ರೆ ಕಂಟಿನ್ಯೂ ಆಗಿದ್ದೀರಾ?
ಕಂಟಿನ್ಯೂ ಆಗಿದೆ ಸ್ವಾಮಿ.
ತಗೊಂಡಿಲ್ಲ ಅಂತ ಏನರ್ಥ? ಕಂಟಿನ್ಯೂ ಆಗಿದ್ರೆ ಏನರ್ಥ? ಯು ಆರ್ ಬ್ಲೋಯಿಂಗ್ ಹಾಟ್ ಅಂಡ್ ಕೋಲ್ಡ್. ವಾಟ್ ಇಸ್ ದಿಸ್? ಅವರು ನಿಮ್ ತರಾನೇ ಅಲ್ಲ, ಬೇರೆ ಅವ್ರಿಗೂ ಬೇಡವಾ?
ಅಲ್ಲ ಬರ್ಲಿ ಎಲ್ಲರಿಗೂ ಕೊಡ್ಲಿ, ಹಂತ ಹಂತವಾಗಿ ಕೊಡ್ಲಿ ಅಂತ ಹೇಳಿದಾರೆ ಸ್ವಾಮಿ.
ಎಲ್ಲಿದೆ ಹಂತ ಹಂತವಾಗಿ ಕೊಡಕ್ಕೆ?
ಅದು ಆಸ್ ಪರ್ ಅನಕ್ಷರ್ ಎಫ್ my lordship.
ಇಲ್ಲಿ ಮುನ್ಸಿಪಾಲಿಟಿ ಇಲ್ಲ ಇದು?
ಕಮಿಷನರ್ ಆರ್ಡರ್ ಮೋಸ್ಟ್.
In the municipality, is it?
Please.
Yes, the petitioners are before this court calling in question an order dated 7/10/2017 passed by the third respondent, whereby the claim of the petitioners for appointment on contract basis for manual scavenging ಎಲ್ಲಿದೆ?
ಅಲ್ಲ ಅಬಲೇಷನ್ ಆಗಿದೆ ಸ್ವಾಮಿ ಅದು.
ನೀವು ಪ್ರೇಯರ್ ಏನು?
ಅಲ್ಲ
appointment on contract basis in the municipality.
as a ಪೌರ ಕಾರ್ಮಿಕ.
Manual scavenging ಇನ್ನೂ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
ಇಲ್ಲ
ಮತ್ತೆ what appointment are you giving them?
My lords, I represent.
ಪೌರ ಕಾರ್ಮಿಕ.
Yes,
ಪೌರ ಕಾರ್ಮಿಕ.
Petition ಅಲ್ಲ, manual scavenging. Appoint as manual scavenging.
ಅಲ್ಲ ಫಸ್ಟ್ ಮ್ಯಾನುವಲ್ ಸ್ಕ್ಯಾವೆಂಜಿಂಗ್ ಅಪಾಯಿಂಟ್ ಆಗಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಆಮೇಲೆ ಅಬಲೇಷನ್ ಆದ್ಮೇಲೆ they have given a representation.
The first petitioner during the pendency of the subject petition is no more. Therefore, petitioners 2 and 3 are who remain is petitioners 2 and 3. The issue in the list revolves around rehabilitation of manual scavengers after the abolition in terms of the Act. On 22/8/2016, it transpires that the people belonging to a certain community had submitted a representation to the 7th respondent to appoint them on contract basis in Savanur Municipal Council as Paura Karmikas. The representation is said to have been recommended between the quarters of the office, and notwithstanding the said representation, it is the case of the petitioners that they are not chosen to be appointed as Paura Karmikas on contract basis, notwithstanding the fact that they were all working as manual scavengers earlier to its abolition in terms of the Act. The learned counsel appearing for the petitioner, taking this quote through the documents appended to the petition, would submit that preference for appointment as Paura Karmika should have been to the petitioners and not to the private respondents who had never worked as scavengers, and their rehabilitation was not that was needed. The learned counsel appearing for the respondent,
8 to 10.
Private respondents 8 to 10 would submit that the petitioners are also working on the strength of the interim order granted 6 years ago as Paura Karmikas in the municipality. The council representing the municipality would also admit the same.
ವಿಚಾರಣೆ ಹಂತದಲ್ಲಿ 2ರಲ್ಲಿ ಅವ್ರನ್ನ ಅಪಾಯಿಂಟ್ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ ಇಲ್ಲಿ. which are page number 18.
Direction I'll give.
Please, please.
Yes, so and so. The, so and so. The learned AGA, ನೀವೇನಿಲ್ವಾ ಇದರಲ್ಲಿ?
State.
State ಇಲ್ವಾ? The learned AGA would also toe the lines of the councils representing the university, the municipality or
1 to 6, my lordship.
the private respondents. The issue now would be whether the state, whether the municipal council has followed the directions of the commission, the Karnataka State Commission for Safai Karmacharis. It is on consideration of the scheme of rehabilitation of those manual scavengers on coming into force of the act. The manual scavengers had to be rehabilitated. The rehabilitation is what is considered by the commission. In terms of the direction of the commission, the respondent municipality ought to have offered employment on contract basis to all those persons who are working as manual scavengers prior to the abolition of the act, as also to others on their eligibility. It is an admitted fact that the petitioners were not chosen, but respondents 8 to 10. But the direction was to appoint every person who was working as a manual scavenger earlier to the bringing of the act stage by stage. Therefore, if respondents 8 to 10 have been performing the duties till now, it is time that the petitioners are also considered for the post of Paura Karmika, or to do the duties of a Paura Karmika on contract basis in the teeth of the object of the act being the rehabilitation of manual scavengers. Therefore, it is for the respondent municipality and the state to ensure that rehabilitation happens in a non-arbitrary manner and not leading to pick and choose of persons who are pick and choose of any person. The municipality shall now consider the cases of these petitioners for the post of Paura Karmika on contract basis in the municipality, and also not dislodge the respondents 8 to 10 if they are all working and work can be found for all the persons. With the aforesaid observation, the petition stands disposed.
Obligations.
Seal number 6, Naveen Chakra. Andrikant, 14%.
In this case, I am a petitioner, sir.
Last time ಬಂದಿರಲಿಲ್ಲ,
ಬಂದಿಲ್ಲ.
3 ಸರ್ತಿನೂ ಬಂದಿಲ್ಲ.
Worship,
Shall appear in party. Committee ಮುಂದೆ ಅಪೇರ್ ಆಗಿಲ್ಲ ಅವರು?
ಆಗಿದ್ದು ಸ್ವಾಮಿ, ಕೊಟ್ಟಿದ್ದಾರೆ. ಅಪೇರ್ ಆಗಿದ್ರಲ್ಲಿ ಒಂದ್ಸರಿ ಅಪೇರ್ ಆಗಿ ಸ್ವಾಮಿ, ಆಮೇಲೆ 2 ಸರಿ ಅಪೇರ್ ಆಗಿಲ್ಲ.
ಎಷ್ಟು ಸರಿ ಮಾಡೋದಪ್ಪ ಇವ್ರಿಗೆ?
Bishop, he is very in maintenance petition also. He has not paid a single penny. Though he is working in a KSRTC, out of 2,40,000 maintenance fellowship, he has paid only 37,000.
What is he, government servant?
Also, he is a KSRTC employee. KSRTC employee. In all the cases, ಅಲ್ಲಿ ಸ್ವಾಮಿ 2 ಲಕ್ಷದ
ಎಷ್ಟಿದೆ
ಅಲ್ಲಿ ಮೇಂಟೆನೆನ್ಸ್ ಕೇಸಲ್ಲಿ 2,02,500 ರೂಪಾಯಿ ಇದೆ ಸ್ವಾಮಿ.
ಇನ್ಯಾವ ಕೇಸಲ್ಲಿ ಮೇಂಟೆನೆನ್ಸ್? ಒಂದೇ ಕೇಸಲ್ಲಿ
ಒಂದೇ ಕೇಸಲ್ಲಿ ಅಲ್ಲಿ 4
ಕೇಸ್ 4 ಮೇಂಟೆನೆನ್ಸ್ ಆಗಲ್ಲ, ಒಂದೇ ಮೇಂಟೆನೆನ್ಸ್
ಅಲ್ಲ ಸರ್. ಒಂದೇ ಪಿಟಿಷನ್ 4 ರಿಕವರಿ ಪಿಟಿಷನ್ ಹಚ್ಚಿದೆ ಸ್ವಾಮಿ. 4 ರಿಕವರಿ ಪಿಟಿಷನ್ ಅಲ್ಲಿ 2ರಲ್ಲಿ 1 ರೂಪಾಯಿ ಕೊಟ್ಟಲ್ಲಿ, 2ರಲ್ಲಿ 1ರಲ್ಲಿ 2,000 ರೂಪಾಯಿ, 1ರಲ್ಲಿ 30.
ವಿಚ್ KSRTC? ಯಾವ್ದು? NW KRTC ಎಲ್ಲಿ ಗೊತ್ತಾ?
ಹುಬ್ಳಿಯಲ್ಲಿ ಸ್ವಾಮಿ.
The respondent who once appeared as a party in person has been dodging these proceedings for over 6 years now. He is said to be an employee of the Northwest Karnataka Road Transport Corporation. The arrears of maintenance to be paid to the petitioners, the wife and the child, is at 2,02,500 as submitted by the petitioner.
ಅಲ್ಲ ಸ್ವಾಮಿ, ಒಂದು ಸಬ್ಮಿಷನ್ ಈ ಕೇಸಲ್ಲ ಸ್ವಾಮಿ, ಮೇಂಟೆನೆನ್ಸ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಈ ಕೇಸಲ್ಲ.
ಕೇಸಲ್ಲಿ ಎಷ್ಟಿದೆ?
ಈ ಕೇಸಲ್ಲಿ ಇಲ್ಲ ಸ್ವಾಮಿ,
ಅರಿಯರ್ಸ್ ಇಲ್ಲ,
ಇದರಲ್ಲಿ ಇಲ್ಲ ಸ್ವಾಮಿ. ಇದು ವಾಟ್ ಹ್ಯಾಪನ್ಸ್ ಇನ್ ದಿಸ್ ಕೇಸ್,
The respondent has filed suit for declaration, Your Worship. Subsequently, he filed one more suit for the same relief. So, hence, the dependents filed application under section 10 for stay of suit. The said application came to be rejected, challenging that order, Your Worship. The petition is filed before Honorable Court. In this case, there is no arrears. What happens, the plenty respondent here has filed earlier OS number 302 of 2015 before the senior civil judge Hirekiri for declaration injunction. Subsequent, Your Worship, with the same relief, he filed one more suit in family court Hubballi.
ಈಗ ಸ್ಟೇ ಆಗಿದೆಯಲ್ಲ,
Yes, Swami.
ಈಗ ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಲ್ಲ ಇಲ್ಲಿ.
ಇದೆ ಸ್ವಾಮಿ, ಎಂಟ್ರಿ ಮಾಡಿದೆ.
ವಾಟ್ ಹ್ಯಾಪನ್ ಟು ದಿ ಅದರ್ ಸೂಟ್?
ಅದು ಯಥಾಸ್ಥಿತಿ ಇಲ್ಲ, ಇಲ್ಲಿ ಹಂಗೆ ಇದೆ ಸ್ವಾಮಿ.
Alright, one chance ನೋಡೋಣ. The party in person is not present even today, as has been the case for the last 3 occasions. Therefore, as a last chance, list the matter on 7th in the fresh matters list.
And 6th
in the fresh matters list. In the event the party in person would not be represented, the court will be constrained to allow the petition hearing the submissions to the counsel for the petition. Next.
Cell number 7.
Interim order next.
Interim order stands extended till the disposal of the petition.
For the petitioner, my lord. Challenging, my lord, the impugned erroneous notification at annexure, my lord, ink page 9. Lord, notification, my lord, to the post of Anganwadi worker. Lord, wrongly shown, my lord, the vacancy, my lord, to the post of Anganwadi assistant. Ink page 9, my lords. The petitioner is working as Anganwadi assistant, my lords, since 2008. Now, my lords, the respond number 2, my lord, in impugned notification shows, my lords, the vacancy. Notice agide, my lords, served, my lord, government.
Government alla sir.
Idu CDO, child development.
Private party yarilva?
No, my lords.
Yes.
Only one post.
Really?
My lords, impugned notification annexure, ink page 9. My lords, notification is to the post of, my lords, Anganwadi worker. My lord, vacancy, my lord, wrongly shown, my lord, to the post of Anganwadi assistant. Ink page 9, my lords. No. Petitioner is working, my lord, as Anganwadi assistant, my lord, since, my lords, 1/2/2008. Now, by way of amendment application, my lords, have produced a service certificate, wherein respondent number 2 has issued a service certificate stating, my lords, that I'm working in the respondent, my lord, Anganwadi Kendra since 1/2/2008, my lords. Now, my lords, impugned notification, they show, my lord, that post is vacant, and I am eligible, my lord, to the post of Anganwadi worker. Now, my lord, I am seeking writ of mandamus as well, my lords, directing, my lord, the respondents to consider my case, my lord, to the post of Anganwadi worker. The post is also, my lord, is vacant since 2018, my lords, in Anganwadi.
In which Anganwadi Kendra?
My lord, the Kokatnur, my lords.
Kokatnur Tottada Anganwadi Center.
Ramatirtha. Now the application is for Ramatirtha.
But it's Kokatnur Tota
application is for
Anganwadi
Ramatirtha antide. Applications were called.
Correct. She is already working there.
Kokatnurದಲ್ಲಿ ಬೇರೆ ಸೆಂಟರ್ ದಲ್ಲಿ.
ಅಂಗನವಾಡಿ ಸಹಾಯಕಿ ರಾಮತೀರ್ಥ ಕೇಂದ್ರ ಕೋಕತ್ನೂರ್ ತೋಟ.
ಅಲ್ಲ ಇದರಲ್ಲಿ ಮಲರ್ಸ್ ಅನೆಕ್ಸರ್ ಎಫ್ ದಲ್ಲಿ ಮಲರ್ಸ್ ದಿ ಆರ್ಡರ್ ಮಲರ್ಸ್ ಆಫ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಅಭ್ಯರ್ಥಿ ಅದು ಅವರು ಅಪ್ಲಿಕೇಶನ್ ಕೊಟ್ಟಿದ್ರು, ಅದಕ್ಕೆ ಶಿ ಹ್ಯಾಸ್ ಬಿನ್ ಅಪಾಯಿಂಟೆಡ್ ಮಲರ್ಸ್
as Anganwadi assistant.
ತಾತ್ಕಾಲಿಕವಾಗಿದ್ದು ಟೆಂಪರರಿ ಬೇಸಿಸ್ ಮಲರ್ಸ್ ನಾವು ನೋಟಿಫಿಕೇಶನ್ ಇಶ್ಯೂಡ್.
ಯಾವಾಗ?
ಮಲರ್ಸ್ ಇಟ್ ಇಸ್
Where is the order of appointment?
annexure of ink page 19. ಅಂಗನವಾಡಿ ಸಹಾಯಕಿ ಅಂತ ಗುರುತಿಸುವ ಬಗ್ಗೆ ವಿಷಯ.
Date ಏನಿದೆ?
Date, my lords, it is not mentioned in annexure F. My lords, it has been issued to me, my lord, in the year 2008. Hence, my lord, I've issued, my lord, service certificate. Amendment application, my lords, ink page 6 of amendment application annexure M. It is stated that since 1/2/2008, my lord, I'm working as Anganwadi assistant.
1/2/2008.
Please, my lords.
Annexure ಏನು?
M, my lords, amendment application.
ಸೇವಾ ಪ್ರಮಾಣ ಪತ್ರ.
Please, my lords.
ಅಂಗನವಾಡಿ ಸಹಾಯಕಿಯಾಗಿ ಸೇವೆ ಎಲ್ಲಿ ಯಾರಿದು? ಅಟರ್ನಿ.
ಈ ಮೂಲಕ ಪ್ರಮಾಣಿಸಿದ್ದವ, ದಟ್ ಇಸ್ ಪಟಿಷನರ್, ಅಂಗನವಾಡಿ ಸಹಾಯಕಿ ರಾಮತೀರ್ಥ ಕೇಂದ್ರ ಇವರು ದಿನಾಂಕ
ರಾಮತೀರ್ಥ ಕೇಂದ್ರ.
ಪ್ಲೀಸ್ my lords, ರಾಮತೀರ್ಥ ಕೋಕತ್ನೂರ್ ತೋಟ.
1/2/2008 ಇಲ್ಲಿವರೆಗೆ ಅಂಗನವಾಡಿ ಸಹಾಯಕಿ ಸೇವೆ ಸಲ್ಲಿಸುತ್ತೆ.
That was a temporary, my lords. Now notification is called for, my lords. If she is entitled for, my lords, the requisite qualifications, then her case will be considered, my lords.
Temporary basis 10 ವರ್ಷ ಆಯ್ತಾ ಈಗ?
Please.
Now you are working?
Still, my lord, she is working at a.
What date is this?
25/10/2018 notification.
Notification is erroneous, my lord. The post is shown vacant, my lords, to Anganwadi assistant, but they're proceeding to with appointment to the Anganwadi worker.
Anganwadi assistant is a cadre lower than Anganwadi worker.
Yes, my lords.
The only grievance is that, my lords, she does not possess the requisite qualification. 10th agilla ಅವ್ರದ್ದು ಓಪನ್ ಯೂನಿವರ್ಸಿಟಿ ಇದೆ.
ಈಗ ಅಂಗನವಾಡಿ ಏನಕ್ಕೆ ನೋಟಿಫೈ ಮಾಡಿರೋದು ಯಾವ ಪೋಸ್ಟ್ ಗೆ?
ನಾವು ದೇಶ ಇದನ್ನ ಸಹಾಯಕ ಅಂತ ಇದೆ.
Anganwadi assistant
ಅಂದಿದೆ.
A post is not vacant at all, she is working antana. But you are working on contract basis.
Contract basis.
But my lord, the posts, my lord, they're proceeding with appointment to the Anganwadi worker, but vacancy, my lord, is shown to my post. I'm working more than, my lord, 10 years now. It is more than 15. If I'm eligible, my lords, let them consider.
The petitioner is before this court calling in question the notification dated 25/10/2018, which notifies the post of Anganwadi worker in so and so, underline ಮಾಡಿದೀನಿ madam. Heard so and so. The petitioner is appointed as an Anganwadi assistant at the aforesaid Anganwadi center on contract basis in the year 2007. The petitioner is said to be qualified with a pass in SSLC, having passed it in the month of January 2014. The state is said to have issued guidelines regarding appointment of Anganwadi assistant and Anganwadi workers in the state. In furtherance of the said guidelines, a notification comes to be issued on 25/10/2018 calling for applications from eligible candidates for appointment of Anganwadi worker, showing the vacancy as Anganwadi assistant. The notification, the learned counsel submits the notification itself is erroneous, as the petitioner is working as Anganwadi assistant there and there was no vacancy. It was actually the vacancy of an Anganwadi worker. The learned AGA on instructions would submit that the petitioner was not qualified to hold the post at the time when she was appointed in the year 2007-2008, and therefore she cannot be considered for appointment as Anganwadi worker, as the post of Anganwadi assistant which she was holding was on contract basis. The learned counsel for the petitioner would join issue to submit that the petitioner today is qualified for having passed the SSLC in the year 2014. Therefore,
sorry, my lords, for the interference. My lords, regular mode also she has completed SSLC on June 2020, my lords. 14 is distance mode. Regular she has completed
anyway, in distance mode and has completed SSLC in the regular mode in the year 2020.
Please.
Nonetheless, he would submit that today the petitioner is eligible to be considered for direct recruitment to the post of Anganwadi worker, more so in the light of the fact that she has been working as Anganwadi assistant in the aforesaid Kendra. The afore narrated facts are not in dispute. The issue lies in a narrow compass as to the notification dated 25/10/2018. Stay there,
please stay,
which has been stayed at the hands of this court throughout. The petitioner is said to be appointed at the aforesaid Anganwadi center in the year 2008. The service certificate issued to the petitioner reads as follows. Will flag up here. Therefore, the petitioner even today is said to be working, which would amount to 16 years of service as Anganwadi assistant in the aforesaid Anganwadi Kendra. In the light of the petitioner working and being fully eligible to be considered for appointment to the post of Anganwadi worker, the state, as and when would issue a notification, should consider the case of the petitioner, taking the experience of the petitioner that she has experience of the petitioner for 16 years as Anganwadi worker, as for the post of Anganwadi worker, the feeder cadre, direct recruitment alla, promotion.
The
feeder cadre for the Anganwadi feeder cadre for the Anganwadi worker is the Anganwadi assistant. Since the interim order is subsisting and the petitioner is continued in the said post, her services would not be discontinued until a notification comes about for appointment to the post of appointment/promotion to the post of Anganwadi worker. Ordered.
My lords.
Then the-
Notification may kindly be set aside, my lords.
Correct, or so and so. In the light of, for the aforesaid reasons, the following order. The writ petition is allowed in part. The notification dated 25/10/2018 being erroneous is set aside. The state is at liberty to continue with the selection, state is at liberty to issue such notification in accordance with law for appointment to the post of Anganwadi worker or Anganwadi assistant, as the case would be in the Anganwadi center. In the event notification is issued, the observations made in the course of the order shall be borne in mind.
Highly obliged.
Next.
Cell number 8, Girish Yadwad, Jay Shetty, Anil Khare.
Yesterday's matter,
My lord,
death of senior citizen.
I have filed the memo, my lord, in fact.
Yen memo?
Memo, my lord.
Death certificate.
Death certificate as also the will, my lord, executed by the first
Will
respondent.
alli sir. Will AC ಮುಂದೆ ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ.
Alala, in favor of his wife. And in fact, my lord, the complaint made by the first respondent before the assistant commissioner may kindly be seen. The second thing is, my lord, what my lord, the petitioner is saying that my lord, he is the husband of my lord, the third respondent, and third respondent has executed a gift deed in his favor. In fact, my lord, your lordship may kindly see the cause title itself. Cause title, my lord, it shows that Sunanda is the wife of my lord Adagowda Patil. And this
Recently
Sunanda, my lord, is stated to have executed a gift deed in favor of the petitioner. My lord, this my lord, gift deed, my lord, your lordship may kindly see the gift deed.
ಆಯ್ತು gift deed ಆಯ್ತಲ್ಲ.
ಅಲ್ಲ gift deed ಪ್ರಕಾರ ಅವ್ರಿಗೆ in fact it is not stamped, duly stamped, not a duly stamped.
You challenge it, sir.
ಅಲ್ಲ, second thing is
See, if you want to challenge as a sibling or a member of the family or even the wife, if you
yes.
want to challenge it, senior citizen forum only, you can go, wife can go, that's a different thing. But if the other members of the family, suit.
ಅಲ್ಲ, already suit is pending,
I'll
pending,
continue.
and my lord, this the very petitioner is also a party in that.
Very good. Excellent. Agitate everything.
In
See,
that suit, my lord.
on the, from the
In
shoulders
fact,
of, from the
another,
shoulders, from the shoulders of a senior citizen, don't settle your scores.
No, I am not so. My lord, in fact, the two senior citizens, in fact, the first respondent and his wife, my lord, in fact, the petition has been filed by the, my lord, the first respondent, my lord, wherein the averments that he and his wife has been, my lord, though senior citizens, have not been, my lord, given any behind their back, my lord, the property has been mutated in their name of, my lord, these present respondents.
Where is wife is a party here?
Wife ಮಾಡಲಿಲ್ಲ, ಸತ್ತ ಮೇಲೇನೂ ಮಾಡಿಲ್ಲ. That's what I am saying.
Allah, mother, your mother, right?
ಮಾಡಿಲ್ಲ.
May I state the facts in one line? Senior citizen files, my lord, this petition. I am the, my lord, his son-in-law to the daughter born to his first wife. ಏನಾಗಿದೆ ಒಂದು ಇಬ್ರು ಹೆಂಡತಿ ಹೆಸರು, first wife and second wife, both name is Rajawwa. First wife had 2 daughters only, out of which one is my wife. The first wife who dies, before her death executes a will in favor of, my lord, my wife. She dies. My wife gets a right. Her name is entered. She executes registered gift deed, properly stamped illa anta helidare. Registered gift deed is executed in my favor. Property as on today stands in my name. Now the father-in-law approaches the senior citizen court saying that all my children have thrown myself and his second wife out of the home. They are not taking care. Prayer made therein is to put him back in possession. Now the court, that is the tribunal, even though securing a revenue inspector's report which says that there is a gift deed, property stands in my name, passes an order that operative portion of the order may kindly be seen. Then whether, my lord, all this argument is necessary or not can be decided. Page number 25. ಪೀಠಿಕೆಯಲ್ಲಿ ಚರ್ಚಿಸಿದಂತೆ ಪ್ರಸ್ತುತ ಸಾವಳಗಿ ಗ್ರಾಮದ ಸೋ ಅಂಡ್ ಸೊ ಜಮೀನು ದೂರದಾರರ ಭಾವು ನೇಮಣ್ಣ ಕಾವಟೇಕರ್ ಇವರ ಹೆಸರಿನಲ್ಲಿ ಅವರ ಹಯಾತಿವರೆಗೆ ಮಾತ್ರ ದಾಖಲಿಸಲು ತಹಶೀಲ್ದಾರ್ ಜಮಖಂಡಿ ಅವರಿಗೆ ಪಾಲನೆ ಪೋಷಿಸುವ ಕಾಯ್ದೆ ಆದೇಶಿಸಿದೆ. So now my lord, his name was to be mutated only during his lifetime. He is now no more. But unfortunately, even though there is an interim order granted in this writ petition, of course, writ petition kodlilla, I approached the division bench. Division bench granted until disposal. But his name is entered. Now I am instructed that taking disadvantage of the entry of his name, now he has my lord made a will. ಅದೆಲ್ಲ ಏನೇ ಇದ್ರು ಅವರಲ್ಲಿ ಮಾಡ್ಕೊಳ್ಳಿ. So this order my lord, and his name has to be deleted.
Including everything, my lord, can be decided in civil court. He is also a party.
Pursuant to this, now his name has to be
Also a party
deleted.
before the civil court.
Allide, but
Also
this
party
order
before
my
the
lord
civil
cannot
court.
be.
My lord, I have given the copy of it.
This order in the face of
Let,
it,
my lord,
after
all the
noting that
parties
land
will
standing in
agitate
my
their
name
rights.
cannot stand for a moment. So it has to be quashed. His name has to be deleted. All other rights to be agitated before the civil court. This is what.
Why were you in a hurry to get your name entered?
My lord, it is long back, my lord.
Long back.
Yes, my lord. His name was there in the record of rights.
ಅಲ್ಲ ಇರ್ಲಿಲ್ಲ ಅಂತಾನೆ ಪೆಟಿಷನ್ ಹಾಕಿದ್ರು.
ಇವ್ರದಲ್ಲ, not the senior citizen who went before the court.
Yes.
But ಯಾರ ನೇಮ್ ಎಂಟರ್ ಆಗಿದೆ ಈಗ?
Senior citizen.
ಅದೇ that should
ಹೌದು.
ಈಗ
That
now
should
it is
go.
not there.
That should go in
Let
view
it
of
be,
this
my
order.
lord.
Order will.
Yes.
Let it be, my lord, go on, my lord. In fact, all the rights
That
can
should
be
be deleted in
agitated
view of
before
this
this.
order.
ಏನೇ ಆಗ್ಬೋದು ಇಲ್ಲ? Lord, one
ಅಷ್ಟೇ ಇರೋದು.
ಅಲ್ಲ ಅದಕ್ಕೆ
ನಿಮ್ದೇನು?
One more aspect in this. My lords, this is not the only 11 acre 30 guntas.
some
This
of the
land is, my
property.
lord, there are two lands. 11 acre 30 gunta, the senior citizen, he retained himself.
ಹಾ ಅದು
And
ಇದೆ.
remaining 11 acre 31 gunta, he, my lord, gives it to his daughters. And
Out of that,
dispute is
5
only
acres in my name.
remaining 11 acre
ಅದು
30.
ನೀವು ಸೂಟಲ್ಲಿ ಮಾಡ್ಕೊಳ್ಳಿ.
ಅಲ್ಲ
Remaining
My lord,
11
more apart from that,
ಈಗೇನಾಗಿದೆ
he is
my lords
also
may
not
kindly
the-
appreciate.
Shetty sir, now that the senior citizen is no more,
Yes.
the benefit of the act
Yes.
goes.
Yes.
If the benefit of the act goes, whatever he has done there, if he is no more, it is for his benefit. ಅವರೇ ಇಲ್ಲ ಅಂದ್ರೆ ನೀವು ಹೊಡೆದಾಡ್ಕೊಳ್ಳೋದು
ಅಲ್ಲಲ್ಲ
ಅರ್ಥ ಇಲ್ಲ.
ಅದು his benefit ಅಂತ ಹೇಳಿಕ್ ಆಗೋದಿಲ್ಲ because complaint may kindly be seen.
ಇಲ್ಲ ಕಂಪ್ಲೇಂಟ್.
He and his wife ಅಂತ ಹೇಳ್ತಾರೆ.
ಚಾಲೆಂಜ್ ದಿಸ್ ಆರ್ಡರ್.
ಅಲ್ಲ
ಅಲ್ಲಿ ನೀವು ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ ಆರ್ಡರ್.
ನಾವು ಮಾಡಿಲ್ಲ, ನಮ್ಮ ಇವ್ರ ಪರವಾಗಿ ಆಗಿದೆ, ನಮ್ಮ ಮನೆಯವ್ರ ಪರವಾಗಿ ಆಗಿದೆ.
ಪರವಾಗಿ ಇತ್ತು ನೀವು ಇರೋವರೆಗೂ.
ಹೌದು.
ಈಗಿಲ್ವಲ್ಲ. ಸೊ
ಅಲ್ಲ,
ನೀವೇ
ನಾವು also my lord,
you
your
should have
lordship,
challenged the finding, not till I'm alive.
ಅಲ್ಲ, what I am saying that complaint averments may kindly be seen. He and his wife, my lord, is not.
All gone. Complaint, averments, order,
That
lock, stock, barrel will go.
No, my lord, that only, my lord, what I am saying that.
You agitate
Whether,
all your rights
my
before
lord,
the civil.
whether without making a wife as a party, can, my lord, it is been.
It is too late for you to.
ಅಲ್ಲ it was for him to make her a party. His
No,
own
no, no,
wife.
not for me.
ಅವ್ರು
My
ನನ್ನೂ
lord,
ಪಾರ್ಟಿ ಮಾಡ್ಲಿಲ್ಲ,
that is-
ಹೆಂಡತಿನೂ ಪಾರ್ಟಿ ಮಾಡ್ಲಿಲ್ಲ.
No, no, no. What I am saying that, but this order is passed, my lord, is without, my lord, wife being made as a party.
On that
Because,
ground
my lord,
also it has
she
to
is
be
claim-
quashed.
No, no, if she is claiming a right, my lord, I will not say anything more, my lord. In fact,
No, you
no, no,
will-
no, no,
you
no,
will
no,
put anything more. I will say many things more.
no, no, no,
No problem.
no, no, whether, my lord,
Who went before the tribunal, sir?
my lord, tribunal, my lord, the first respondent is no more.
1 minute, sir. Who went before the tribunal?
First respondent.
ಯಾರ್ ಮಾಡ್ಬೇಕಾಗಿತ್ತು?
First respondent is not.
ಯಾರನ್ನ ಪಾರ್ಟಿ ಮಾಡ್ಬೇಕಾಗಿತ್ತು?
ಅಲ್ಲಲ್ಲ, first respondent is no more now.
Sir, you tell me ಯಾರನ್ನ ಪಾರ್ಟಿ ಮಾಡ್ಬೇಕಾಗಿತ್ತು?
Now-
ಏನೋ ಹೇಳ್ತಾ ಇದ್ರಲ್ಲ behind ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ ವೈಫ್ ನ who has to make them parties?
Petitioner, my lord,
ಯಾಕೆ
because
ಅವ್ರ
he is.
ಹೋಗಿದ್ದು tribunal
No, no,
ಮುಂದೆ?
now first respondent is died.
Sir, ಅವರ
First-
ಹೋಗಿ tribunal ಮುಂದೆ.
First respondent is no more. My lord, who has to be represented on his
This is
behalf
the
after
problem.
his death?
You are always begging the question and never an answer. That's the problem.
No, no,
Don't do that.
no, no, but my respect, no,
My
no.
question is
No.
plain and simple. Who went before the tribunal?
First respondent.
Who is in control of someone making parties?
No, no,
Who is in
before,
control?
my
Who
lord,
had- who had to make
no,
your
no,
wife party or
no,
him
no,
party?
before the, my lord, first respondent, my lord, before the deputy commissioner, I am not saying that, my lord.
ಅಲ್ವಾ?
My lord, so far as, my lord, this, before this honorable court.
Why
in
should
vi-
he make a party?
No, no,
here, sir?
in view of death.
Why should he make
No,
the
in view,
wife a party?
ಅಲ್ಲಲ್ಲ,
here?
in view of his death. In view of his
Why
death.
should he make?
No, no, I will, my lord.
ಪಾರ್ಟಿ ಮಾಡೋಕ್ ಬರೋದಿಲ್ಲ ಅಂತ ಕೇರಳ ಹೈಕೋರ್ಟ್ ಡಿವಿಷನ್ ಬೆಂಚ್
Sir,
ಹೋಲ್ಡ್ಸ್.
ಬರಲ್ಲ ಸರ್, ಅದಕ್ಕೆ ಜಡ್ಮೆಂಟ್
ಅಲ್ಲ ಜಸ್ಟ್ ಟು ಕೌಂಟರ್ ಇಸ್ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ದನ್ನ ದಿ ಡಿವಿಷನ್ ಬೆಂಚ್ ಸೆಡ್ ಯು ಇಂಪ್ಲೀಡ್ ದಿ ಪಾರ್ಟಿ. Learned single judge, it was
No, no,
wrong. Then
question of
division bench
impli-
affirms that it was
question
wrong.
of impleading would not arise.
I will now.
Otherwise, my lord, I will make a necessary application for
Oh,
impleading.
I will not give this petition.
ಅದೇ ಬರೋದಿಲ್ಲ ಅಂತ ಜಜ್ಮೆಂಟ್ ಕೊಟ್ಟಿರೋದು, ಅದೆಲ್ಲ ಬರೋದಿಲ್ಲ.
Even for a moment to generate further litigation here, yes.
What my respectful submission is that
Tell us, sir.
all of them are before the civil court. Let that may agitated matter.
ನಾನೇನೇ
be
ಹೇಳ್ದೆ ನಾನು.
pursued.
But this my lord, order, it has to be observed that his name has to go pursuant to
I
this.
will pass.
Yes, yes.
The petitioner is before this court calling in question an order dated 10/2/2022 passed by the tribunal constituted under so and so Act, Senior Citizens Act, i.e. the Assistant Commissioner. They've heard so and so. Facts in brief, Germain, are as follows. The third respondent is said to have executed a registered gift deed in favor of the petitioner, gifting the subject property to the hands of the petitioner. Therefore, the petitioner is said to have become the owner of the property, and his name is also entered into the record of rights. The history to that gift appears to be from the hands of the first respondent traveled to the third respondent. Therefore, the first respondent, father of the second respondent, and father-in-law of the present petitioner.
Marriage is also disputed, not because she is not the wife of
The civil court al madi, sir.
In fact,
Yes.
from their government
So and
itself.
so. Father-in-law of the petitioner approaches the assistant commissioner on 21/9/2021. 10/2/20. When did he approach, sir? Girish, neevunu hinge madidre.
21/9/2021. Application at annexure C, page number 18.
The assistant commissioner on 21/9/2021 seeking the re-entry of his name into the record of rights of the subject land that was projected before the tribunal, alleging that the husband and the wife have not been taken care of by the donee of the property, the petitioner herein. The petitioner was not made a party to the proceedings, nor his wife. The first, the
wife is a party.
Wife is a party.
Our respond number 3.
The illalla alli.
Allidar. Magalidar.
So the petitioner was not made a party. The tribunal allows the application filed before it and directs that the entry in the record of rights be restored in favor of the first petitioner, first respondent, the father, and that would remain during his lifetime. The said order is in challenge before this court. Interim order was initially refused, which was challenged before the division bench, and the division bench grants an interim order of stay and makes it subject to the outcome of the present petition. The learned counsel Girish Dharwad, appearing for the petitioner, submits that the first respondent who had approached the tribunal is no more today. Therefore, none of the rights that flew from the order in which the first respondent was the applicant should not be allowed to remain. He would submit that all the parties all the members of the family are before the civil court in OS 80 of 2022, and the rights should be left to be agitated before the said fora. Counsel for the first respondent, J. Shetty, would admit the fact that the father is no more, but would make a vain attempt to seek that the wife should be impleaded as a party respondent to these proceedings in the subject petition. And would submit that that a perusal at the complaint would indicate that husband and the wife both were ill-treated by the children, and therefore the petition should not be disposed on the score that the first respondent is no more. The learned counsel Anil Kale, representing Yarna Kale, the fourth respondent would toe the lines of the present petitioner in contending that the parties are before the civil court and they would agitate their rights before the civil court. I have given my anxious consideration, so on, so on, so. The afore narrated facts are not in dispute. The act is created for the purpose of benefit of the senior citizens and empowers a senior citizen to knock at the doors of the assistant commissioner on the grievance of whatever kind it would be, whatever of manifold nature, grievance of manifold nature. One such grievance that was projected by the senior citizen, first respondent herein before the tribunal was with regard to an alleged mutation entry that was made in favor of the petitioner in terms of a gift deed. The tribunal,
He doesn't say so. In his petition, he does not refer to me, the gift did nothing. He says that his children are not taking care and they have got mutated their own names, and this is what
the complaint before the assistant commissioner was of the senior citizen, first respondent, was that the children of his children are not taking care of his needs and have got the property mutated in their own names, and therefore the tribunal and own names. It is to be noticed that the present petitioner was not even made a party before the tribunal. The tribunal passes an order protecting the rights of the senior citizen till he is alive or during his lifetime. Page 25, the order reads as follows. It transpires that the first respondent now has died on 9/10/2024. Therefore, the order that was to be in operation up to the date, during the lifetime of the first respondent would automatically cease on the death, on his death, which is on 9/10/2024. 9/10/2024. Therefore, the benefit that was rendered to a senior citizen first respondent undoubtedly vanishes on the death, on his death. The siblings or the children are in a squabble with regard to property. The forum for resolution of the said dispute is not before the assistant commissioner, nor in furtherance of the order of the assistant commissioner. It should be before a competent civil court. Rightly so, the family members are before the competent civil court in original suit 80 of 2022. They are at liberty to agitate all their rights before the civil court. In the light of the order impugned having its life only up to the lifetime of the senior citizen, and he breathing his last, the order also should breathe its last. Therefore, the order which was limited cannot have an unlimited benefit to others. Therefore, the order is now to be obliterated, and all the consequential action taken on the strength of the order would also be obliterated.
including entry of the
consequential action.
Sometimes the revenue authorities won't understand.
If any, obliterate for the aforesaid reasons, the following order. The writ petition is allowed, so and so order is quashed. Any action taken pursuant to the order or on the strength of the order shall be restored status quo ante, which will however remain subject to the result of the civil suit pending in original suit OS 80 of 2022, ordered accordingly.
Bill number 9, PN Hatti, CS party.
The one that regarding the suit, if my lord should say that it was the contention of
party.
It was the contention of the respondent number 1 ಅಂತ ಹೇಳಿದ್ರೆ suit ಇಲ್ಲ ನಾನು ಪೆಟಿಷನ್ ಅಲ್ಲಿ ಹೇಳಿಲ್ಲ
ಡೈರೆಕ್ಷನ್ ಅವರದು ಕಂಟೆನ್ಷನ್ ಅಂತ ಹೇಳಿ
ಸೂಟ್ ಬಗ್ಗೆ ಸೂಟ್ ಪೆಂಡಿಂಗ್ ಇರೋ ಬಗ್ಗೆ ಕಂಟೆನ್ಷನ್ ನಂದು ಅಂತ ಬಂತು. ಇಟ್ ವಾಸ್ ನಾಟ್ ಮೈ ಕಂಟೆನ್ಷನ್. ಪ್ಲೀಸ್
ನೀವು ಪಾರ್ಟಿ ಇದೀರಲ್ಲ,
ಅವರು ಪಾರ್ಟಿ ಇದ್ದಾರೆ.
ಇಟ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಎನಿವೇ ಸಬ್ಜೆಕ್ಟ್ ಟು ದಿ ರಿಸಲ್ಟ್.
Yes.
Please appear on behalf of petitioner. Last occasion, Your Lordship, pleased to hear this matter. But petitioner retired without any promotion for 25-30 years.
The government order.
Yes.
Colleague is not there, my lord.
Where is she?
He is not keeping there, my lord. Day after tomorrow, sir. Saturday, my lord, sir.
Saturday, Friday.
Friday, please.
Day after tomorrow,
please.
Bill number 10.
But I appear for the counsel for the petitioner, my lord.
Yes, Bhagat sir.
A brief fact in reading to the case, my lord. The petitioner is assistant engineer, which is a Group P post, but appointed as assistant engineer. Am I audible, my lord?
Case mute ಆಗೋಗುತ್ತೆ ಹಿಂಗಾದ್ರೆ.
ತಮ್ಮ ಕೇಳ್ತಾ ಇದೆ ಬಟ್
Yes,
My lord,
sir.
am I audible now?
Oh, more than audible. Yes, sir.
Yes, my lord. My lord, 14/1/2011 is appointed as my lord assistant engineer my lord, by the with the prior approval of the board.
Who is the answering
Karnataka.
respondent? Ready, Allah?
Let me-
Yes.
Short question is my lord, whether the second respondent is competent to impose penalty of dismissal under the rules. Not on merit, my lord, I am arguing today.
ಮತ್ತೆ
By
interim
granting
order.
interim order, my lord.
Granting interim order in a 2022 petition. Where is the
No, no.
question?
Interim order was there, my lord. While granting interim order, this court granted stay of impugned order having regard to the my lord competency.
It is still respondent as filed today filing that. Yes, sir. Competent ilwa?
Lord,
I have produced the regulation, my lord, NDC.
the order of dismissal should have been passed by a board as it is appointing authority. But here MD has passed the order, but subsequently it's been placed before a board, my lord, and particular order is ratified.
Ratified. Principle of ratification will relate back to the date of the order. Kodi, Mining Board versus Sunil. 2006 5 SCC. Give it. Bandilwa?
No, that cannot. No, board is the appointing authority.
That was
Board
also
is
a
the
case.
authority.
That was also a case of dismissal by an incompetent authority, and the board of directors affirmed it. Then the apex court, 3-judge bench of the apex court holds that principle of ratification. It relate back. Board of Mining versus Sunil, sir.
Yes, my lord. Kindly appreciate this. Here is a case, my lord. The board is the authority to pass order, not anybody else. Charge memo must be issued by the board. Kindly appreciate, my lord, this.
No, ide, Sunil. Who is the disciplinary authority? Sir, one moment, sir. Who is the disciplinary authority?
My lord,
Board, my lord.
that
One nimsha, sir.
disciplinary authority is a board, my lord. Appointing authority is disciplinary authority is a managing director.
Disciplinary authority is managing director.
Managing
Where do you
director.
get it?
It is not there, my lord.
Who is the disciplinary authority?
But appointing authority is there, not kindly see page 169. I produced the rule.
Where is the schedule, sir?
Schedule, all schedule I have produced, my lord. So far as what disciplinary authority is concerned.
Sir, where is the schedule of empowerment?
No empowerment. No empowerment in the schedule, my lord.
Sir, empowerment andre schedule of authorities who are empowered to pass orders.
Such a rules are not framed at all.
Who is your disciplinary authority? What cadre are you
But
in, sir?
according to me, my lord, kindly take rule.
Not according to you, sir, according to law.
According to law, my lord. According to law, my lord, I have produced the rule itself. My lord, page 162. My lord will come to rule 4, classification of post. Then rule 11. Page 157, my lord, assistant engineer is a group B post. My lord, then my lord, 11.3, page 169, appointing authority. Appointing authority shall be the board for group A and B post. Managing director is for other post. That's all.
Bhagavad sir, appointing authority, 1 minute Kelly.
Yes.
Appointing authority need not be the disciplinary authority.
Yes, my lord is right.
Right. Disciplinary authority is different, appointing authority is different.
My lord, I fully agree with your lordship, my lord. There is no other rule.
That is why I am saying here what is depicted is appointing authority. He need not be the disciplinary authority. Who is the disciplinary authority?
Correct, managing director is not the disciplinary authority.
How do you say that?
There is no other rule. There is no other rule.
Yes, mister.
That is a difficulty, my lord.
I need to verify it, my lord.
What do you need to verify?
That is the disciplinary authority, my lord.
ನೀವು ಇಲ್ಲಿವರೆಗೂ ಇಬ್ರು ಬೇರೆ ಬೇರೆ ಇರ್ಬೋದು ಅಂತಾನು ಗೊತ್ತಿಲ್ವಾ?
Then as it was the contention, my lord, and
sir,
that is
your contention, your contention has baffled him. The two can be different. The two need not be one. Yes.
No need
That
at
is
all.
why I
My lord
said
is right.
where is the schedule of empowering of empowered officers?
It is not there, my lord.
Tomorrow, my lords, I'll verify, my lord, I'll submit tomorrow.
Who is the disciplinary authority? To
Yes.
assistant engineer.
Yes, my lords.
Appointing authority may be the board.
Yes,
But that need not be the disciplinary authority. If there is nobody, then I will take him as a disciplinary, I take the board as disciplinary authority.
Yes, my lords.
This is wrong. This is not the way to frame rules. On schedule ಮಾಡಕ್ಕೆ ನಿಮ್ಗೆ ಯಾರು disciplinary authority, appellate authority ಅಂತ? For
Probably
imposition of penalty, who is the disciplinary authority?
board, my lords.
Board.
Allah, then appointing authority is a board, my
Board.
lords.
If according to you, imposition of penalty is by the board, who is the appellate authority? Government. This is a statutory board, sir. Where is the government coming in?
Yes, my lords.
There is no regulation framed, my lord, regarding regulating disciplinary authority and appellate authority. That's the difficulty I faced.
Tomorrow, my lords.
Tomorrow.
Yes, my lords.
Yes. And tell your board, anyway, I will write in this. ಈ ತರ ambiguity ಇಟ್ಕೊಂಡು what law can you lay down?
My lord,
Interim order.
Serious. That will continue.
my lord, one more sufficient, my lord.
Sir.
Serial number 120 is also common order, same order. 120, 120, it's a common order, my lord.
ಎರಡು ನಾಳೆ ಬರಲಿ ಬಿಡಿ.
ಪರವಾಗಿಲ್ಲ, ತೊಂದ್ರೆ.
We'll decide.
But I have searched, my lord. If anything is there, my lord, I could have submitted. I have not.
No, I'm not saying you have not submitted, but in a service rule or in a
Yes,
conduct
Lord.
and discipline rules, you should always have a schedule of authorities empowered to pass out.
Certainly, my lord, it is not there. I have produced all the schedule,
That we'll
1
see.
to 5.
Because
1 to 5.
appointing authority is definitely the board in any statutory boards. But
Correct.
that need not mean that they are the disciplinary authority.
Certainly, my lord, disciplinary authority may be different, appointing
Yes.
authority may be different. I
Yes.
fully agree.
Yes.
But I have produced all schedules.
We'll see, we'll
that,
see.
my lord,
Tomorrow. Yes.
in the fresh matter list, my lord.
Yes, sir.
In the fresh matter list.
You, aitu, sir. Yes.
Lords, the petitioner has purchased the petition property, which is a residential apartment in a public auction, my lord. In that regard, the sales certificate is issued by the bank and it got registered on.
ಅಲ್ಲ, registration is done, my lords.
ಹಾ.
ಇದರಲ್ಲಿ mutation entry ಮಾಡಬೇಕಾಗಿತ್ತು. There is a mistake on the part of the officer, my lords.
Kaveri software.
ಇದಿಲ್ಲ,
Lords,
ಇದಿಲ್ಲ.
they're asking me,
ಅಲ್ಲ, my lords, we have written letter, my lords, thrice. They have not responded, my lords. That
The officer.
the
respondent number 2, my lord.
We'll ask him to be present. ADLR.
Yes, my lord.
ADLR city survey. Because the order itself is, my lords.
DGA submits that despite 3 communications, the ADLR has not responded. Therefore, the ADLR, ಏನಿದು?
City survey.
Dharwad.
ADLR city survey, Dharwad. City survey.
City survey.
ADLR city survey shall be present before the court at 2:30 PM on 6th.
Please.
ಇವಾಗ ಅವ್ರು ಬರೋದ್ರೊಳಗೆ ಮಾಡಿರ್ತಾರೆ.
Yes, sir.
12 ದಯಾನಂದ ಮಡ್ಡಿ ಜೀವ ಗತಿ ಮಾಡಿ.
Lords,
ಸುಮ್ನೆ ಹೇಳಿದ್ರೆ ಆಗದೇ ಇಲ್ಲ.
the respondent board, the state pollution control board, has notified 56 posts calling for a post of assistant environmental officer, in which, my lord, for 2A category there were 5 posts, 2 for a women, 2 for a rural, 1 handicapped and 1 general merit. So, my lord, for 2A category others, I have filed application. My lord, though posts were 56, my lord, the 52 were selected and final list has been released. At the same time, my lord, the additional list was also released. And what is noted is, my lord, if somebody in the main list is not appointed, then the parallel person in the additional list would be appointed for that particular post. So as they haven't appointed, my lord, vacancy no 9 ಇದೆ. So, my lord, initially the writ petition allowed in my favor. That is at page number annexure E, page number 41. Yes, my lords. So here, my lord, the very categorically it is stated that I have entitled to that particular post and considered me within 3 months. My lord, despite that, my lord, they have issued an endorsement. After filing a contempt petition, they issued an endorsement, which is absolutely what should have been a grounds before the writ court. Those grounds have been taken. And the initial appointments have been done in the year 2014. While, my lord, what they say is, one Mr. Adarsh was not appointed. In his place, I should be considered. That is the order, my lords. So they say that as the marks of the others were higher, so he has considered for his non-appointment was considered in a general merit. So we'll keep the general merit post vacant.
Have you challenged single judge's order?
No, my lord, it attained finality.
Allah, my lords,
Finding has become final.
in the writ petition, my lords, they pass.
ನೀವು writable ಏನ್ ಹಾಕ್ಲಿಲ್ಲಲ್ಲ?
ಇಲ್ಲ, Allah, they told us to consider and pass the appropriate.
ಆ consideration ಗೆ there is some finding given.
My lords, in the contempt, we our
Contempt is for contempt. Don't improve your case in contempt.
Allah, in the writ petition, my lords, our contention was that we have forwarded to the government and government.
That is considered by the land single judge.
Later, my lords, government directed us, my lords, in among one post which is reserved for the category 2A general.
Others did not join.
Did not join.
ಹೌದಾ? ಇವ್ರು ಕೂಡ ಕೆನೆ.
Allah, but category 2A general ಗೆ already Veena, the name Veena Kona at the serial number 30.
Others yes was also for category 2A.
He was selected in the general merit.
No,
Who was selected? Others.
Yes.
He also did not join anyway.
he did not join.
Allah, but the
Merit he had traveled to general merit.
Yes.
yes, yes. But
No, no, no.
what the
Even in
petitioner
the
is
general
claiming-
merit, he was not appointed. Sorry, my lords.
what the petitioner is claiming now, it is for 2A category. And in that 2A category, already Veena Kona, who has more merit marks than the petitioner, who already is selected and the list is announced.
You can't non-suit the person who has been selected. But he join ಆಗಿಲ್ವಲ್ಲ others post ಗೆ you can give it. That is the direction anyway. That's
Allah,
That is the
in
direction.
that writ petition, my lords,
one ನಿಮಿಷ sir. Para 5. Others was selected under category 2A and the material on record would show that others S had not joined the said post. All right. Counsel for the petition produced list of employees so and so. The said post has been lying vacant for nearly 7 years, though the petitioner's name was found in the additional list, waiting list. This observation has become final.
allow 2A ಒಳಗೆ select ಆಗಿದ್ರೆ we would have.
ನೀವು ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರೆ ಈ ಆರ್ಡರ್ನ there was some meaning. Not having challenge, now you cannot. We'll have to again allow the petition with a positive direction.
Now, my lords, if that is the case, my lords, there is no post as
ಅಲ್ಲ,
of now.
ಇನ್ನು 9 ಪೋಸ್ಟ್ ಇವೆ. ಇನಿಷಿಯಲಿ 56 ಇದ್ದದ್ದೇ 52 ತಗೊಂಡಿದ್ದಾರೆ.
And it is not that he was not in the select list at all. He was in the waiting list.
Yes, my lords.
Please.
You should have operated the wait list. And wait list also has a life only for 1 year or 2 years. Now what?
Where petitioner claims for the post, my lords, that post itself is not there now. Because
No, it
because
is
already
there. That is
2A
the finding of the court, sir. It is there.
ಒಂದು ವೇಳೆ 2A ಒಳಗೆ the others was
ಇದೆ ಅಂತಾನೆ ಬರೆದಿದ್ದಾರೆ ಇಲ್ಲಿ ಮುಂಚೆ. That finding has become final. Why should I not follow it?
Lords, I requested for passover.
Passover ಬೇಡ. ನಾಳೆ ಬೇಡ. We'll take it on 7th. Please list on 7th in the fresh matters list. Yes.
Okay, please, ma'am. Grateful.
Bill number 13, Shri Nilopan.
Next, A is the impugned order, my lord.
Dismiss for non-prosecution ಆಗಿತ್ತಾ?
Yes.
ಏನು ಕಾಂಪ್ರಮೈಸ್?
Compassionate appointment, my lord, has been denied without assigning any reasons, my lord.
ನೋಟಿಸ್ ಆಗಿಲ್ಲಲ್ಲ. ನಿಮಿಷ. ಕೋಆಪರೇಟಿವ್ ಬ್ಯಾಂಕ್
Yes.
ಯಾರ ಅಪ್ಲೈ ಆಗ್ತಾರೆ? ಯಾರಿಲ್ವಾ?
Emergent.
ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್.
Third,
three again, better,
dispensation.
Memo. The learned counsel for the, emergent notice to the respondents 1 and 2 returnable by the 18th of February. List the matter on 18th in the fresh matters list. Notice to the third respondent is not necessary for the present. Memo ಆಮೇಲೆ
14, Ganesh Rai Bagi, Shivraj P. Mudhol.
Appear for the respondent. Appear for the respondent, yes, come, my lord. My lord, a petitioner filed, my lord, the writ petition seeking a writ in the nature of mandamus, my lord, annex H, page 54, to appoint her on compassionate ground on account of, my lord, he sustained, my lord, electric injury but the Act and regulation does not provide for my lord, appointment of any my lord, compensate ground if they suffered my lord, injury. Only death of my lord, on account of death of the deceased employee, my lord, the Act provides.
Now, if electrical injury due to
While, while she is not the, in the terrace, not while she is not the, putting not the, hanging the wet cloths, not, she not come in contact with not the electric wires. She suffered. Then she filed a suit for seeking compensation. Appeal, then 7,20,000 has been not awarded, decree was passed by the civil court. After that, not after lapse of 16 years, not this representation has been filed. Date of alleged incident is 2008, 4/10/2008. Representation is 2015. Therefore, my lord,
what was she?
No,
she's, at that time she was minor, my lord, student, my lord, she's student.
No, who died?
No died, my lord, there is no death, my lord. The petitioner herself, my lord, come in contact with my lord, electric wire.
Who was there? Her mother, father as an employee?
They're not my,
Oh, employment on this
on this
electrical mishap.
Yes, regulation does not provide, my lord. Regulation only, but death of not the employee.
She is not an employee.
Not employee, and her parents are not working.
ಅಷ್ಟೇ ಇದು ಬಿಟ್ಬಿಟ್ರೆ ಕಷ್ಟ ಆಗುತ್ತೆ. Public employment.
80% of disability, my lord.
You've seen the photographs. What to do? Where is the scope of
My lord,
employment?
my lord, in the event of my lord, any call for or recruitment, any fresh recruitment, my lord, she may be reserved.
You can
Because
reserve
this
the
court can't
like-
very well, my lord.
There is a
right to-
provision for reservation of disability.
On the disability, you can.
They are entitled.
And even, my lord, even priority also may be given at the time of recruitment. That can be, this court can very well.
Sir, see, there will be so many people who have suffered this mishap due to electricity. This is not due to the making of the respondents. It's a fortuitous circumstance. You can't. But the petitioner is before this court seeking the following prayer. On 4/10/2008, the petitioner, a minor girl at that point in time, is said to have gone to the terrace for washing the clothes. And after washing the clothes, the wet clothes come in contact with the live wire and caused serious injuries. The petitioner is said to have suffered 80% disability and continues to suffer the said disability as it was a permanent disability due to the accident. The petitioner then approaches the tribunal seeking compensation on the accident, and the compensation is also granted to the petitioner. A representation then springs on 17/8/2023 for an accident that had happened in the year 2008, seeking appointment on compassionate grounds.
Compassionate.
Appointment on compassionate grounds in the respondent corporation. This comes to be rejected.
No, not rejected. We have not.
Oh, sorry.
Passed any note.
Appointment on compassionate grounds. The representation having not been considered has driven the petitioner to this court in the subject petition. The learned counsel appearing for the petitioner submits that the petitioner has suffered disability due to the accident on account of the clothes coming into contact with a live wire. Therefore, the petitioner should be given a channel for seeking appointment on compassionate grounds, as it is due to the act of the corporation. The learned counsel Shivraj Mudol, representing the corporation, would submit that the appointment on compassionate grounds is in terms of rules, scheme, or any other guidelines, which will be only on the death of the breadwinner of the family who is already an employee. The petitioner, father, mother, or the petitioner are not employees of the corporation. Therefore, a stranger cannot seek compassionate appointment. The afore narrated facts are not in dispute. The dates link in the chain of events and the link in chain of events are all a matter of record. The accident happens on 4/10/2008, which results in morbidity of the petitioner, which is to the tune of 80% today. The petitioner then the petitioner then is granted compensation assessed at 7,50,000 and now seeks appointment on compassionate grounds. While sympathy or empathy apart, it is the respondent is a state under Article 12 of the Constitution of India, and it would deal with public employment. Public employment cannot be granted except in terms of law. The rules or guidelines or scheme of compassionate appointment is available only to the kith and kin of or the dependents of the family, of the corporation servants. The family of the petitioner being none and the petitioner being a stranger to the corporation cannot be seen to contend that she is entitled to consideration of her representation for appointment on compassionate grounds. Compassionate grounds. Therefore, finding no merit, compassionate grounds. It is needless to observe that in the event the corporation would call for applications from eligible candidates, the petitioner would be entitled to apply. At that point in time, the accident may be taken note of.
Please.
In accordance with law by the respondent corporation, ordered accordingly.
Much of that.
Mrityunjaya Salikiri, Shanti Spasmani.
Vishal?
My lord, a compassionate appointment is rejected that she is a married daughter, my lords.
Yes, madam.
Your lordship, the petitioner made application in 2016, your lordship. It has been rejected through the endorsement stating that the married daughters are not eligible. In 2018, they made, both the applications has not been challenged in this petition.
All right. Now, married daughter anta matra madidira. So you reconsider it in tune with law.
Your lordship, there is a division bench judgment, your lordship, where it has
The
been
dependent, Justice Dixit avardalva. Alva, kodi.
Justice Krishna Dikshit.
Krishna Dikshit. Dependent.
Your lordship, at para number 4, it has been settled position of law that in order to claim compassionate appointment, the claimant has to prima facie show that she belongs to the family of the employee.
This is affirmed by division bench and the Supreme Court also.
Your lordship, this
Gender discrimination you can't. She will prove her dependency by adequate affidavit
Your lordship,
documents or whatever it is.
if I can draw your attention to Annexure B, your lordship, at page number 12, she states that her petitioner mother states that ನಾನು ಅವಿದ್ಯಾವಂತಳು ಇದ್ದು ನನಗೆ ಯಾವುದೇ ಕರ್ತವ್ಯವನ್ನು ನಿರ್ವಹಿಸಲು ಆಗುವುದಿಲ್ಲ ಹಾಗೂ ಮಾನಸಿಕವಾಗಿ ಸದೃಢಳು ಇರುವುದಿಲ್ಲ. ನನಗೆ ಒಬ್ಬಳೇ ಮಗಳು ಇದ್ದು ಆಕೆ ಹೆಸರು ಶಂಕರವ್ವ ಮೆಣಸಿನಕಾಯಿ ಅಂತ ಇದ್ದು ನನ್ನ ಮಗಳು ಮತ್ತು ನನ್ನ ಅಳಿಯ ನನ್ನೊಂದಿಗೆ ಇರುತ್ತಾರೆ. It shows that there is proper means, your lordship, to.
No, it shows that mother is dependent on the daughter. Or daughter is dependent on the mother. Mere marriage will not matter.
Your lordship, in this judgment.
Please.
Division bench.
Yes, my lord. And again, my lords, that dependency is, my lord, para 5, my lords. Para 5, my lords. The court doesn't deny that, my lord, a married daughter is entitled. But it only, para 5, it only says, my lord, she is entitled to apply. That means a married woman is entitled to apply for compassion. Does not mean that despite
We'll follow that and this.
It shows that if she is dependent upon the natal family.
She will show the dependency, don't worry. You reconsider it. I'm sorry. This is affirmed by Supreme Court also.
I'm sorry, I did not bring that, my lord. And my lord, in another, my lord, I have stated In Apurva Shri and others, SLP 20116 of 2021, though I did not get that because your lordship judgment was there. The apex court has held, my lord, that married daughter cannot be denied, my lord.
That is saying this.
Yes.
The appellate court says we give our imprimatur to this order.
Yes.
Yes.
So, my lord, since apex court has confirmed that position, they can't deny, my lord, make a discrimination.
Subsequent judgment of the apex
That
court
the
also.
dependency, my lord, in my affidavit also I have stated.
Justice open order. Amal in the ಬೇರೆ ಇನ್ನೊಂದಿದೆ. We'll answer. We'll quote everything and answer it.
Please, my lord.
Yes. ಇದೆರಡು ಇರ್ಲಿ.
Please. I'll give Apurva judgment also.
Apurva Shri, Justice Arvind Kumar.
Please.
Post this on 7th. List on 7th is in fresh matters. Next.
16.
My lord, in this case, my lord, the father died, my lord, during pendency. Yes, my lord. During pendency of he was terminated from service. He had called in question. Then during pendency, my lord, he died. Then the court holds, my lord, that the family is
Order setting aside the order of dismissal.
There is order is held to be illegal and it is set aside, and family is held to be entitled for all benefits.
The petitioner is before this court seeking the following prayer. Heard sounds. The father of the petitioner joins the service of the corporation on 12/12/1996. In the year 2009, on the ground of illness and owing to his absence, he was terminated from his services by the corporation. Agreed by the said termination, the petitioner is said to have raised an industrial dispute in ID 13 of 2016. During the pendency of the dispute, the father of the petitioner dies. The tribunal allows the petition in terms of its order dated 29/6/2020, notwithstanding the passing away of the employee, holding that the termination by the corporation is wholly illegal and directs all the terminal benefits to be paid to the petitioner. The terminal benefits were all paid to the family of the deceased. A representation then springs for seeking appointment on compassionate grounds on 15/7/2020. This comes to be rejected. Reject ಮಾಡಿದ್ದೀರಾ?
Rejected, my lords.
Rejected. What is the reason?
That
rejected
the
on
tribunal has not ordered for compassionate appointment.
They rejected on the score that the order of the tribunal is silent about grant of an appointment on compassionate grounds. Or why will tribunal do that? Grant of appointment on compassionate grounds or otherwise. The petitioner is before this court calling in question the said endorsement so issued. The learned counsel appearing for the petitioner submits that the tribunal, even after the death of the employee, had held the termination to be illegal and directed all consequential benefits to be paid to the petitioner. Therefore, the endorsement that the tribunal has not rendered any finding without finding about compassionate appointment is illegal, is a submission. The counsel, what's your name?
Prashant Hosman. He's on panel. He's on panel.
So and so. Learned counsel Prashant Hosmani, appearing for the petitioner, would vehemently refute the submission to contend that though the terminal benefits are settled in favor of the employee, since the favor of the employee, no consequential benefit of the kind of appointment that is seeking was observed or ordered by the tribunal. Therefore, the rejection does not warrant any interference. I have given my so and so. The aforenarrated facts are not in dispute. The father of the petitioner incurring termination of service is a matter of record. The termination of service being set aside and a direction being rendered to grant all consequential benefits in ID 13 of 2016 is also a matter of record. The order which sets aside the order of dismissal of the petitioner reads as follows, page 20 to 21. It was held that the petitioner was entitled to all service benefits without back wages for the period of absenteeism. The corporation is said to have settled all the terminal benefits. The application, this representation for compassionate appointment is submitted by the petitioner, which comes to be denied by the endorsement.
My lord, Annex C, my lord, page 28, 15-7, page of 28.
Page 28, so and so. By the impugned endorsement dated 29/6/2020. Impugned endorsement dated 14/8/2023.
It's 2020. Yes.
The reason for rendering the endorsement is on the face of it illegal. The tribunal could not have directed consideration of the case of the petitioner for compassionate appointment. The tribunal set aside the order of dismissal and did hold that the family was entitled to all service benefits. All service benefits are granted. If an employee is entitled to compassionate appointment on the death, as the death was during the subsistence of the dispute and the dispute having gone in favor of the employee, the respondent was bound to consider the application or the / representation for compassionate appointment in accordance with law. In that light, the endorsement is rendered unsustainable. For the aforesaid reasons, the following order. Allowed, quashed, the respondents are directed to reconsider the representation of the petitioner for appointment on compassionate grounds in terms of, in accordance with law, within an outer limit of 3 months from the date of receipt of the copy of the order, if not earlier. Ordered.
17, Chair Shri Nilopan.
Mandamus, my lord.
Dismissal.
Mandamus, my lord.
Mandamus
I have
for
been
what, sir?
relieved from fifth respondent.
Mandamus for what?
Lord, I was.
One AGA, 2, 1, 2, 3, 4 AGA, 5, 6 emergent notice.
5, 6, my lord, penal advocates. My
So
lord.
and so,
Please.
5, 6. Kodiya, yaar sir.
Lord, date
Based
may be
on
fixed, my lord.
14th.
Please.
Yes.
Bill number 18, Karthik Anchari.
Last time I was,
For the petition
my lord,
discussion.
directed to verify all the tribunal benefit paid to them.
Verify all the.
Yes. Yeah, they are
ಏನೇನ್ ಕೊಟ್ಟಿದ್ದಾರೆ?
workman's compensation ಕೊಟ್ಟಿದ್ದಾರೆ 2,76,000 as per order of the commissioner for workman's compensation, plus pension is given under pension scheme 1995. 800 rupees he is getting the pension despite provided with the casual employment, working, getting some 18,000 rupees.
Yes, madam. You want to verify?
Yes, ma'am.
Nale?
Yes.
Tomorrow in the fresh matters list.
Much.
Yes.
Bill number 19, Ravichandra.
Massive passover, my lord. Massive passover, my lord.
No passwords.
No, my lord. Senior is on his legs, my lordship.
Outcome of the judgment and ಮಾಡಿದ್ಯಲ್ಲ. ಏನ್ promotion to what post?
No, my lordship. Yesterday the matter was heard, my lordship.
Yesterday.
Howದು?
Was regarding
It is repeated today, my lordship.
Oh, this.
Hyderabad to
Non
general
Hyderabad.
quota, he could not have been.
KNK, non-KNK.
Please.
Yes.
Karnataka.
Yes, please.
Yes, sir. ನಿಮ್ದು ಆಗಿದೆ. ಹೇಳಿ.
Since we have filed an objection to that effect, but in so.
No judgment.
I will produce the judgment, my lordship. That.
ಯಾವ್ದು ಇಲ್ಲ. ಈ ಇಶ್ಯೂ ಎಲ್ಲಿ ಬರ್ದಿದ್ದಾರೆ?
ಇಲ್ಲ,
ನಾನು ಹೇಳಿದ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀನಿ.
ನೀವು ಹೇಳಿದ್ದು produce ಮಾಡಿ.
That we will do. Yes, post the matter for on
31st, my lord. Massive.
31st ಬೇಡ sir. Wait.
But ಇದು
Post the matter on 7th.
Please.
At 4 PM for dictating orders.
Please.
Yes. ಅದು ನೀವೇನ್ ಮಾಡಕ್ಕಲ್ಲ, ನಾನೇ ಮಾಡ್ಬೇಕು. Wait.
Please.
There is no precedent, sir.
There are no precedent, but analogy as regards to SC being continued, that is there, my lord.
ಏನಿದೆ?
That
Yes,
is-
gentlemen, it is
please.
ಬೇಕಾದಷ್ಟಿದೆ.
Please, but as regards this, my lord, chapter 5 of the rule says that how the seniority and subsequent allotment should be made.
Now, ಈಗ who is the employer here?
Employer is
Employer is
the
JESCOM.
JESCOM, my lord, but common notification,
So documents ಇಲ್ಲ appointment order ಇಲ್ಲ.
as it
Produce,
is
my
there, my lord. It is at annexure.
Annexure.
Appointment order ಏನ್ condition ಇದೆ?
It is subject to the Hyderabad Karnataka rules and regulations amended from time to time.
2013
ಅಂತ
order.
ಇದೆ.
ಆಯ್ತಾ?
point number 7 ಅಲ್ಲಿ ಇದೆ.
ಹೌದಾ?
Please.
ಇದೆ. Now, he is appointed, he has claimed 371J.
Please.
On merit, he goes to the top.
Please.
Did you, has he given up his right saying that he is not going to claim 371J?
No, my lords.
That has not been, my lords, in the notification, but my lords,
In the appointment order, have you indicated that he is not going to get 371J?
not exactly, my lords, not
13,
exactly.
there was an option to choose till 13, 14, but post that, since in the application itself, he ticked that he wants to claim Hyderabad, Karnataka. But because of the 2016 circular, we says that if the candidate is meritorious, he has to be adjusted towards the residual quota rather than local cadre. So because of that, the circular dated 16/11/2016, yeah, because of his merit, he was placed upon in the
Does he lose his status?
judicially.
Reservation of SC, ST is caste based.
Please,
It is by birth.
please,
Reservation under 371J is a domicile reservation.
please.
So unless he continues to be from that place, he will not lose that reservation.
Lose that.
So just because he's meritorious and is sent to non-Hyderabad, Karnataka cadre of the appointee, does not mean that he will lose his domicile.
Only one submission, as my friend said, my lord, 16, 17, after is when we give him the list.
Adanna, whether it
delay, my lords.
amounts to acquiescence.
That's the only.
There is no estoppel against statutes.
My lordship, after the probation was declared, my lordship, on
ನೀವು ಅದೆಲ್ಲ ಹೇಳ್ಬೇಡಿ ಸುಮ್ಮನೆ.
21 ಅಲ್ಲಿ
ಸುಮ್ಮನೆ ಇದ್ದೆ ಅಂದ್ರೆ ಆಗಲ್ಲ.
One more to just, my lord, when this particular list which is prepared for the promotion also, it is based upon the roster point. So if he is able to fit in that, the other 4 persons are as per roster, they are a little bit higher. That's the only.
What solution will see?
Please, please.
Because there is no precedent in this.
please.
And we may permit to submit on that day if something is.
Lord.
Please.
I will file the judgment in the counter, my lords.
Well,
Which
I will do.
Please.
20 SN Rajendra, Gurudev Gachinma.
Lord, petitioner has got, my lord, benefit of, my
Requested
lord,
for
15
4th of
years time
February.
bond scale. Benefit, my lord, in the year 1994, my lord. In lieu of, my lord, he is not getting the promotion for continuously for 15 years. As per the rules of
ಆಯ್ತು
1994.
ಇಲ್ಲೇನೋ ಆರ್ಡರ್ ಮಾಡಿದಾರಲ್ಲ ಈಗ
How?
3 ವರ್ಷ ಕೊಡಂಗಿಲ್ಲ ಅಂತ.
ಅಲ್ಲ, with respect to the withdrawal, ಅವರು ಏನ್ ಚಾಲೆಂಜ್ ಮಾಡಿದಾರೆ, we have sought ಇದು ರಿವೈಸ್ ಪೇ ಸ್ಕೇಲ್, my lords.
ವಿಡ್ರಾ ಮಾಡಿದ್ದೀರಾ?
ಅಲ್ಲ, I have sought for the instructions from the authorities.
ರಿಕವರ್ ಮಾಡ್ತಾ ಇದಾರೆ ಈಗ?
My lord, in the connected writ petition, my lord, he said that, they said that, my lord, on 11/7/2012, on the basis of which, my lord, the 15 years time bond scale was withdrawn. That, my lord, the order itself, my lord, they have withdrawn in connected writ petition, my lord. This is the order.
List on 7th, yes.
Please, great.
Cell number 21 MS Harvey.
Petitioner is a retired assistant teacher of the third respond high school, my lord. During the service, my lord, certain allegations were made against the, my lord, petitioner, alleging that, my lord, the petitioner failed to complete the syllabus of the 8th and 9th standard, my lord, during the year 2014 and 15. Based on that allegations, my lord,
Jurisdiction ಇಲ್ಲ ಅಂತ ಇದೆ.
jurisdiction, they have imposed the punishment of compulsory retirement, my lord. Challenging that, I have filed appeal before the appellate authority.
Problem is judgments ಕೊಡಿ.
In the last
Time ಆಗ್ತಾ ಇಲ್ಲ, not ಕೊಡಿ.
Please.
7, division में judgment. Events.
ಯಾವ್ದು MS ರಾಮಯ್ಯ?
No, no.
MS Ramaya was the main case, your lordship, wherein that very point has, please.
4 postulates are laid down.
Please.
Yes, four postulates. When the punishment is in punitive in nature, that is to victimize the employee, your lordship.
That I know, that is subsequently interpreted also.
Please.
We'll see. Again, 7th ಗೆ ಹಾಕಿ ಮಾಡಿ.
Please.
There are 2 other judgments.
Since retired, my lord, he is a retired
Since,
teacher.
So what?
Well, since both concurrently held that, my lord.
We have shown him mercy or to punishment of compulsory retirement.
If it is an order without jurisdiction, it goes, we'll see. Yes.
But they have taken a state contention before the appellate authority in the beginning itself. Appellate authority held that the appeal is maintainable. Challenging that, they have not filed any appeal.
Observation has not
Finally,
been
my
made
lord,
in
the order has been passed.
22 Srikanti Patil.
7th, my lord.
KL Patil.
Notice ಆಗಿಲ್ವಾ?
KL Patil sir is appearing for Ms. R4.
Yes, list on 11th, next.
23 Anand L. Sandrimani.
My lord. My lord, for submission, my lord. Serial number 22. Password, my lord.
11th, yes.
Password, my lord. Request, my lord.
11th, sir.
Yes.
It is mandate matter not. This honorable court has,
Division bench. Where is the order of remand?
Annexure H, my lord. The respondent has been directed to conduct a fresh inquiry.
No, I had passed an order. What happened to this?
But subsequently, without conducting the inquiry, the impugn order will pass at annexure. Impugn order at annexure M, my lord, by the Taluka Panchayat Executive Officer, which is no jurisdiction, my lord.
What happened to this order, sir?
This order has been implemented fresh to conduct the inquiry. But they are not conducting the inquiry without considering my reply and pass this impugn order.
Yes, who is, ಯಾರಿಗೆ ಹೇಳಿದ್ದದು?
Taluka Panchayat.
Respondents are directed to furnish the report to the Lokayukta. What is the impugn order now?
Impugn order annex M, my lord.
Next page?
Page
89.
18, my lord.
ತಾಲೂಕಾ ಪಂಚಾಯತ್.
First time ಬರ್ತಾ ಇರೋದಾ?
Please.
First,
Learned AGA is directed to
R1. R1.
accept notice for the first respondent. 1, 2 and 3 emergent notice returnable by the 18th.
impugn order, because the dismissal, my lord.
You are working?
No, now I'm dismissed from this as per this order, my lord.
Correct. Interim order ಬೇಕಾ?
Interim.
ಏನು? Reinstatement.
Because this honorable court has already directed to the respondent to consider the earlier order, and as per this order, I have been in service, my lord.
ಒಂದೇ ನಿಮಿಷ. ಈಗ earlier order reinstatement ಹೇಳಿದ್ನ?
ಮಾಡಿದ್ದಾರೆ ಸರ್, ನಾನು ಮಾಡಿದ್ರು ಮತ್ತೆ
Reinstatement
ಮಾಡಿದ್ರು
ಮಾಡಿ ಮತ್ತೆ terminate
ಮತ್ತೆ ಕಂಪ್ಲೇಂಟ್ ಕನ್ಫರ್ಮ್ ಮಾಡಿ.
ಯಾವಾಗ terminate ಮಾಡಿದ್ರಿ?
As per next, sir.
Date, sir.
Please.
Date, sir.
Please, my lord. 10/6, my lord.
10/6 of which
24,
year,
my
sir?
lord. 10/6/24, my lord. Next, sir. M. Sorry.
6 ತಿಂಗಳ ಹಿಂದೆ ಆಗಿರೋ ಟರ್ಮಿನೇಷನ್ ಇವತ್ತು ಸ್ಟೇ ಮಾಡ್ಬೇಕಾ ನಾನು?
Because
ಸ್ಟೇ ಮಾಡ್ಬೇಕು. Yes, emergent notice returnable by the 18th.
this.
Final order of termination.
This.
24 DJ Nayak.
Mandamus, my lord. Yes, the respondent number 1, my lord.
Only the annexure G that was replied on 1990, my lord.
1990?
He was misplaced in the duty, my lords. That was not founded.
Misplaced an item.
Sorry. Sorry, my lords.
It is not material, sir, to say misplaced and missing ಅಂತ ಹೇಳಿ.
Missing, please, sir. Adರಲ್ಲಿ annexure G, page number 19, my lords. 20. So the central government has directed him to give one more representation by giving all details, my lords.
She is 90 years already.
ಹೌದು, 26/9/90ಕ್ಕೆ. ಅದಾದ್ಮೇಲೆ ಇಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
My lord, she is living alone.
ಅಲ್ಲ, ಅದಕ್ಕೆ ಏನ್ ಮಾಡ್ಬೇಕು ಗೊತ್ತಾಗಿಲ್ವಾ?
ಇಲ್ಲ, ಏನು ಗೊತ್ತಿಲ್ಲ ಅವ್ರಿಗೆ. She is illiterate, man.
ಆಯ್ತಾ?
Petitioner is before this court seeking the following prayer. The petitioner, ಇಬ್ರಿದಾರ?
1 and 2.
Yes.
The first petitioner is the wife of one, Keshav Majlikar, and is now 90 years old. The second petitioner is the daughter, both of whom are before this court seeking the following prayer, aforequoted prayer. It is the case of the first petitioner that her husband, ಯಾವಾಗ missing,
1990, man.
who was working in the army, ಏನಿದು?
Army, man.
Who was working in the army, goes missing in the year 1990. 32 years thereafter, on realizing that the husband will not come back, submits a representation for grant of pension to the family from the date the husband went missing till today. That having not been considered is what has driven the petitioners to this court in the subject petition. The learned counsel, learned DSGI, Venkatesh Kharvi, would on instructions submit that if a fresh representation is submitted with all the details, the respondent would pass necessary orders in accordance with law. The submission is placed on record. In that light is also the fact that the first petitioner is already 90 years old. I deem it appropriate to direct the respondents to pass necessary orders on the representation. 90 years old, I direct the petitioners to submit a representation within 2 weeks from today. And if the representation is submitted, appropriate orders would be passed within 6 weeks thereafter. It is made clear that the claim of the petitioner is not assessed in the case at hand, ordered accordingly.
25 K. Anand Kumar, Mallikarjun S. Kriyaman.
In this case, my lord, the institution has already submitted, my lord, pension papers to the second respondent, my lord, on 12/12/24. I have produced a memo also, my lord.
Forward ಮಾಡಿದೀರಾ?
ಕೊಟ್ಟಿದ್ದೀವಿ ಸರ್ ಅವರಿಗೆ ಕೊಟ್ಟು.
ನಿಮಗಲ್ಲ.
ಅಲ್ಲ, second respondent
ಮಾಡಿದೀರಾ?
Yes, my lord. I have produced the acknowledgement also, along with memo, my lord, on 25, my lord.
10/12/24 ಗೆ.
12/12 ಗೆ ಇದು ಆಗಿದೆ ಸ್ವಾಮಿ, received by the second respondent in the office.
ಯಾವಾಗ?
I'll get instructions from the ಗೊತ್ತಿಲ್ಲ. They are not served the copy also.
ಯಾರಿಗೆ?
ಗವರ್ಮೆಂಟ್ ಗೂ ಸರ್ ಮಾಡಿದ್ದೀನಿ ಸರ್.
ಗವರ್ಮೆಂಟ್ ಗೆ
Please.
ಕಳಿಸಿ 10/12/24 ಆಗಿದೆ. ಯಾವಾಗ ರಿಲೀಸ್ ಮಾಡ್ತೀರಾ ಪೆನ್ಷನ್?
Next week, any date?
First part of it ಆಮೇಲೆ ನೋಡ್ತೀನಿ. But ಇಲ್ಲರ from your pocket costs ಯಾವತ್ತು?
Next week, any date?
List the matter on 7th.
Please.
The learned counsel appearing for the institute
3 and 4.
3 and 4 has filed a memo depicting transmission of all necessary documents for the purpose of payment of pension to the petitioner on 10/12/2024. Despite that, no pension is paid to the petitioner. He has retired on 31/5/2024. Therefore, the learned AGA submits that if a week's time is granted, necessary action would be taken and reported to the court. List on 7th in the fresh matters list.
Please, please.
Number 26 Ravi Hegde, Prashant Usmani.
Kindly have it, my lord, after 2 weeks.
My lord's matter was heard. And this is, my lords, regarding the punishment was imposed without conducting inquiry on the ground that it's a minor punishment that was imposed. Can't be. Therefore, my lords, let there be.
ಇವಾಗ ಟಿಪಿಸಿ ಆಗಿದೆ ಅಂತ ಒಂದ್ 2 ವಾರ ಬಿಟ್ಟು ಹಾಕೊಳ್ಳಿ, ನಾನು ಪರ್ಸ್ಯೂ ಮಾಡ್ಬೇಕು. ಟಿಪಿಸಿ ಆಗಿದೆ.
Withdraw ಮಾಡ್ತೀರಾ?
ಅಲ್ಲ, ಅವ್ರು ಕರೆದಿದಾರಂತ ಈಗ ಏನ್ ರಿಸಲ್ಟ್ ನೋಡ್ಕೊಳ್ಳಿ.
As far as, my lords, the other petition is concerned, wherein, my lords, that punishment order is challenged. Lord, that may be sent back. We quash it, sent back, and we will, my lords, conduct an inquiry.
Sent back ಅಂದ್ರೆ promotion.
ಕೊಡಲ್ಲ. That is the reason.
No, my lord, what happens, my lords, there is already a charge sheet now, my lords, pending.
We'll send it back after 2 weeks. Sent back ಅಂದ ತಕ್ಷಣ ಅದೇ ಸಾಕು. Court has directed hold an inquiry. So TPC sealed cover. Yes. ಅದಕ್ಕೆ list the matter on 18th February.
There are interim orders, my lord.
Interim order subsisting will continue to the next date of hearing. Yes, next.
27
25 ದಲ್ಲಿ it seems that the government has forwarded, now forward ಮಾಡಿದ್ದಾರೆ.
ಯಾರಿಗೆ?
ಅಕೌಂಟ್ ಜನರಲ್ ಫಾರ್ವರ್ಡ್ ಮಾಡಿದ್ದಾರೆ.
ಆಯ್ತು, next week.
Please.
7th ಹೇಳಿ.
Please.
Retired teachers ತೊಂದರೆ ಕೊಡಬೇಡಿ. Yes.
27 H. N. Godareddy.
Claim of compassionate appointment is rejected, my lord.
Very compassionate appointment.
Yes, my lord. Impugned order is at page number 33, my lord.
Library supervisor.
Yes, my lord. On the ground that, my lord, no rules were existing at the time of death of Jilla Panchayat.
ಯಾರದು? ನೋಟಿಸ್ ಆಗಿಲ್ವಾ?
Notice ಆಗಿದೆ, served, my lord.
ಯಾವತ್ತು ಸರ್ವ್ ಆಗಿದೆ ಮೇಡಮ್? ಈ ಫೈಲ್
R4. Estimate is appearing for.
December 10th. One opportunity ಕೊಡೋಣ.
Please.
List the matter on 12th February. Well, ತುಂಬಾ ಆಗಿದೆ. 11th February.
Number
The
28,
interim order,
which party?
interim
Order
order.
subsisting will continue till next week.
Kindly permit me to withdraw the writ petition.
Huh?
Kindly permit me to withdraw the writ
Thank
petition.
you,
They
sir.
have come
It has
back.
been, my lords,
It's registered.
Learned
Registered.
counsel for the petitioner seeks leave of the court to withdraw the petition on account of his grievance being redressed. Yes.
Applied.
In the light of said submission, disposed as withdrawn. Next.
Number 29, Harisha S. Naik.
Lords, 29, I represent the petitioner's counsel. Lord, this is a case where the recruitment process had begun after taking approvals and permissions. Lords, after issuing the public notice and calling for interviews, the government issues an impugned order at Annexure G, my lords, at page 53, changing the procedure. Annexure G at page 53, my lords.
What's the change?
Lords, what they do is, my lords, the criteria for calling for interviews is fixed at ratio of 1:5, which your lordships would get at page 54.
What was the earlier thing? 1:10?
Lords, all of them were to be called. That's a UGC regulation also, my lords, of 2018. And also the marks they change. Please see 3, my lords, serial number 3.
Where is your notification?
Lords, the paper publication, my lords, calling recruitment is at page 25.
Date, sir.
Lords, that is on 8/2/2023, 8th of February 2023. And my lords, nominating Karnataka University nominating subject experts was on 4/3/23.
Heard the learned senior counsel Ken Panindra appearing for Adit Chandan Gowda. The challenge is to a government order dated
53, page 53, my lords, 28/3/2023.
28/3/2023.
And also, it's also, my lords, amended subsequently on 7/12/23, which your lordships would get at page 74.
And a subsequent amendment on 7/12/2023. It transpires that the petitioner society, which runs the college, had called for applications by a paper publication on 8/2/2023. Interview agidya?
Interview letters had been sent. We have finished our interviews.
And the committee was constituted to interview, and and interview also is said to be over. After the issuance of the notification / paper publication comes the impugned government order, and after the interview and all the process being over, the subsequent government order. It is by now too well settled principle of law that rules of the game cannot be changed once the game has commenced, which would be that the criteria for selection could not be changed once the notification for selection was issued and the selection process is midway. No doubt the state is not the one who has issued any notification for appointment, but it is an aided institution following the rules of the government. The rules that were in existence is what would govern the notification that was issued prior to the amendment to the rules or otherwise. Therefore, there shall be an interim order of stay as prayed for. 1 AGA, 2
All state.
Ella state, learned
Ella
AGA
state.
accepts notice for all the respondents, lists the matter on 14th February in fresh matters list. Objections, if any, by then. Either lane objection. The constitution bench ಹೇಳಿದೆ. You
Please.
can't.
Tej Prakash, which? Tej Prakash.
So I have not got it. I'll
What?
get it. Tej Prakash, I'll get it.
Tej Prakash.
Tej Prakash.
Yes, I know. Yes. It is only reiterating Manjula.
Manjula.
Yes.
Great.
Number 30, Sanjay's category, Raviraj parties.
Your lordships, there is one more matter, your lordships, pertaining to the same order, your lordships. Same order has been challenged.
ಏನಾಯ್ತು?
Same mutation entry has been challenged.
ಇನ್ನೊಂದಿದೆಯಾ? ನೀವು ಅದಕ್ಕೆ ಮೆಮೊ ಕೊಡ್ಬೇಕು, ಸ್ಲಿಪ್ ಕೊಡೋದು ನಿಲ್ಸಿ ಕೋರ್ಟ್ ಅಲ್ಲಿ. ಎಸ್, ಸ್ಲಿಪ್ ಚೀಟಿ ಎಲ್ಲ ಆಗ
ಫಾರ್ ಪೋಸ್ಟಿಂಗ್ ಅಂದ್ರೆ ಮೆಮೊ ಕೊಡ್ಬೋದಿತ್ತು, ಅದು ಕನೆಕ್ಟ್ ಮಾಡಿ ಅಂತ.
ಕನೆಕ್ಟಿಂಗ್ ಮೆಮೊ ಕೊಡೋದು ಬೇಡ.
ಸಾರಿ,
ಅದಕ್ಕೆ ಏನೇನೋ
ಸಾರಿ my lord.
ತಗೊಳ್ಳಿ. Tag along with so and so. We'll list them on 7th.
Please.
List on 7th.
Your Lordship, entry model may kindly be.
Entry model subsisting will continue to the next date of hearing.
Jay Shetty.
ಏನ್ ಟೆಂಡರ್ ಶೆಟ್ಟರೆ?
Tender, my lord, in fact, after the last date, my lord, fixed for the tender notification, my lord, after submission of the tender, they, my lord, change the tender conditions.
ಈಗ ತಾನೇ ಹೇಳಿದ್ನಲ್ಲ, changing the rules of the game after the game.
After the game starts. And that's why, my lord, the representation was made.
Too
And-
well settled the law.
And now, my lord, they are saying.
And section 14 prakara, if you want to bring in a change, you'll have to notify everybody with regard to that change.
Getting objections, my lord, they have to.
ಇಷ್ಟೇ ಇದೆಯಾ?
Stayed. In fact, my lord, the representation was made. Because, my lord, even changed condition, my lord, I may be allowed to, my lord, submit the document, and document have been submitted.
ಮಾಡಿದ್ರಾ?
ಅದನ್ನು ಕನ್ಸಿಡರ್ ಮಾಡಿಲ್ಲ. They want to, my lord, now give it to some other person by
Yes.
lottery ಅಂತಾರೆ.
List the matter on 7th in the fresh matters list. Illi, where is the subsequent order passed?
Annexure, my lord, the annexure B as well as, my lord, annexure G.
ಇದೆಯಾ? Then don't, till next date, don't allot it to anybody
And-
else. Status quo quo, the tender be maintained till the next date of hearing, 7th in the fresh matters list.
Yes.
Number 32 VG Bhatt.
The petitioners retired employees of the Karnataka University.
The
In their
Karnataka
1997, as per the
University,
improper committee report, their pay scale has been fixed. Now it has been retired, revised.
University ಯಾರು appear ಆಗ್ತಾರೆ?
KL Patil.
Lieutenant Counsel KL Patil is directed to accept notice for response 2 and 3, AGA 1. Yes.
In the connected matters, not to precipitate order has been passed.
Tag this petition along with so and so. The respondents are restrained from precipitating the matter during the pendency of the petition. Yes. Next.
Bill number 33, Halima Begum.
ಇರೋಲ್ಲ.
Parole, my lord, it is not fit case, my POCSO. ಅದೇ ನಿನ್ನೆ ತಾವು ಎಮರ್ಜೆನ್ಸಿ ಪರೋಲ್ ಕೊಟ್ಟಿದ್ರು, ಅದೇ ಸೇಮ್ ಕ್ರೈಮ್. ಇಟ್ಸ್ ನಾಟ್ ಫಿಟ್, my lords, as per the
ಇದು ಎಮರ್ಜೆನ್ಸಿ
ಅಲ್ಲ ಅಪ್ಲಿಕೇಶನ್ ಇಲ್ಲ ರೆಗ್ಯುಲರ್.
ಅದು ಎಮರ್ಜೆನ್ಸಿ ಪರೋಲ್ 55, ಇದು ಎಕ್ಸ್ಟರ್ನ್ಮೆಂಟ್ ಇದ್ದಂಗಿದೆ, ಸೆಕ್ಷನ್ 55 ಅಂತ ಹೇಳಿ. ಇಲ್ಲ ಇಲ್ಲ.
ಆಗ್ಬೇಕು.
Yes, list the matter on Monday, 4th guys, in the fresh matters list. Next.
34, Assistant
4th alla,
Warden.
5th, sorry.
This is case, my lord, wherein, without holding inquiry, my lords, the petitioner is, my lords, dismissed from the service. Lords, I have, my
Yes,
lords,
government.
2 judgments which I have, my lords.
But who has to answer?
My lords, government.
Please. I don't have file, my lords.
ಅವರು ಇನ್ನೊಬ್ರು ಇಲ್ಲ. List on 31st in the fresh
Please.
matters list. Day after
Please.
tomorrow.
Please.
35, PG Chignargu. Geeta Kayal.
Sought for direction to consider the representation, lordship.
Who
I
has to
appear for the
consider?
respondent.
Respondents, your lordship.
In this case, I appear for the
Consider
respondent.
ಮಾಡ್ತೀರಾ?
Alla, if it is a request is irrelevant and not considered, he is nowhere concerned. He says he is a member, but he is not participating active
File
party.
your objections.
I'll file an objection.
Lieutenant Counsel for the respondent seeks 2 weeks time to.
But my
Geeta
petition
KM
member of the, not the bank, your lordship.
seeks 2 weeks time to.
Please, much.
File objections to the, can I say don't file objections?
Let them file, let them file.
Objections to the petition. List after 2 weeks.
Much.
Next.
36, Kishan G.
Lord, I am permitted to appear through VC, my lord. Lord, this is a petition filed seeking writ of mandamus or direction to the respondent authorities to consider the representation, my lord.
Redesign.
Yes, my lord.
ನಿಮ್
My lord,
ಮನೆ
in
ಪ್ರಕಾರ
fact,
ಮಾಡ್ಬೇಕಾ ಸರ್?
no, my lord. In fact, previously this was a state highway, my lord. Now they have proposed to convert this to a national highway. If this is
Not
converted into
village
national
convert.
highway,
Yes. NHAI ಗೆ ಯಾರು appear ಆಗ್ತಾರೆ ಇಲ್ಲಿ? National Highway Authorities friendly.
ಶಿವರಾಜ್ ಬದೂರಿ.
Bulluli. Learned Counsel Shivraj Bulluli is directed to accept notice for respondents 2 to 4. Learned MB Kanvi, Senior CGS, is directed to accept notice for the first respondent. Petitioner to serve set of papers upon the aforesaid counsel forthwith. List the matter on 6th in the fresh matters list.
Lord,
Yes.
emergent notice to respond number 5, my lord, is it? Respond number 5 is also there, my lord, private respondent.
I respond number 5 be served by way of hand summons on Bharat, Amel 6th.
Lord, kindly pass over, my lord.
My lord, I am seeking for interim relief also, my lord, because this work,
interim order.
yes, my lord,
Oh,
because
petition,
this work,
petition, one ನಿಮಿಷ ಕಿಶನ್, petition ಇವತ್ತೇ ವಜಾ ಮಾಡಬೇಕಾಗಿತ್ತು, interim order ಕೇಳ್ತಾ ಇದ್ದಾರೆ. Yes. Next.
37.
Lord, 37, 38, kindly pass over, my lord.
List on 11th, yes.
Lord, interim order, my lord.
Interim order subsisting will continue.
Please, Lord, 17th. Lord, it may-
Pass over ಕೇಳಿದ್ಯಾರು? 17.
Or passer kartar. This is my lord, registration of the new society. Lord, 3 judgment.
Fees da. A share fee, what is?
Yes, yes, my lord. Share collection of share amount.
Collection of share.
And it was done. Then subsequently registration was also issued. New society is.
Pass over, pass.
Please.
Number 39, Joshna P.
Please, my lord. Petitioner is seeking direction to the respondent to not to insist the petitioner to obtain the license, my lord.
Not to us. What license?
Recreation club.
Recreation club, my lord. Sorry.
ಎಲ್ಲಿ?
Please, my lords.
Judgment ಎಲ್ಲಿ?
Annexure C and D, my lords.
C and?
D, my lords. Page number 24.
C and D. ಕವಿತಾ ಮೇಡಮ್. C and D. ನಿನ್ನೆ ಒಂದು ಆರ್ಡರ್.
Number 40, KD Nagar.
I'll get instruction, rowdy sheeter, I'll get instructions from us whether on any other
Kannada
cases.
AGA is directed to accept notice for the, ಆಗಿದೆಯಲ್ಲ? Notice for the respondents, list on 7th in the fresh matters.
41, Nilendra D. Gunde.
Please. Nilendra.
Section 55 lords of Karnataka Police.
Externment.
Externment.
NDPS.
NDPS.
Lords, 2 cases, lords, is the court permit for 2, lords, in both the cases, lords, what they say.
Anyway, opportunity is given to you to appear and.
Lords, I have appeared, lords.
No, the report against, you want to see the report?
Report is not.
The report is that you are distributing ganja in the schools. How can you be kept there? ನೀವೇ ಹೇಳಿ.
Lords, I do, lords, for a moment, my lords, may bear.
School ಮಕ್ಕಳಿಗೆ ಆಗ.
For a moment, bear me for 2 minutes, interesting.
The
in
menace
both the
of
cases.
narcotics should stop. Particularly, this is,
I do,
you are fit to be externed.
In both the cases, 205 grams of ganja te ತೋರಿಸ್ತಾರೆ.
That is in possession, but the allegation report against you is this. With this report, can I say I don't believe the police report?
I do understand.
Lord, ಮಾಡಿದ್ದಾರೆ ಈಗ.
6 months, lords, the punishment prescribed in NDPS Act itself is 6 months, lords, maximum.
Consumption gado. You are not allowed to
205
consumption,
grams,
sir. Consumption is 6 months imprisonment.
How?
Your conspiracy there. Distribution, it's 10 years.
ಮಿಕ್ಕಿದವ್ರು lords, ಯಾರು ತೋರಿಸಿಲ್ಲ, my lords, may kindly see 2 cases, lords, they register. In both the cases, lords, same quantity of ganja is alleged to have been, lords, recovered.
Not a case. And ನಿಮ್ ನೋಟಿಸ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂದ್ರೆ ಅಥವಾ ಹಿಯರ್
Notice is given, it is not accompanied, my lords, by the report, lords, of the inspector. One is, my lords, of the year, my lords, that is crime number 1/2024 and 26/2023.
Second matter,
My
there are
lords, may
another.
kindly see both the orders in both the, my lords, petitions.
ಗಾಂಜಾ ಅನ್ನು ಮಾರಾಟ ಮಾಡುತ್ತಾ ಮುಗ್ಧ ಜನರಿಗೆ, ಯುವಕರಿಗೆ ಮತ್ತು ವಿದ್ಯಾರ್ಥಿಗಳಿಗೆ ಗಾಂಜಾ ಸೇವನೆ ಅಂತ ಪ್ರಚೋದಿಸುತ್ತಾ ಬಂದೆ ನಿಮಗೆ ಯಾವುದೇ ಕಾನೂನು ಭಯವಿಲ್ಲದೆ ರಾಜಾರೋಷವಾಗಿ ಪ್ರತಿಷ್ಠಿತ ಏಕೈಕ ವ್ಯಕ್ತಿ NDPS. I will not say.
If both the petitions are looked into for, my lords, they are cyclostyle copies, my lords.
ಎಲ್ಲದರಲ್ಲೂ ಹಂಗೇನೆ.
Same, my lords, except para number 2.
Some other offense.
Except para 2, my lords, everything is, my lords, same. Even my lords are aware, my lords, in many cases, my lords, it is totally cyclostyle copy except, my lords, cost title. Even the quantity
This
of.
case, my lords,
Report ಕೊಡಕ್ಕೆ
ಮಾಡಬೇಕಾಗಿತ್ತು.
ಕಾನೂನು ಪ್ರಕಾರ that circular is also issued. Now this officer will be held responsible for quashing the order.
But my lords, so far these cases are concerned, my lords, as they are the
No,
biggest
I'm
college
aware.
students, my lords.
Even my lord, statement of any of the college student is also not forthcoming, my lords, for having.
Externment ಅದೆಲ್ಲ evidence
My lords, I do admit, my lords, report
Externment, you
the
don't need detailed evidence.
my lords are much aware, my lords,
inquiry
how.
to be conducted. Apprehension is enough.
My lords, I do admit, my lords, but my lords, the order copies in both the petitions source, except cost title.
ಎಲ್ಲಿ ಕಳಿಸಿದ್ದಾರೆ ಈಗ?
My lords, I have been sent, my lords, to, my lords, Bidar, Humnabad, my lords. Livelihood to Barola, my lords.
Okay. Livelihood problem. ಅಲ್ಲಿ ಗಾಂಜಾ
Driver.
distribute
Auto
ಮಾಡಕ್ಕಾಗಲ್ವಾ?
driver by profession, my lords. Everything has to be borne, my lords, by the
We'll
father
see.
who is.
ಆಯ್ತು
cook, my
ಅಂದ್ರೆ
lords.
ಲಿಸ್ಟ್ ಆನ್ 7th ಅವತ್ತೇ ಆರ್ಡರ್ ಮಾಡ ಸ್ವಲ್ಪ ದಿನ ಇರ್ಲಿ ಬಿದರ್.
42 Nitendra T.
Similar, my lords, ಅಲ್ಲಿ ಕೂಡ same
ಎರಡು
quantity,
same both.
same orders.
No.
My lords, in the fresh matters, my lords,
Fresh.
7.
43 Hemant Kumar Elhavargi.
In fact, my lords, so far as chapters, my lords, in section 55.
Where? All right.
Please.
For the petitioner most.
NDPS is not the one that is enumerated there.
How?
But times have changed. That is 65 Police Act. Times have changed. This is what I want to write. Yes.
Tender matter, my lordship, without GST. My lordship. As per circular, as per annexure A, my lordship.
Lord, Lord, relief is not for quashing the tender notification. But based on annexure A, lordship kindly see.
What is the ground, sir?
Prima facie,
Please,
Lord,
Lordship.
at the outset, Lord, whether a grievance is sustainable or not, Lord, I think
Why?
the reason is, Lord, he is seeking to quash, Lord, the tender notification on the assumption that, Lord, annexure A, lordship kindly, based on annexure A, circular issued by the government.
9/8/2024.
My Lord,
9/8/2024.
exactly.
Yes.
This one is, my Lord, the tender notifications sought to be quashed, my Lord, is in respect of service, my Lord, shipped and maintenance. And the annexure A refers to, my Lord, your lordship kindly see, my Lord, GST ಅನ್ನು ಹೊರತುಪಡಿಸಿ ಕಾಮಗಾರಿ ಟೆಂಡರ್ ಅನ್ನು ವರ್ಕ್ಸ್ ಟೆಂಡರ್ಸ್
ವರ್ಕ್ಸ್ ಕಾಂಟ್ರಾಕ್ಟ್ ನಿಮ್ದೇನು
ಇವ್ರದ್ದು ಸರ್ವಿಸ್ ಶಿಫ್ಟ್ ಅಂಡ್ ಸರ್ವಿಸ್
ಅದೊಂದೇ ಗ್ರೌಂಡ್
ಪ್ಲೀಸ್ ಅಂದ್ರೆ AMD ಅಮೌಂಟ್ ಸ್ವಲ್ಪ ಹೈ ಆಗುತ್ತಂತ ಸೊ ಅದು ನಾಟ್ ಅದು GST ಇಸ್ ನಾಟ್ ರಿಫಂಡಬಲ್ ಅಮೌಂಟ್.
ಸರ್ವಿಸ್ ಕಾಂಟ್ರಾಕ್ಟ್ ವರ್ಕ್ಸ್ ಕಾಂಟ್ರಾಕ್ಟ್. ಎನಿಥಿಂಗ್ ಎಲ್ಸ್?
ಅದು ಒಂದೇ.
The petitioner is before this court calling in question notice inviting tender dated 4/11/2024 on a solitary score that payment of GST is exempted in terms of a circular dated 9/8/2024. Heard so and so. The respondent KPTCL. The respondent KPTCL issues a notice inviting tender for, where is it? Where is tender?
Lord, tender, my Lord, annexure.
Paper
Annexure B and C, my Lord. C is the, my Lord, service and ತೋರಿಸ್ತಾ ಇದೆ.
Service of what?
Shift and maintenance. Shift and maintenance.
The issues a notice inviting tender calling for applications from eligible tenderers for the purpose of servicing shift
and maintenance of substations.
Servicing and maintenance of
substations.
Swift stations.
Substations.
Substations. The contention of the petitioner is that to participate in the tender, what is indicated in the notice inviting tender is that GST should be made. GST should be paid. It is his contention that GST is not applicable to all service tenders in terms of the notification in the circular dated 9/8/2024. The circular reads as follows, page 10 and 11. The circular is unequivocal that in tenders of the state or instrumentalities of the state, wherever it is for the purpose of works contract, no GST.
Lord, GST, Lord, one clarification, Lord. Lord, may I read once again the heading, Lord? GST ಅನ್ನು ಹೊರತುಪಡಿಸಿ exclusion of, Lord, while calling, Lord. They are liable to pay it, Lord, but the exclusion.
In so far as works contract is concerned, excluding GST, the tender notification should be issued. The subject tender in the case at hand is admittedly not a works contract, but a tender notification issued for the purpose of Servicing,
shift and maintenance.
shift and maintenance of substations. Therefore, it is admittedly a service contract. The circular would not come to the aid of the petitioner as it deals with works contract. In that light, there is no merit in what the petitioner seeks to project in the case at hand. Petition being devoid of merit stands disposed.
Placed.
Nagbhushan R. Girish S. Fulmani.
11th. Could you office objections and first time? List the matter on 11th. Interim order subsisting will continue till the next date of hearing.
45 MS Harvi Prashant S. Vasmani.
Disability Act covered.
Covered.
Certificate issued under the PAR number 3, not under the PAR number. It's covered, ma'am.
Again covered. What covered, madam?
Your Lordship, Justice Kamal judgment.
Ah,
Lighter duty.
Lighter job. The petitioner is before this court seeking the following prayer. In identical circumstances, this court has, following the judgment rendered by the coordinate bench, held as follows. The learned counsel appearing for the respondent would not dispute what is held by this court, quoted supra. In that light, petition deserves to succeed with the same relief, same equity, madam. We shall. Yes.
Directed to provide job to continue the. Please.
46 Shivraj Sibalaki.
Please, my lords. My lords, I appear for the petitioners in this matter. My lords, it's a challenge to an order demanding differential GST on royalty paid to the government for excavation of the limestone under the mining lease.
Yes,
Similar
sir.
matters already there are orders, my lords, and the entire demand is based on a circular of October 21. It says that the amendment is retrospective.
Which are the similar orders, sir?
Well, the learned friend is doing compilation at page 25 of this compilation.
25.
Yes, but the reference is given in my synopsis at page 5. In my case, in fact, I have paid 12% GST. That they are demanding differential at 18%.
Yes.
6% differential.
Girish Ulimani, who appears?
Shivraj Balloli.
One day. Shivraj Balloli, Union of India.
Union and central tax, GST also.
CBSE. Learned counsel Shivraj Balloli accepts, is directed to accept notice for the respondents. Petitioner to serve requisite set of papers upon the counsel. The, what's his name?
Ravi Raghavan.
So and so, appearing for the petitioner would take this quote of the documents appended to the petition as also identical orders passed, identical orders of stay granted by different courts. Therefore, there shall be an interim order of stay as prayed for till the next date of hearing. List the matter on 17th February, the fresh matters list. Objections, if any, by then. Yes, next.
Great.
Yes, sir. 47.
Election matter, madam.
Yeah, election. Nomination.
Nomination. In this case, what happened, my lord, they kindly see the annexure C, my lord. Annexure C.
This I am not going to stay, sir.
No.
You raised an election petition for the nomination judgment.
Annexure C, my lord.
Pass over. 2:30 will dispose it. Yes. Next.
48 Girish Vibhat.
First time, Allah.
The removal of the petitioner's name from the provisional list for appointment library supervisor.
Second provisional list.
Please.
So what?
May I take my lord to page number 22 for a moment of the petition. Page number 22.
Who has done it? Who has done it?
Jilla Panchayat. 23, the column number 10.
Reason ಏನು ಕೊಟ್ಟಿದ್ದಾರೆ?
I will come to it, my lord.
Page 23 is it?
Page number 23. The first provisional list, column number 10. Yes. Sanduru, Rajapura, Gram Panchayat.
ಏನ್ ಮೇಡಮ್ ಅದು?
And ಅದರಲ್ಲಿ ಇದು ಫೋರ್ತ್ ಕಾಲಮ್ ಅಲ್ಲಿ ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ ಹುದ್ದೆ ಖಾಲಿಯವರ ಗ್ರಾಮ ಪಂಚಾಯತಿ ನಿವಾಸಿ ಆಗಿದ್ದಾರೆ.
ವರ್ಕ್ ನಡೀತದೆ ನೀವು ಹೇಳ್ತೀರಿ. ಕೋರ್ಟ್ ನಡಿಬೇಕಾರೆ ಏನು?
The fourth column was ಅರ್ಜಿ ಸಲ್ಲಿಸುವವರು ನೀವು ಗ್ರಾಮ ಪಂಚಾಯತಿ ನಿವಾಸಿ ಆಗಿದ್ದಾರೆ. So against my name, answer is yes. So I am the resident of that village. Now may I take my lordship to the page number 27, the second provisional list. 27.
ಇದ್ರಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾರೆ?
ಇಲ್ಲ, the seventh respondent, column number 4. ಸದಸ್ಯರು ಸ್ಥಳೀಯ ನಿವಾಸಿ ಆಗಿದ್ದಾರೆ. ಇಲ್ಲ, no.
The petitioner is a participant in the recruitment process for the post of library supervisor at Rajapura Gram Panchayat. Pursuant to the selection process, the petitioner's name is found in the provisional select list, which depicts her to be from the same village. A second provisional select list is notified on 6/1/2025, which shows the petitioner is not a resident of the.
ನನ್ನ ಹೆಸರು ತೆಗೆದೇ ಬಿಟ್ರು.
Second provisional select list, the name of the petitioner is taken off and the name of the private respondent comes in on the ground that she is the resident of the said village, said Gram Panchayat. Seventh respondent, Gram Panchayat. In the light of the anomaly and no reasons coming forward for removing the name and adding the name of the seventh respondent, further proceedings shall remain state till the next date of hearing. 1 to 6.
1 and 6 government.
1 and 6.
1 and 6 government. 2, 3, 4 and 5 Shivraj Hiremat.
Gurraj Hiremat. Seventh respondent be served by way of hand summons.
Please.
Yes, list on 7th.
The similar matter is listed on first, my lords. One matter listed.
But I will take it on 7th.
Please.
Yes.
Please.
49,
Same, my lords.
Same order.
Same ಇದೆ. Column number ಅಷ್ಟೇ change.
50,
Same. Please, my lords. Grateful.
51, BC Gnanaya Swami.
The rowdy sheet are open against the petitioner. Your lordship, there is a civil dispute and case and counter case, my lord.
Current AGA is directed to accept notice for respondent 1, 2, 3, all respondents, to secure instructions and make his submissions. Rest on 7th.
52, BC Gnanaya Swami.
Dispose ಮಾಡುವುದಾ?
ತಮ್ಮದೇ ಜಜ್ಮೆಂಟ್.
ಡಿಸ್ಪೋಸಲ್ ತುಂಬಾ ಅರ್ಜೆನ್ಸಿ.
ಸಿವಿಲ್ ಸೂಟ್ ಪೆಂಡಿಂಗ್ ಐತೆ ಸ್ವಾಮಿ ಇಲ್ಲಿ ನಮ್ದ್ರಲ್ಲಿ.
3 cases pending ಅಂತ ಹೇಳಿ.
Anyway, in terms of this order, the petitioner is before this court seeking the following prayer. The heard so and so. And madam. Heard so and so. The learned counsel for the petitioner submits that in identical circumstances, this court has passed the following order. In the case at hand as well, what is pending against the petitioner are only civil suits. And there is no warrant to add the name of the petitioner in the list of rowdies. In the light of the learned AGA would also submit that identical orders.
3 criminal cases are pending ಅಂತ ಅವರು ಹೇಳಿದ್ದಾರೆ.
ಅದೇ ಕೇಸ್ ಅಂಡ್ ಕೌಂಟರ್ ಕೇಸ್ in respect of
civil suits and criminal cases.
Annexure, your lordship.
In that light, the petition stands disposed in the on the reasons rendered by this court supra and in the same with the same order. Same, yes.
51, 52, 55 and 106 family members na ಹಾಕಿದ್ದಾರೆ sir.
Oh, 51,
family members
52, 55
and 106.
106 ಬರ್ಕೊಂಬಿಡಿ madam, same order. Yes, next.
Selma 53, Basvarajaya.
And the petitioner is a contractor. Some of the tender works is awarded in favor of the contractor. And after completion of the work, he submitted the bills. But in the bills, as per the condition, they have to deduct the royalty amount along with the other taxes. Now, the third respondent, engineer, says that unless I produce the mineral dispatch permit, they have to deduct 5 times of the penalty of the royalty amount. But this is covered by the.
Annexure G, page 42, same order. Serial number 132 is same. Eradu tag madbudi. The learned AGA is directed to accept notice for respondent
One, my lord.
1, 2 and 3, KPTC alla.
Kamte, sir.
KPTCL ಇದ್ರಲ್ಲಿ.
BS Kamte.
Kamte, sir.
BS Kamte is directed to accept notice for respondents 2 and 3. Petitioner to serve set of papers upon the aforesaid council.
And 132 ದಲ್ಲಿ KNN ಅಲ್ಲಿದೆ.
132 ಅಲ್ಲಿ
KNN
ನಲ್ಲಿ ಯಾರ ಪೇರ್ ಆಗ್ತಾರೆ? ಎರಡು ಸೇಮ್ ಅಂತ ಹೆಂಗಂದ್ರಿ?
ಅಲ್ಲ ಸೇಮ್ ಅಂದ್ರೆ ಇದು ಪೆನಾಲ್ಟಿ ಹಾಕ್ತದ ಸೇಮ್, ರಾಯಲ್ಟಿ ಸೇಮ್.
ಟ್ಯಾಗ್ ಏನ್ ಮಾಡಬೇಡಿ. ಎಸ್ ನೆಕ್ಸ್ಟ್ 132 ಬರ್ಲಿ.
Before Anandar Kolli.
Petitioner was working as a technical assistant in the respondent number 2 and 3 authority. Without holding inquiry minutes, the petitioner dismissed from the service.
Directed to accept notice for the first respondent 1, 2, 3, 4, 5 emergent notice returnable by 20th, returnable by 21st February. Next.
For stay months.
Entry ಮಾಡಿ. ಅದು ಅಲ್ಲೋನೆ ಮಾಡೋಣ. Wait.
Please.
21st February.
Tender matter, your lordships. After completion of the work, the respondent number 1 has blacklisted the petitioner, your lordships, without even giving opportunity for
No
hearing,
notice?
your lordships. No notice was issued, your lordships.
Serial number?
56, your lordships. At Annexure J, your lordships.
The petitioner is before this court calling in question an order dated 5/12/2024 by which the petitioner is said to be the company. Firma ಏನಿದೆ?
ಇದು, your lordships.
The petitioner, a class 1 civil contractor, is sought to be blacklisted. The learned counsel for the petitioner submits that not even a notice is issued prior to the order of blacklisting. Solely on the said submission, there shall be an interim order of stay of the order dated 5/12/2024. The ಯಾರಿದು?
Annexure J, your lordships.
ಎಲ್ಲ ಸ್ಟೇಟ್. ರೂರಲ್ ಡ್ರಿಂಕಿಂಗ್ ವಾಟರ್, sanitation department 1, 2 and 3 learned AGA is directed to accept notice for the respondents.
Your lordships, and Annexure F also, your lordships.
Entry order ಏನ್ ಕೇಳಿದೆ?
No, no, the copy is maybe sorry.
For petitioner to serve set of papers upon the learned AGA forthwith. Next.
57, Roshan Sahib.
Lordship, one more submission. At serial number 58 also similar matter, your lordships.
ಇನ್ನೊಂದು ಮ್ಯಾಟ್ರ್ ಕಾಯ್ದು ಕಷ್ಟನ. Wait.
Appear for the petition. Petition is filed seeking regularization of employment.
ಒಂದು ನಿಮಿಷ. learned ಎಲ್ಲ ಸ್ಟೇಟಾ?
Respondent number 5 is the outsourcing agency. Notice may be dispensed.
2, 3, 4 AGA. Sharp watch and ಬೇಡ ಬಿಡಿ ಅವ್ರೆ.
Please.
We'll see. Emergent notice to the 5th respondent.
I'm seeking interim relief in this petition.
If the petitioners are working today, their services shall not be dispensed with. In regularization in interim order ಅಷ್ಟೇ.
Please, please. And
Next. Same 56 order.
59, Shivraju HB.
Please, my lords. Petitioner, my lords. Whereas, my lord, the present petitioner is appointed by the respondent number 1, my lords, of Karnataka State Road Transport Corporation, my lords. Whereas he is appointed as assistant mechanical engineer, my lords, in the year of 2008. And he has worked.
Prashant Usmani.
Prashant Usmani.
Counsel Prashant Usmani is directed to accept notice for respondent 1 and 2. Skill development officer, government. Third respondent AGA. Petitioner to serve set of papers upon the said council.
Please.
Yes.
60, BC Gnanaya Swami.
The transferring the license, fair price of license, my lord, covered by judgment of your lordship.
Compassionate appointment.
How-
Compassionate program.
House, on the overage, your lordship, it is.
Kodi.
This.
Father having authorization, father died in 24 covered, yes. The petitioner is before this court seeking the following prayer. The father of the petitioner during his lifetime had authorization to run the fair price shop, which he ran up to the date of death on 7/9/2024. The petitioner then submits a application seeking transfer of license that reject ಮಾಡಿದಾರಾ?
Also.
That having been rejected has driven the petitioner to this court in the subject petition. This court in identical circumstances where transfer of license was rejected on the same grounds as following the earlier order, orders passed by the coordinate bench held as follows. Para 3 to end. The learned AGA would not dispute the position of law as is laid down by this court. In that light, same order. Allowed. Next.
61.
Notice, my lords, not order.
Notice, first separate order sheet madi. Learned AGA is directed to accept notice for respondent 1, 2, all respondents.
All respondents.
Yes. Amel heard anta ಮಾಡಿ. 50.
61.
My lords, petitioner was appointed by respondent number 1 as meter reader, my lords. His probation period is not clear, his seniority has not been given. But as per the notification at Annexure M, my lords, if he has completed SSLC with Kannada as third language, he is eligible for the said declaration, my lords.
ESCOM yaru kamte avara? Shivraj Mudol.
Disciplinary, my lords.
Learned Counsel Shivraj Mudol is directed to accept notice for 1 to 5, 6 BS Kamte petitioner to serve set of papers upon the aforesaid counsel forthwith. 7th.
Grateful, my lords.
13th, yes.
62. Roshan Saib Chabbi.
This petition also seeking regularization.
Huh?
Regularization.
Same.
Please.
1, 2, all AG,
Except
1 to
respondent.
4 AGA,
Please.
5 emergent notice.
Maybe
The
dispense.
petitioner is working as on date. His services shall not be dispensed during the pendency of the subject petition.
Please, my lord. Notice to respond number 5 may kindly be dispensed.
Bad
Outsourcing agency, I do not have any relief against them.
But emergent notice ಬೇಡ ಅವರಿಗೆ. Memo haki.
Please.
Yes.
63. Kola Ahmad Ahmad.
Same order as 61, my lords. Herein,
Same as 61.
our R5 notice is to be served on Sumana Nagananda, my lords. Bescom is there.
Why, sir?
Because he was earlier appointed in Bescom, my lords. After that, his transfer was made in
Oh,
HESCOM.
ESCOM.
Yes, my lords.
Council 5 ಗೆ madam Sumana Nagaran, 6 Kamte, 1 to 4 Shivraj Mudol.
Please, my lords. Grateful, my lords.
Yes.
64. AP Hegde.
Seeking voting rights, my lords.
Madam, voting rights order. Voting rights, interim order, voting rights interim order.
Please, I am permitted to.
ಇದೆಯಲ್ಲ ಕೊಡಿ. Hand delivery.
Yes.
ಆಮೇಲೆ. Yes, next.
65. Preliminary hearing. Baswaraj Guruji.
Respond. This is made in respect of seeking regularization of the services. Petitioners are seeking regular services. Not endorsement has been challenged, wherein the endorsement has been given, stating that the posts wherein they are working, it is not a sanctioned post.
Since when are they working?
But since 10 years, they are working.
Where are the petitioners?
10 years, but sanctions.
Bring them under Daily Wage Welfare Act.
Please.
Daily Wage Welfare Act. Appointment ಯಾವಾಗ ಆಗಿದೆ ಇವರು?
Appointment, yes, your lordship kindly take the page number. Annexure E, the page number ಹಾಕಿಲ್ಲ. But they are working as since 10 years ಅಂತಂದು ಹೇಳಿದ್ದಾರೆ ಅಷ್ಟೇ. ಸತತವಾಗಿ 10 ವರ್ಷ ಒಂದೇ ಹುದ್ದೆಯಲ್ಲಿ ಪೂರೈಸಿರುವವರೇ ಹೌದು ಅಂತ.
ಎಸ್ ಗಂಗಾಧರ್ ನೀವಿದ್ದೀರಾ?
So for my lords, the
Government is.
declaration is concerned, my lords. Similar, my lords, order has been passed by its honorable court.
I will not follow this. We'll see.
Please.
Much law is flown after that. ಯಾವತ್ತು ಬೇಕು?
Even this judgment also not produced.
7. List on 7th at the request of the state.
I appear for the petitioner, my lord. Impugned order is page number 78, my lord.
Let we'll take it after lunch. Continue after lunch.
Right submission.
In the interim order, date of election wrongly mentioned, madam. I can't benefits of order.
With your lordship,
Tomorrow morning. Tomorrow, yes.
with your lordship permission. Serial number 131, your lordship, it's a pending election matter. It's necessary of a disposal of that matter. Kindly it may be taken 2:30 if at all
2:30
reached.
count.
Because your lordship,
We'll take it at 2:30.
please. Great.
My lords, serial number 79. We had moved it, but it has been posted for maintainability. I am seeking some accommodation for the 2 or 3 days for the purpose to come before the honorable court. 79, serial number 79.
Whatever you want, madam, adjournment ಕೊಡ್ಬೇಕಾರೆ.
Yes.
6, 7, ಆಮೇಲೆ 10th full week. ಯಾವ್ದು ಬೇಕಾದ್ರೆ ಕೊಡಿ. 6 and 7 ಕೊಡಿ. 3, 4, 5, 9. 1 ಮೇಡಮ್. Whatever time you want.
Till number 118 minutes. In the last occasion, I have mentioned it. For posting in that matter in fresh matters, 2017 dismissal.
I'll take it. ಆ ತರ ಎಲ್ಲ ಬೇಕಾದಷ್ಟಿದೆ. We'll take it.
Parted matter.
Parted matter.
It was 2 times been argued before your lordships in Bangalore itself.
Bangalore. What is that? 482 na?
ಇಲ್ಲ dismissal order, challenging the dismissal order of the branch manager. It's a matter of 2017 dismissal.
All right, we group will see.
Madam, serial number 66. Court officer. Court officer.
ಸರ್ ಹೇಳಿ ಸರ್.
66 ಮಧ್ಯಾಹ್ನ ತಗೊಳ್ತೀರಾ?
66 ಮಧ್ಯಾಹ್ನ ತಗೊಳ್ತೀವಿ ಸರ್.
ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್.
ಕೋರ್ಟ್ ಆಫೀಸರ್ 36 ಡೇಟ್ ಯಾವತ್ತು ಕೊಟ್ಟರು? ಸೀರಿಯಲ್ ನಂಬರ್ 36 ಯಾವ ಡೇಟ್ ಕೊಟ್ಟರು ಮೇಡಮ್?
36 ಸರ್.
ಹೌದು.
36 ಆಯ್ತಲ್ಲ ಸರ್?
6-2ನಾ? ಓಕೆ ಮೇಡಮ್. R1ಗೆ ಹೆಸರು ಯಾರೋ ಹೇಳಿದ್ರು ಮೇಡಮ್, ಗೊತ್ತಾಗಿಲ್ಲ. ಬೆಳ್ಳಳ್ಳಿ ಸಾಹೇಬ್ರು ಇದಕ್ಕೆ 224. R1 ಯೂನಿಯನ್ ಆಫ್ ಇಂಡಿಯಾ ಯಾರಿಗೋ ಹೇಳಿದ್ರು, ಹೆಸರು ಗೊತ್ತಾಗಿಲ್ಲ ನನಗೆ.
62 ಹೌದು ಸರ್.
ಅಲ್ಲ, R ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 1ಗೆ ಯಾರು ಮೇಡಮ್ ಅಡ್ವೊಕೇಟ್ ಯೂನಿಯನ್ ಆಫ್ ಇಂಡಿಯಾಗೆ? ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 1 ಯೂನಿಯನ್ ಆಫ್ ಇಂಡಿಯಾಗೆ ಟೇಕ್ ನೋಟಿಸ್ ಅಂತ ಯಾರಿಗೋ ಹೇಳಿದ್ರು. ಕೋರ್ಟ್ ಆಫೀಸರ್ ಕೇಳಿಸಿದ್ರ?
Court officer, sir. Court officer, sir. ಮೇಡಮ್ ಕೇಳಿಸ್ತಿದೆಯಾ?
ಸರ್ ಹೇಳಿ ಸರ್. ಬಿಸಿ
ಮೇಡಮ್ 109 ಐ ರಿಪ್ರೆಸೆಂಟ್ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್. ಇದರಲ್ಲಿ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಸ್ವಲ್ಪ ಒಂದು ಅಕಾಮಿಡೇಷನ್ ಬೇಕು ಮೇಡಮ್. ಅದರಲ್ಲಿ 109
ಸರ್ ನೀವು ಪಿಟಿಷನ್ಸ್ ಇನ್ಫಾರ್ಮ್ ಮಾಡ್ಬೇಕಲ್ಲ ಸರ್?
ನಾ ಮಾಡ್ತೀನಿ ಮೇಡಮ್. ಅವ್ರು ಮೂವ್ ಮಾಡಿದ್ದಾರೆ ಅಮೆಂಡ್ಮೆಂಟ್ ಬಗ್ಗೆ. ನಾನು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ಬೇಕು, ಅದಕ್ಕಂತ ಟೈಮ್ ಕೇಳ್ತಿದ್ದೀನಿ ಮೇಡಮ್. ನಾನು ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡ್ತೀನಿ ಮೇಡಮ್.
ಸರಿ ಸರ್. ನೆಕ್ಸ್ಟ್ 10th ಹಾಕ್ಲಾ ಸರ್?
ಎನಿ ಡೇಟ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬಿಟ್ಟು ಯಾವ್ದಾದ್ರು ಡೇಟ್ ಹಾಕಿ ಮೇಡಮ್. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬಿಟ್ಟು ಬೇರೆ ಹಾಕಿ. ಎನಿ ಡೇಟ್
10th of February sir.
No problem madam. Thank you very much. Thank you very much. Please.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 36 ಅಲ್ಲಿ R1
ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 66 ಏನಂದ್ರಿ ಸರ್?
ಅಲ್ಲ 36 ಅಲ್ಲಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 1 ಯೂನಿಯನ್ ಆಫ್ ಇಂಡಿಯಾಗೆ ಟೇಕ್ ನೋಟಿಸ್ ಅಂತ ಹೇಳಿ ಯಾರೋ ಒಬ್ರು ಅಡ್ವೊಕೇಟ್ ಹೆಸರು ಹೇಳಿದ್ರು ಮೇಡಮ್, ಅದು ಗೊತ್ತಾಗ್ತದೆ.
ಎಂ ಬಿ ಕಣ್ವಿ ಅವರಿಗೆ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1 ಸರ್ ಟೇಕ್ ನೋಟಿಸ್ ಆಗಿದ್ದು.
ಓಕೆ, ಮತ್ತೆ ಬಳ್ಳೊಳ್ಳಿ ಸರ್ ಅವ್ರಿಗೆ 2 to 4.
ಶಿವರಾಜ್ ಬಳ್ಳೊಳ್ಳಿ ಫಾರ್ 2 to 4.
ಹಾ, ಮತ್ತೆ 5 ಗೆ ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ಅಂತ ಹೇಳಿದ್ರಲ್ವಾ ಮೇಡಮ್?
5 ಹ್ಯಾಂಡ್ ಸಮನ್ ಸರ್.
ಥ್ಯಾಂಕ್ ಯು.
ಏನ್ರಿ ಮೇಡಮ್?
ಸೂರಜ್ ಬಾಬು ಇಲ್ಲ, ರಾಕೇಶ್ ಬಿಲ್ಕಿ ಅದ.
Court officer.
Matter pertains to Dharwad bench, serial number 66.
I appear for the petitioner, my lord. The petition is for setting aside the DE instituted against the petitioner. The it is at annexure H, my lord, page number 78. So this DE is instituted based on the audit report, my lord. Then audit report is at annexure C, page number 18, my lord. So the order instituting the DE violates section 295 of the Karnataka Municipalities Act, my lord.
Who has to answer?
Chief Officer TMC my lord, before KAT.
Who appears?
TMC my lords.
KMS. ಅವರು.
KAT.
Is he a KMS officer?
Please my lords. Chief Officer TMC.
Chief officer ಯಾರನ್ನ ಬೇಕಾದ್ರೆ ಹಾಕ್ಬೋದು. Even community affairs officer also can be posted as chief officer grade 2. ಎಲ್ಲರಿಗೂ KAT ಅಲ್ಲ. If he is an officer of the Karnataka Municipal Administrative Service, only then. ಮೊನ್ನೆ ಹೇಳಿದೀನಿ ಮತ್ತೆ ನೀವು ಅದನ್ನ ಹೇಳ್ತೀರಾ.
Sorry man, I was.
ಎಲ್ಲರಿಗೂ KAT ಗೆ ಹೋಗ್ಬೇಕು chief officer ಅಂತ ತಕ್ಷಣ. Yes sir, who has to answer? KAT ಬಿಟ್ಟು ಬೇರೆ ಏನಾರು ಹೇಳಿ.
Day after tomorrow last night. ನಮ್ಮ colleague ಬಂದು ನೋಡೋರು.
ಯಾರು ಸೌಮ್ಯ ಅವ್ರ ಹೆಸರೇನು?
Kirti.
List the matter on 6th at the request of the council, 7th representing the state. Interim order subsisting will continue till the disposal of the petition. Next.
67, Dinesham Kulkarni, PM Nadav.
On ಮಾಡಿಲ್ವಾ?
The petitioner working as a SDA in a private aided institution. So far as teaching staff is concerned, it is admitted to grant.
Non-teaching staff
Yes.
ಮಾಡಿಲ್ವಾ?
That's why I referred more on annexure H, wherein it is held that she is eligible.
Management. We have already sent, my lord, but it was.
Comment. ನೀವು ಯಾರಿಗೆ ರವಿ?
Your opponent.
Respondent number 7, my lord.
Now he is retired.
ನಿಮ್ಮ appointment ತಗೊಂತಾ ಇದ್ದಾರಾ ಅವರು?
Please, my lord.
Taking away your appointment?
Yes, my lord, he is aggrieved by, now, my lord, the situation has been changed.
He is retired, my lord.
The
Oh, you
sixth
retired
respondent.
Last time,
Last time,
Yes,
my lord.
How's that?
it was
Sixth respondent was one of the aspirant.
Lord,
Now, my lord, he has already attained the age of superannuation.
Lord,
Who was considered to the post of general merit in view of he was overaged at the time of direction. Then, my lord, now he retires before his consideration of his case.
Subsequently, my lord, there
Proceedings
was
are
an
pending.
endorsement.
As per the letter, nobody has been given appointment. And the college has not sent proposal to the government.
But we sent, my lord, it was returned with the endorsement stating that it was additional post since already.
ರಿಟೈರ್ ಆಗಿದ್ರಲ್ಲ ಅದು
Now,
ಕನ್ಸಿಡರ್ ಮಾಡಿ.
under changed circumstances, my lord, they have to review it, my lord.
Will direct reconsideration. Yes.
Please, my lord.
ಅಷ್ಟೇ.
That's the.
Anything else?
The endorsement may be set aside.
That will be set aside.
2 endorsements they have issued. One, invoking rule 8(2), their contention is nobody is entitled for grant in aid, subsequent appointment, but it is not applicable because
It's a STS.
institution is belonging to SC/ST. That rule is not made applicable. So that also I have challenged.
The petitioner is before this court calling in question twin endorsements dated 16/9/2023 and 4/12/2021 and 16/9/2023. Heard Dinesh M. Kulkarni along with also appearing for the petitioner and so and so. The petitioner is working as a second division assistant in the 5th respondent Hampi Virupaksheshwar Swami first grade college run by the 4th respondent. The issue in the list is about admission of the posts hyphen non-teaching to come within the ambit of grant from the hands of the state government. The petition is preferred in the wake of the non-consideration of the case of the petitioner for admission to grant and the consideration of the case of the sixth respondent on the score that he was senior for admission of grant to the post of second division, admission of the grant of the post of second division assistant. Sixth. The heard sounds, I thought sounds. The petitioner is appointed as a second division assistant on 2/11/1995. After about 18 years of service of the petitioner, the college comes to be admitted to grants from the hands of the state. Pursuant to the college getting admitted to grants, the college forwards the proposal of the petitioner for approval on 20th March 2024. Since the said approval had not come about, the petitioner had to knock at the doors of this court in writ petition 106292 of 2016. Pampapati yaru?
It is not.
Sixth respondent.
The sixth respondent had knocked at the doors of this court in so and so. The writ petition was allowed on 2/3/2021.
It is by petitioner.
Another petition filed by the Anasuya is
Synopsis ಅಲ್ಲಿ ಏನು ಪೂರ್ತಿ ಹೇಳಲ್ಲಪ್ಪ.
Annexure came at
number 5 ಅಲ್ಲಿ ಬರ್ದಿದೆ.
page number 39.
1062.
Both the petitioner and the respondent, so respondent number 6, had approached this court in different writ petitions. An endorsement comes to be issued against the petitioner on 4/12/2021 on him filing a contempt seeking implementation of the order passed in his favor. The endorsement was that the petitioner was not eligible to be appointed as there was no vacant post since the sixth respondent had already been appointed and he was senior to the petitioner. The other reason rendered in a subsequent endorsement was invoking rule 8.
Sub-rule 2.
Sub-rule 2 of Rule 8 of Karnataka Education Institutions within bracket Collegiate Education Rules 2003. The petition is preferred on the score that the approval of grant of the sixth respondent and ignoring the petitioner is erroneous, as well as invocation of the aforesaid rules to decline the candidature of the petitioner. The learned counsel Dinesh M. Kulkarni would reiterate the averments in the petition, seeking a direction for admission of the case of the petitioner, admission of the candidature of the petitioner for the grant from the hands of the state. The learned counsel T.M. Nadaf, appearing for the institution, appearing for the fourth and fifth respondent, would submit that the sixth respondent, who was at that point in time appointed pursuant to the order passed by this court, has now retired from service, and the said retired from service, and the proposal is forwarded to the state government for considering the case of the petitioner,
as well as seventh respondent.
So and so. The learned counsel Ravi Hegde, who represented the sixth respondent, seventh respondent, would admit the fact that he has retired.
You innobru.
Sixth respondent.
Sorry. Indian problem.
Lord, he comes.
Iga the present government order, what he has challenged is, my lord, the government has said the Pampapati's case was considered as a general merit candidate because he has overaged. Then, my lord, remaining two posts, my candidature, respondent number 7, was considered under SC category.
If his case is now considered against sixth respondent, what's the problem? How are you?
Yes,
agree?
yes. That's what I'm.
The learned counsel Ravi Hegde, appearing for the seventh respondent, would submit that if the case of the petitioner is considered qua the vacancy that has arisen of the sixth respondent, he would have no grievance.
Yes.
The state the learned AGA for the state would also submit that if a proposal comes about from the hands of the
fourth and fifth respondent, the consideration of the case of the petitioner, que the vacancy that has now arisen in place of the sixth respondent would be met. Then
From date of eligibility. she
ಅದನ್ನ
then-
they will pass. Date of eligibility, ಅವ್ರು ಆಲ್ರೆಡಿ ಇದ್ರಲ್ಲ ಅಲ್ಲಿ.
ಅಲ್ಲ ಅವ್ರದ್ದು ಅಪ್ರೂವಲ್ ಆಗಿರ್ಲಿಲ್ಲ.
ನಿಮ್ದು ಅಪ್ರೂವಲ್ ಆಗಿತ್ತು.
ಅವ್ರದ್ದು ಆಗಿರ್ಲಿಲ್ಲ. And his name was not recommended. Sixth respondent name was not recommended. Only petitioner and seventh respondent name was recommended.
ಗ್ರಾಂಟ್ ತಗೊಂಡ್ಬಿಡಿ. ಆಮೇಲೆ ಏನ್ ತೊಂದ್ರೆ ಇದ್ರೆ ನೋಡಿ. ಇಲ್ದರೆ ಈಗಲೇ ಎಲ್ಲ ರೈಡರ್ಸ್ ಹಾಕಿದ್ರೆ ರೇಟ್ ಅಪೀಲ್ ಹೋಗುತ್ತೆ. Then it will be pending for another 5 years. Why?
That may be kept open. That is
in accordance with law ಅಂತ ಹೇಳಿರ್ತೀವಿ. ಏನು ತೊಂದರೆ ಕೇಸ್. So I have given my anxious consideration to the submissions made by the respective learned counsel and have perused the material on record. The four narrated facts linked in the chain of events, the dates of appointment are all a matter of record. The petitioner, as observed herein above, joins on 2/11/1995 as a second division assistant. His appointment is approved pursuant to the college fifth respondent getting admitted to grant in aid. The tussle for admission of the non-teaching staff for grant in aid loomed large in the institute. Writ petitions had been preferred both by the petitioner and the sixth respondent before this court. The sixth respondent was appointed, ignoring the sixth respondent was brought under the ambit of grant, ignoring the claim of the petitioner. The situation today is that sixth respondent has retired on attaining the age of superannuation. Therefore, the case of the petitioner, therefore there is no impediment today, legal or otherwise, to consider the case of the petitioner for the post of consider the case of the petitioner for admission to grant in aid in the post of second division assistant, as was done to the sixth respondent. The learned counsel for the institute, TM Nadaf, submits that a proposal is sent, or if not sent, will be sent in the next 2 weeks with regard to the recommending the case of the petitioner for admission to grant in aid. 3 months. 3 weeks. 3 weeks. Within 3 weeks, admission to grant in aid. The learned AGA would submit the submission of the learned AGA that in the event the proposal comes about from the institution, the same would be considered in accordance with law and appropriate orders would be passed. And the order passed and communicated to the petitioner. Insofar as the seventh respondent is concerned, he is nothing to do with the appointment against the vacancy of the sixth respondent. Therefore, he cannot have any grievance if the case of the petitioner is considered where the vacancy that has now arisen out of the retirement of the sixth respondent. In that light, in the light of the aforesaid circumstance, I deem it appropriate to pass the following order. The writ petition is allowed. The impugned endorsements stand quashed. The matter is stand quashed. The institution, if not already communicated, shall communicate its proposal for admission of the petitioner to grant in aid, and the state shall consider the same in accordance with law, owing to the vacancy that has arisen out of the superannuation of the sixth respondent. The petitioner shall be entitled to all consequential benefits that would flow from the consideration and admission of the petitioner to grant in aid.
Please.
That should suffice. Ordered. The said exercise shall conclude. The said exercise of communication between the parties shall, and an order being passed, shall conclude within 3 months from the date of receipt of the copy of this order.
Arvind Kulkarni, VM Shilvan.
Petitioners are before this honorable court seeking for regularization as well as for admitting them to the grant in aid.
One by one, sir. First regularization, amel grant.
Petitioner number 1 to 4 have put in all 24 years of service.
In what cadre?
Plus as assistant professors.
Assistant professor?
E colleges.
Assistant professor regularization idea.
In fact, the earlier round of litigation, this honorable court having taken all the contentions of the other side, has negatived their contentions and has passed the orders at page number
How can you-
97.
How can you pass orders of regularization of assistant professors? UGC scales.
How?
Under the UGC, where is the scheme of regularization?
But the request has been rejected only on 2 counts, that though only because I have put in so many years of service, I cannot be regularized. That is what is the ground on which it has been rejected, page number 120.
ಅದಾಯ್ತು 24 ವರ್ಷ ನೀವು ಅಸಿಸ್ಟೆಂಟ್ ಪ್ರೊಫೆಸರ್ ಆಗಿ ಹೆಂಗೆ, how did you work on contract basis?
Initially, the procedures were followed. Even the nominee of the government was also present when the process was taken up for the appointment. Annexure D, page number.
They are not entitled for lords.
Okay.
ಅಲ್ಲ
24 ವರ್ಷ ಕೆಲಸ ಮಾಡಿಸಿಲ್ವಾ?
but regularizing of the services lords, the having regard to the lords, during the pendency of this petition, along with the statement of objection, I have produced lords the Nadodi of the lords the committee. As per that lords, after subsequent development has been taken place.
What development?
That
How are you saying they are not entitled?
lords, they have on the basis of contract work.
I told don't
No,
tell that.
on they have been appointed lords on the contract basis. No, they are continued on the contract basis itself, lords. So regularizing them, lords, without lords calling for the post, lords.
UGC scheme.
They were initially, page number, annexure D, page number 31 may kindly be seen.
ಮೈಸೂರು ಯೂನಿವರ್ಸಿಟಿ ಎಲ್ಲ ಮಾಡಿದಾರಲ್ಲ ಕೊಡಿ.
ಹೌದು, ಅದು ಇದೆ. I place it on record that.
But 24 ವರ್ಷ ಕೆಲಸ ಮಾಡಿ you can't send them.
Without calling for lords.
ಏನ್ qualified? Qualification ಇದೆ 24 ವರ್ಷ
ಅಲ್ಲ
ಮಾಡಲ್ಲ.
qualification ಅಲ್ಲ, we are calling for applications for the lords only on the basis of lords.
Annexure D, page number 31 may kindly be seen. There, the nominee of the government was also present when the proceedings were conducted. Annexure D, page number 31.
Where is your appointment order?
Please, lords, page 31. Annexure
Details
D.
of lecturers with qualification. There is somebody without qualification also. Yes.
And these were sanctioned post and admitted to the grant also. Plus, annexure D, if my lords were pleased to see, third signature, it is DDPI, the departmental nominee.
ಎಲ್ಲಿದೆ?
Lords, annexure D, page number 31, lords. Immediately after the names
of the interview committee. All right.
Immediately after the
DDPI
names.
is also present.
Please.
Where is the appointment order?
Please, appointment order commences from page number 32, annexure E series. Added to this, if my lords were pleased to see annexure Y, page number 97. This is the earlier round of litigation. All these points which have been mentioned in the impugned order has been negatived by this.
Direction is given.
Please, notes, annexure Y, page number 97. The order commences from page number 102. If my lords permit, I'll read the. My lords?
Whose case?
The petitioners.
ಮತ್ತೆ ಯಾಕೆ ಮಾಡಿಲ್ಲ?
Even after this order, they have rejected my the contention.
Rejected by whom, sir?
By the respondent number 1.
ಈ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರ ಅವರು?
Please, that is what is being challenged before.
ಅಲ್ಲಪ್ಪ, ಈ single
This has attained penalty. This has not been challenged. And all these contentions have been negatived by this honorable court in this order. If my lords were pleased to permit me, para number, page number 104, para 5.
Who has rejected it?
Please.
Who has rejected?
Respondent number 1. Respondent number 2, sorry.
Who yaru?
College.
Who yaru?
Commissioner, Department of College Education.
Aದೇ government sir.
Government. Annexure Z is the impugned order. Annexure, page number 116. The reasoning portion commences from 120.
ಆಯ್ತು.
69. 120 is the
impugned order. There, my lords, may I read, my lords, the 2 paras. ಅಲ್ಲದೆ ಉಮಾದೇವಿ ಹಾಗೂ ML ಕೇಸರಿ ಪ್ರಕರಣಗಳಲ್ಲಿ ಒಂದು ಬಾರಿಗೆ ಸೇವಾ ಸಕ್ರಮಾತಿ ಕ್ರಮವನ್ನು ಜರುಗಿಸಿದ ನಂತರ ಇನ್ನು ಮುಂದೆ ಇಂತಹ ತಾತ್ಕಾಲಿಕ ನೇಮಕಾತಿಯನ್ನು ಮಾಡಿದಿರಲು ಸಹ ಆದೇಶವಿದ್ದು ಅನುದಾನಿತ ಶಿಕ್ಷಣ ಸಂಸ್ಥೆಗಳು ಸರ್ಕಾರದ ಅಂಗವೆಂದು ಪರಿಗಣಿಸಲು ಸಾಧ್ಯವಿಲ್ಲದ ಕಾರಣ ಹಾಗೂ ಮಾಲೀಕರ ನೌಕರರ ಸಂಬಂಧ ಕೇವಲ ಆಡಳಿತ ಮಂಡಳಿ ಮತ್ತು ಸಿಬ್ಬಂದಿಯ ನಡುವೆ ಇರುವುದರಿಂದ
ಗ್ರಾಂಟಿನೇಡ್ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಅಲ್ಲ
Grant. Please.
ಸರ್ಕಾರವು ಅನುದಾನಿತ ಶಿಕ್ಷಣ ಸಂಸ್ಥೆಗಳಲ್ಲಿ ಸಿಬ್ಬಂದಿಗಳ ಸೇವೆಯನ್ನು ಸಕ್ರಮಗೊಳಿಸುವ ಪ್ರಶ್ನೆ ಉದ್ಭವಿಸುವುದಿಲ್ಲವೆಂದು ತಿಳಿಸಲಾಗಿರುತ್ತದೆ.
Deliberately passing an order contrary to an order without challenging it is on the face of it contempt, aggravated contempt.
Annexure Y, my lords, already that contention has been
Para 7
negated.
ಅಲ್ಲಿ earlier round of litigation, very same contentions were taken.
This has been negated, my lord.
Page 106.
I will refer it to contempt bench after allowing this. Deliberately order pass ಮಾಡ್ತೀರಾ contrary to the order court. Huh? Who is this man who has passed it? ಕಾಲೇಜು ಶಿಕ್ಷಣ ಆಯುಕ್ತರು
Commissioner of College Education.
The petitioners are at the doors of this court, yet again, calling in question an endorsement dated 31/7/2021 and a subsequent resolution dated 11/9/2022 passed by the second respondent, the Commissioner of Collegiate Education, rejecting the claim of these petitioners for regularization of their services. The petitioners are all working as assistant professors, working in the cadre of assistant professor in which institute? Putturu
Respondent
Swami
number 4
College
institution.
of Teacher, Madam, cost title ಇದೆ.
Fourth respondent.
So, the fourth respondent institution. The facts concerning the entry of service of the petition, entry into the institution of the petitioners need not be gone into great detail, as these very petitioners were before this court in writ petition 110831-1108337
Please.
of 2015, which comes to be disposed on April the 10th, 2019. The facts narrated therein, if paraphrased to the subject order, would suffice. The coordinate bench has held as follows. Quote the entire order. This court, the coordinate bench, negativing every contention of the state by the detailed order, directed consideration of the case of these petitioners for regularization of their services and also directed approval for their appointment to be done and extension of grant in aid. Therefore, the state suffered an order which negatived all their contentions. The order has become final. Pursuant to the order comes the endorsement impugned in the subject petition. The endorsement reads as follows. Quote the endorsement. The endorsement is verbatim similar to what contentions the state had advanced before the coordinate bench, all of which had been categorically negative. The endorsement has again driven these petitioners to this court in the subject petition. I hasten to add that the order passed by the coordinate bench has become final. Therefore, the observations therein also became final.
merely because the court had only directed consideration of their cases would not mean that the state, without challenging the order, would pass an order which is directly contrary to the observations made in the course of the order. Be that as it may, the order of the concerned court, the order of the coordinate bench had stopped at the reference to the judgments of the apex court concerning regularization up to the year 2020. The apex court, in its latest judgment in the case of Jaggu versus so and so, 2024 SSC online SC page 3826, has held as follows. Quote paragraph 7 to 27. The apex court considers the entire spectrum of the law with regard to regularization and holds that making an employee work for long time and leaving them in the lurch would be exploitation of human labor. The case at hand is one such illustration of exploitation of human labor. In the case at hand, the teachers. A perusal at the order of in the case at hand, as observed in the order passed by the coordinate bench, interviews were conducted by the granting aid institution at the time of appointment of these petitioners. The interview committee constituted had a member of the state, i.e. the Deputy Director of Public Instruction. Therefore, the interview had the stamp of the state being a party to it. This happens in the year 2001. We are in the year 2025. Therefore, for the last 24 years, the petitioners have toiled in the institution and are awaiting their regularization, as their fate today hangs in limbo due to the deliberate act of the state in passing an order that is completely contrary to what this court had observed. The impugned endorsement refers to the judgment of the apex court in the case of Uma Devi and M.L. Kesari, both of which stood considered by the coordinate bench and contentions negatived. Even otherwise, the judgment in the case of Uma Devi and M.L. Kesari are considered in the case of Jaggu Supra, and the apex court has distinguished it to become applicable only in certain cases. The case at hand is not the one where the state could decline regularization of these petitioners for having made them work for the last 24 years. Therefore, finding 24 years. Before parting with the order, it becomes necessary to notice the action of the state. A perusal at the order passed by the coordinate bench and the endorsement passed subsequent to the order of the coordinate bench would, on the face of it, amount to contempt of the order passed by this court, as the state does not challenge the order but passes an order as observed, contrary to the orders. It is this that not only fringes on the borders of contempt, but an aggravated contempt, as deliberate wrong orders are passed to get away the order passed by the constitutional courts by the state. It is time that they are hauled up for contempt, as the petitioners are made to repeatedly knock at the doors of this court. The apex court, considering an identical circumstance in Anil Ratan Sarkar 2001 3 SCC 540, has held that passing orders contrary to the orders passed by the court would, on the face of it, become an aggravated form of contempt, and the state would become liable for contempt. They are liable for contempt. But since the direction is given to regularize the service of the petitioners, this court would hold its hands to refer the matter to the contempt court. And if the state would yet again drive the petitioners to this court on the same cause of action, notwithstanding the observations made in the course of this order, this court would view the matter seriously and be constrained to initiate contempt proceedings against the state. For the aforesaid reasons, the following order. The petitioners, the writ petition is allowed, so-and-so quashed, the so-and-so quashed. The cases of the petitioner shall be considered for regularizing their services, and all necessities of documentation between the parties be complete within 2 months within 8 weeks from the date of receipt of the copy of the order. Petitioners shall be entitled to all consequential benefits of the approval of their appointments or the admission to grant in aid, as the case would be, that would flow from the order of regularization. Yes.
69, Shiv Shiro, Jay Gachinmat.
I appear for the advocate for the petitioner.
I appear for the respondent 7, the slum board.
My lordship heard this matter at length. If your lordship should permit me to point out annexure A, page 25 of the petition.
One moment, Amit. What's the matter?
This is a
annexure C. They are claiming that it is a granted land. Subsequently, it was their possession was not with the petitioner for last 40 years, and it is notified under the Slum Board Act. So therefore, my lord, their entire right is depend upon the interpretation of annexure C and consequential mutation order at annexure E. Some records is required. May I request for 3 days time, my lord.
Okay.
I instructed the officer to verify the original records pertaining to annexure C and E.
May I point out? May I point out? The government advocate.
Amit, can we have this on 6th?
It could be, my lord, but the learned government advocate has taken more than 8 months of time on the very same reason. I will point out to your lordship, my lord, you had heard this matter completely. Just two sentences from page number 25, annexure A, the first page, last 2 sentences, your lordship will remember what I had argued. The last 2 sentences.
Yes.
I am grateful. My lord, the learned government advocate is confused about a grant being not made like in the Karnataka state by the order of the authority. But my lords, under the Bombay Land Revenue Code, the grant is to be first given by way of a declaration by the occupant, which is certified by the Mamlatdar and the other officers there.
No,
and another is a Kabulaya.
You submitted all this on the last time.
Great.
Yes, sir. Gangadhar sir.
5th or 6th.
Ashte, ಆಮೇಲೆ ಕೊಡಲ್ಲ.
I will not take it.
Your lordship.
I will not take
Your lordship, may I make a submission? May I make a submission, your lordship?
Yes, sir.
Your lordship, any date other than 4 to 7th, your lordship.
Why?
Your lordship, I don't think I should make this submission, but I would be at Kumbh Mela, your lordship. My personal an opportunity in 144 years, your lordship, once in a lifetime.
My learned friend, if he is appearing for the slum board, my lord, the
slum board.
You are to answer or the state?
State is.
Your lordship, only my only anxiety is if the burden of compensation is made shifted on the slum board. Your lordship, I would be made that would be difficult for the reason that the land given to me was by the government free of everything. There was no petitioner on the records, your lordship. So if the compensation is saddled on my part, your lordship, that would cause some disturbance to the slum board. Only to show that
compensation would be primarily granted by the state.
I'll take it on 11th as a last chance.
Please, your lordship. Please,
my lords may record that your lordships have heard in part.
Yes. I don't think I'll change by then.
Lords, one submission. Submissions made by learned senior counsel in furtherance of that, my lords. Whatever the documents which are sought to be produced by the state, those are lost and they have lodged the FIR before the jurisdictional police station is
ನೋಡಿ
what.
ಏನ್ ಸಬ್ಮಿಷನ್ ಮಾಡ್ತಾರೆ ಅಂತ ಹೇಳಿ. Yes, at the request of the council, at the request of the additional advocate general and the council representing the slum board, heard the learned senior counsel Amit Kumar Deshpande appearing for the petitioner to hear the learned new time keltiran beda, to hear the additional advocate general and the council appearing for the state, list this matter on 11th at 3:30 PM for the hearing. Yes.
Oblige, oblige, Lord.
Bill number 70, Raghavendra Purohit, J. Shetty.
Raghavendra Purohit.
My lords, the wife of the petitioner died due to COVID on 4/9/2020, my lords. The annexure L2, my lords, page 29, these are the guidelines of the government, my lords.
1 ಲಕ್ಷ
50,000 ಕೊಟ್ಟಿದ್ದಾರೆ. As there is no record, my lords, in the government hospital. Death of the
50 ಯಾಕೆ ಕೊಟ್ರಿ?
ಅಲ್ಲ ಅದು ಇಮಿಡಿಯೇಟ್ ಅಲ್ಲಿ 50
ಯಾಕೆ ಕೊಟ್ರಿ ರೆಕಾರ್ಡ್ ಇಲ್ದೇನೆ 50?
ಡ್ಯೂರಿಂಗ್ ದಿ ಡೆತ್ ಅಂದ್ರೆ ಕೋವಿಡ್ ಟೈಮ್ ಅಂತ 50 ಕೊಟ್ಟು ಬಿಟ್ಟಿದ್ದಾರೆ.
ಇಲ್ಲ ಆಯ್ತು 1 ಲಕ್ಷ ತಾನೇ ಇರೋದು, ಮತ್ತೆ 50 ಕೊಟ್ಮೇಲೆ ಇನ್ನು 50 ಕೊಡ್ಬೇಕು.
There is death certificate, my lords. The reason of the death is also due to COVID.
Cause of death.
Yes, my lords. Page number 13, my lords, annexure C.
Page number
13, my lords, annexure C.
cause of death COVID pandemic, RT-PCR positive, COVID pneumonia.
ಇಮಿಡಿಯೇಟ್ 50,000 ಕೊಟ್ಟಿದ್ದಾರೆ ಅಲ್ಲಿ.
ಇದು ಕೊಟ್ಮೇಲೆ ಪೂರ್ತಿ ನಿಮ್ ಸ್ಕೀಮ್ ಪ್ರಕಾರ ಕೊಡ್ಬೇಕು.
ಅಲ್ಲ, as the my lords, the name was not registered in the health and family department, so that other amount was not given, my lords. Direction, my lords.
ನೀವ್ ಯಾರಿಗೆ ಶೆಟ್ರೆ?
Hospital.
ಹಾಸ್ಪಿಟಲ್ ಅಡ್ಮಿಟ್ ಆಗಿದ್ದೀರಾ?
Admit ಆಗಿದೆ. Certificate shows.
Yes. The petitioner is before this court seeking a direction by issuance of a writ in the nature of mandamus, directing the second respondent to approve the compensation of 1 lakh or next year?
1 lakh, my lords.
1 lakh to the petitioner on the death of his wife due to COVID-19. Heard the learned counsel Vaibhavi Inamdar appearing for the petitioner, the learned counsel J. Shetty representing the hospital representing the 6th respondent and the state for respondent 1 to 5. The petitioner is said to be the resident of Gadag Taluk. On 4/9 yavat admit agiddu? On 4/9/2020, the wife of the petitioner is said to have died on account of her being diagnosed with COVID-19. The death certificate to that effect would indicate that the petitioner, wife of the petitioner, dies due to COVID. On the death, immediately 50,000 rupees was approved to be sanctioned to the petitioner on account of the death of his wife. The learned counsel takes this court through the documents with particular reference to scheme idea illi?
Yes. Annexure L2.
Page
29 onwards, my lords. Page 31. 6th
takes
guideline.
this court through ಅಲ್ಲ 1 ಲಕ್ಷ ಕೊಡ್ಬೇಕು ಅಂತ ಎಲ್ಲಿದೆ?
6th guideline, my lords. Page 31.
I am at annexure G.
Annexure L2, my lords.
Annexure
L2.
L2
29 onwards, my lords. 31.
13 29 31 ಯಾವುದೋ ಒಂದು ಕಮ್ಯುನಿಕೇಶನ್ ಇದೆ.
6th guideline.
6th guideline. Takes this court through guidelines issued by the state for compensation to be awarded to those who die on account of COVID-19. Guideline is 6,
Yes, my lords. 6.
ಪರಿಹಾರ ಪಾವತಿ ವಿಧಾನ
ಯಾವ ಪೇಜ್? ಪರಿಹಾರ ಪಾವತಿ ವಿಧಾನ.
Yes, ma'am.
ಅದ guideline 6, which is germane to be considered in the list, reads as follows. 1.5 ಲಕ್ಷ ಕೊಡ್ಬೇಕಾ?
1 ಲಕ್ಷ ಫ್ರಮ್ ದಿ ಸ್ಟೇಟ್ ಅಂಡ್ SDRF 50 ಕೊಟ್ಟಿದ್ದಾರೆ.
ಈಗ 50 ಕೊಟ್ಟಿದ್ದಾರೆ.
50 ಕೊಟ್ಟಿದ್ದಾರೆ my lords.
In terms of the said guideline, the kith or kin of the person who dies on account of COVID-19 are entitled to 1,50,000. 50,000 from the hands of the state and 1 lakh from 50,000 from the
SDRF.
from two different funds of the state. As observed herein above, on the death and the representation being made, the husband, the petitioner, was sanctioned, given compensation of 50,000. The remaining 1 lakh is not approved to the petitioner on the score that the hospital details were not found. The hospital is also before this court. Learned counsel J.S. Shetty, representing the hospital, would submit that the wife of the petitioner was an inpatient, and all records of her being an inpatient and dying due to COVID-19 is placed by the petitioner. In that light, the reason for which the non-consideration of another 1 lakh to be paid to the petitioner is erroneous, or the endorsement that is issued is on the face of it erroneous. In that light, the petitioner deserves to succeed, and a mandamus to the second respondent to pay the compensation to the petitioner in consonance with the aforequoted guideline, as his wife has died due to the COVID pandemic for the aforesaid reasons, the following order. Writ petition is allowed, so and so stands quashed. The mandamus issues to the second respondent to pay compensation of rupees 1 lakh in terms of the scheme, in terms of the guidelines noted herein above. The said order shall be complied with within 3 months from the date of receipt of the copy of the order. If not,
BPL ಅಂತ ಇದೆ ಅಲ್ಲಿ ಕಾರ್ಡ್ದಾರು BPL ಕುಟುಂಬಕ್ಕೆ ಅಂತಿದೆ.
BPL?
ಬಿಲೋ BOT ಪವರ್ ಲೈನ್
below
poverty line. So ಅವ್ರಿಗೆ ಅಷ್ಟೇ ಬರುತ್ತೆ 1.5 ಲಕ್ಷ ಅಂತ. If they produce that, my lords,
in accordance with
please
guidelines ಪ್ರಕಾರ
please
50 ಕೊಡಬೇಕಾದ್ರೂ BPL ಗೆನೆ ಕೊಟ್ಟಿರೋದು.
SDF ದವರು ಅಲ್ಲಿ ಇಮಿಡಿಯೇಟ್ ಕೊಟ್ಬಿಡ್ತಾರೆ. SDF they don't look into the, my lords.
BPL ಅಲ್ವಾ?
ಇದೀವಿ my lords. I have produced.
BPL ಕಾರ್ಡ್ ಇಲ್ಲ ಇದು.
71 BV Somapur.
Yes.
Their submission is that subject to result of WP.
Joining order.
ಒಂದು ನಿಮಿಷ ಹಂಗೆ ಹೇಳ್ಬಿಟ್ರೆ ತಾಳಿ, ಒಂದು ನಿಮಿಷ. Subject to result of WP. ಏನಾಗಿದೆ ಈಗ?
Interim order was granted by this honorable court, and by the in view of the interim order, the petitions were were not disengaged from the services, my lords.
They have continued.
They are continued,
So
but they have not issued the joining order. Now the IMD has issued a
last
letter.
time we had passed this order.
Please.
Yes. Will issue. The learned counsel appearing for the petitioner. This court on 15/1/2025 had passed the following order. The learned counsel representing the seventh respondent has now undertakes that joining orders or joining letters would be issued to these petitioners, which would the submission is placed on record. The seventh respondent shall forthwith issue the joining letters to the petitioners, which will however remain subject to the result of the petition.
From the date of their joining.
Subject
Because-
to result tane. Yes.
Please, my lords, because with respect to petitioner number 2, my lords, they have issued the joining order from the December
All
month,
right.
my lords,
So and so from the date
of interim
the-
order.
From the date of interim order.
From the
All
date.
right. Joining letters which shall, it is needless to observe that the joining letters would be from the date of grant of the interim order.
Please, my lords.
ಅಷ್ಟೇ.
Please,
ಇಲ್ಲ ಅಂದ್ರೆ ನಾಳೆಯಿಂದ ಕೊಡ್ತೀರಾ ನೀವು?
please.
72 urgent. 73 Mallikarjun S. Hireman.
Petitioner, my lord. The service of the petitioner was terminated, my lord.
ಅಂಗನವಾಡಿ?
ಇಲ್ಲ. ಗ್ರಾಮ ಸೇವಕ ಸಹಾಯಕ. As per annexure B, my lord, he was appointed, my lord, and he worked for 12 years, my lord. Earlier, the post was vacant owing to the dismissal of the earlier employee, my lord. Subsequently, he filed an appeal before the labor tribunal, my lord. According to that, my lord, the order was set aside and he was directed to reinstate, my lord.
ಲೇಬರ್ ಕೋರ್ಟ್ಗೆ ಯಾಕೆ ಹೋದ್ರಿ? ಗ್ರಾಮ ಸಹಾಯಕ ಅಲ್ಲೇಂಗ್ ಬರುತ್ತೆ?
ಅವ್ರು ಹೋದ್ರು, previous employee had approached the labor court, my lord. And the labor court has quashed the appointment order and directed to reinstate, my lord. Immediately, my lord,
Yes, no, without.
immediately as per Annexure D, my lord, he was taken into service, my lord, and my service were terminated, my lord.
ಈಗ ಏನ್ ಕೇಳ್ತಾ ಇದ್ದೀರಾ?
Now, my lord, I am seeking for alternate, any other alternate remedies available. Group D post, he is a physically handicapped, my lord. He has
It is
worked for
available, my
12
lords, then.
years, my lord.
If there is any vacancy, my lords,
If there is vacancy, maybe
No, ಆ ತರ ಪಬ್ಲಿಕ್ ಎಂಪ್ಲಾಯ್ಮೆಂಟ್ ಯು ಕ್ಯಾನ್ ಬಿ ಅಕಾಮಡೇಟೆಡ್ ಕಾಂಟ್ರಾಕ್ಟ್ ಬೇಸಿಸ್.
basis. ಅಲ್ಲ, it's
Similar
only an
matter.
honorary post.
ಸೇವಕ್ಕಾಗಿ ಗ್ರಾಮ ಸಹಾಯಕ.
ಸಹಾಯಕ, honorary post.
similar matter ದಲ್ಲಿ Annexure G ಪ್ರಕಾರ there was a direction to similar matter.
WP
ಹೌದು
Vacancy arise ಅಂತ ಹೇಳಿ ಮಾಡಿದ.
2011 ಅಲ್ಲೆಲ್ಲ
If vacancy arises.
since he is a handicapped, my lord.
the petitioner is before this court seeking the following prayer.
First prayer I will not press, my lord, because I sought for quashing of the.
The learned counsel submits that he would not press the first prayer. Therefore, the first prayer is said to be given up, is held to be given up by the petitioner. What remains is a direction by issuance of a writ in the nature of mandamus, directing the respondent to consider the case of the petitioner for any post in the Gram Panchayat. Any post in the office of the Tahsildar, considering his representation submitted on 22/7/2024. The learned counsel for the petitioner submits that the petitioner was initially appointed as Gram
Sahayak.
In synopsis note, Gram Sahayak on 13/12/2012, and after 12 years he was sought to be removed, the removal of which was challenged before the labor court, and the labor court directs reinstatement. So by then some other person was appointed to the post of Gram Sahayak. ಯಾರಿಲ್ವಾ? ವೇಕೆಂಟ್ ಇದೆ ಈಗಲೂ?
ಅಲ್ಲ ಇದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂತಂದ್ರೆ ಅರ್ಲಿಯರ್ ಎಂಪ್ಲಾಯ್ ವಾಸ್ ಡಿಸ್ಮಿಸ್ ಫ್ರಮ್ ದ ಸರ್ವಿಸ್. ಇನ್ ಈಸ್ ಪೋಸ್ಟ್, ಮೈ ಲಾರ್ಡ್, ಐ ಹ್ಯಾವ್ ಬೀನ್ ಅಪಾಯಿಂಟೆಡ್.
ಯಾವಾಗ ಡಿಸ್ಮಿಸ್ ಆಗಿದ್ದವರು?
ಮೈ ಲಾರ್ಡ್, ಹಿ ವಾಸ್ ಡಿಸ್ಮಿಸ್ಡ್ ಆನ್
ಬರ್ಕೊಳ್ಳಿ ಮೇಡಮ್.
11/11/2009.
The petitioner was beginning in Barkodi. The petitioner was appointed as Gram Sahayak, an honorary post, honorarium, on 13/12/2012. His appointment comes about on account of a termination of the incumbent from his appointment. It transpires that the person who is terminated approaches the labor court challenging the order of termination/dismissal. The labor court sets aside the order of dismissal and directs reinstatement of the said employee. His reinstatement leads to termination of the employment of the petitioner. The learned counsel for the petitioner submits that there are still vacancies in the respondent, and he can be accommodated in any posts in the light of the fact that he has worked for 12 years as Gram Sahayak. The learned counsel would also submit that in identical circumstances, the coordinate bench has passed the following order. Page 49 to 51. In that light, I deem it appropriate to follow suit SUIT by directing the respondent to consider the case of the petitioner in terms of his representation, and as and when vacancy arises anywhere in Gadaga, in Haveri Taluk, in the post of Gram Sahayak, to be in accordance with law. Same.
Please.
Ordered according.
74.
49, madam, 49 ಇದೆ ಅದರಲ್ಲಿ ಏನು ಮಾಡಿದ್ದಾರೆ ಅದು ನೋಡ್ಕೊಂಡು ಮಾಡಿ.
Roshan Sahib, repeat.
Lord, in this, the respondent state was directed to furnish documents which led to the termination of petitioner's employment.
State ga
Please.
ಇದರಲ್ಲಿ The tender is for 1 year. Now, next month tender will complete, my lord.
ಯಾರ ಟೆನ್ಯೂರ್?
Tender ಮೇಲೆ ಅವರು they have been appointed, my lord, by the authorities. Tender ಕರೀತಾರೆ. Tender ಕರೆದು
ಟೆಂಡರ್
outsource employees. My lord, may I, my lord, for a moment? A letter, my lord, written by the after the interim order. By taking undue advantage of the interim order, my lord. That,
Who has written?
Petitioner has written a letter making complaint against the officer who has removed him.
ಇದು ಬೇಕಾಯ್ತಲ್ಲ?
For a moment, if I may draw your lordship's kind attention.
No drawing.
My lords,
ಇದು ಬೇಕಾ?
No, my lord, that was because of the reason that petitioner is pressurized to withdraw this petition. Unnecessarily memo is issued after passing of interim order. My lord?
Where is the memo?
Memo, I have furnished it along with memo dated 28/1 yesterday.
Yes, sir. Memo ಕೊಡಿ ಏನು? ಇದಾ?
Now tender is about to, my lord, end. Because the pendency, my lord, it is not possible for the authority also to, my lord, call for tender.
ಎಲ್ಲಿದೆ ನಿಮ್ಮನ್ನ
My lord.
ವಿಡ್ರಾ ಮಾಡಕ್ ಹೇಳಿದ್ದಾರೆ?
ಇಲ್ಲ, that is the reason why they have issued memo, my lords, and the entire reason for termination revolves around the case, my lord. Because if I may request for a moment to peruse the memo which I have furnished. My lord, memo dated 9/1/2025.
Now, one more employee also, my lord, has resigned from the.
ಅಲ್ಲ ಏನ್ ತಪ್ಪಿದೆ ಇಲ್ಲಿ? ನೀವು ಪದೇ ಪದೇ ಅವ್ರಿಗೆ ವಿಡ್ರಾ ಮಾಡಿ ಅಂದ್ರೆ ಇದೇ ಲೆಟರ್ ಬರೋದು.
ಏನು ಮಾಡಿಲ್ಲ ಅವರು.
ಯೋ
ಇಲ್ಲ ಮಾಡಿ ಏನು ಮಾಡಿಲ್ಲ. Now, after the order, my lord, earlier he has been removed, and thereafter, my lord, he has been reinstated. During the pendency of the proceedings only, he has been reinstated. Now, my lord, the tender period is about to end, my lord. And after that period, my lord, we have to call for a fresh tender.
When is the tender ending?
My lord, the next
Definitely you will not be selected in that.
Next month, my lord.
My lord, one humble submission. Though the direction is issued by this honorable court to produce documents which led to termination, the state has chosen not to furnish those documents.
ಈ ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಡ್ತಾ ಇದ್ದಾರೆ. Why termination?
Termination was not later on withdrawn and he has been allowed.
Why was it passed? I asked you to produce the records.
In fact, those documents I have furnished along with memo dated 9/1.
ಏನ್ termination ದಾ?
ಅಲ್ಲ, documents which led to termination.
9/1.
9/1.
ಏನದು?
It says that it is a recommendation letter made by a law minister, based on which my.
ಆಮೇಲೆ the file verification, my lord.
Now they choose not to produce any documents and pressurize me to withdraw. My lord.
ಈಗ this ಪದೇ ಪದೇ ವಿಡ್ರಾ ಮಾಡ್ಕೊಳ್ಳಿ ಅನ್ನೋದು ಕರೆಕ್ಟ್ ಆಗಿದೆ. ಯಾಕಂದ್ರೆ ರೆಕಮೆಂಡೇಶನ್ has come from the law minister.
Thereafter, my lord, that person who has been appointed has resigned and again he has been reinstated at the same place. He is continuing. But now, March 14th, my lord, the tender period will be over. But till then, we will continue, my lord, without any and because of
March ಯಾವತ್ತು?
March 14th. Till March 14th, we don't disturb him, my lord.
My lord, he was up.
Tender has to be called for, my lord, because of pendency of this, my lord, that may be clarified and.
Well, you are working now.
Now I am working, my lords. In fact, I was appointed under a scheme.
You will decide this issue before that date.
Please.
Interim order is there, Allah?
Interim order.
This court on 15/1/2025 had passed the following order. 9/1/25.
9/1.
The learned counsel for the petitioner, this court had directed records to be secured as to why the petitioner was terminated. The records are produced. The documents are produced by the petitioner by way of a memo. His services come to be terminated. His services appear to have been terminated on account of a tippani from the law minister. The learned AGA submits that they said that the orders were not acted upon and it was withdrawn later. Be that as it may, the petitioner alleges, the learned AGA alleges that the petitioner has communicated to the deputy commissioner, which is not in good taste. A perusal at the contents of the communication is that the petitioner is alleging that the higher ups are repeatedly
pressurizing the petitioner to withdraw the petition. There appears to be some connection between the allegation, as the earlier termination was on account of a tippani from the law minister. Therefore, if the state is pressurizing an employee to withdraw the petition, it would amount to interference with the administration of justice and amount to contempt.
One more,
Yes.
one more letter. CSL Mallikarjuna, person has resigned from the post, his post, because of the torture given by the petitioner. Letter about resign ಮಾಡಿದ್ದಾರೆ.
Torture given by?
Petitioner. He has written, he made allegation against him and he has resigned from the post. ಮೊನ್ನೆ ಮಾಡಿದ್ದಾರೆ. Still Mallards, the officers of this contract will.
My lord, that is all created documents just to target me now.
ಹೌದಾ? ಯಾವತ್ತಾಗಿರೋದು ಇದು?
ಮೊನ್ನೆ 2021.
And I am not notified about it also.
ಇದಾದ್ಮೇಲೆ
20th ಆದ್ಮೇಲೆ ಅವರು ರಿಸೈನ್ ಮಾಡಿದ್ದಾರೆ.
ಅಲ್ಲ ಈ ಲೆಟರ್ ಆದ್ಮೇಲೆ ಈ ಲೆಟರ್
ರಿಸೈನ್ ಮಾಡಿದ್ದಾರೆ. We will continue his service Mallards till the substance of this Mallards tender period.
This is how outsourced employees are treated, man.
Cannot call for Mallards fresh tender because of pending of this petition.
Don't call. Yes. List the matter on 18th at 4 p.m. for further hearing. Please. Interim order subsisting will continue till the next date of hearing.
Grateful.
75, Gangadhar Kaskiri, Pawan Vidodati.
Serial number 75 appear for the petitioner's counsel, my lord.
Yes, sir.
A writ petition, my lord, filed seeking a writ of mandamus to execute a lease cum sale deed as per the order of the CEO of the KIDB. On the last date, my lord, my learned friend who's appearing online, he had sought for some time. There was some progress. Now, in all fairness, there is some progress. Day before yesterday, my lord, we received a letter from the KIDB asking for some balance payment of 13,68,000. I'm told
We have paid yesterday only.
Yesterday it has been paid. So,
They have not produced the acknowledgement, Lords. All that they have produced is, Lords, they have made the payment through RTGS. The acknowledgement from KIDB is not produced.
I think payment ಮಾಡಿದಾರಲ್ಲ, acknowledgement from KIDB ನೂ ಇದೆ ನೋಡಿ.
ಇಲ್ಲ ಅದು RTGS ಮಾಡಿ ಅದೇ RTGS through ಕಳಿಸಿದ್ದು ಅವರು ಹಾಕಿದ್ದಾರೆ.
Next memo is there, my lord. We have paid, my lord.
There are two memos ಸರ್ ಮಾಡಿದ್ರು ಅವ್ರಿಗೆ.
Please.
ಸರ್ ಮಾಡಿಲ್ವಾ?
ಅಲ್ಲ ಪೇಮೆಂಟ್ ಮಾಡಿದ್ದು ಹಾಕಿದ್ದಾರೆ, acknowledgement ಮಾಡಿದ್ದು ಹಾಕಿಲ್ಲ.
Is online, my lords.
Anyway,
We have paid, my lord.
Heard the learned senior counsel Vikram Holigod appearing for the petitioner. Pursuant to the order passed by this court on 17/12/20, on 17/12/2024, it appears that the balance payment is now made by the petitioner. With the balance payment or its acknowledgement being made available to the respondent, I see no impediment for the redressal of the grievance of the petitioner by the second respondent KIDB. Therefore, the redressal of the grievance shall be done by the next date of hearing. List the matter on 7th in the fresh matters list.
Please.
Yes.
Lord, may I request for 1 month time at least, Lords. There are 2 sale deeds that are to be executed.
We'll take it on 20.
The week commencing 17th, my lords, because this election
18th.
18th.
Please.
Election ಯಾವತ್ತು?
ಗೊತ್ತಿಲ್ಲ ಇನ್ನ.
Let it be called in the last week of next
month. Can't go
month.
beyond 16th, my lord. So any date after that should be fine with me.
After
Let it be
16th.
called in the last week of next month, Lord.
ಇಲ್ಲ date ಕೊಟ್ರೆ at least there'll be some movement. Otherwise again 1 month they'll
ಅಲ್ಲ
be
ಅದೇ
quiet.
date ಕೊಡ್ಲಿ. Last week of next.
List the matter on 21st February in the fresh matters list.
Deeply obliged, my lords.
Please.
Yes. Next, do the debate.
Sir. 131, VM Shilwant Ranjita.
Wherein your lordship in Shilwant sir matter, they have sought for right to vote as an they were the ineligible voters, your lordship. And interim order was came to be passed stating that they have got the voting right. And I have challenged their challenge. Based on that, Your Lordship, they have got only voting right, not right to contest. Subsequently, the returning officer also accepted their nomination, saying that in the interim order they have got nomination, contesting right also. So their nomination was accepted. I have given the objection. Based on objection, Your Lordship, endorsement came to be passed. In my writ petition, Your Lordship,
ಇಂಟ್ರಿ ಮಾಡಲ್ ಏನಿದೆ ಅಷ್ಟೇ ಈಗ.
interim order is only right to vote. In my petition, Your Lordship, I have challenged that endorsement.
I appear for society, my last. The earlier petition.
ರೈಟ್ ಟು ವೋಟ್
Right
ಅಷ್ಟೇನಾ?
to vote ಕೊಟ್ಟಿದ್ರು, right to vote ಮಾಡಬೇಕಾಗಿತ್ತು, ಅವ್ರು ಬೈ ಮಿಸ್ಟೇಕ್ ಇದನ್ನು ಕೊಟ್ಟಿದ್ರು.
ಬೈ ಮಿಸ್ಟೇಕ್.
ಕೊಟ್ಟಿದ್ರು. Returning officer accepted the same. Later on, the second writ petition came to be filed, wherein the nomination has been stated. Single candidate has been contested. ಬೇರೆ ಯಾರೋ ಮಾರಲ್ಲ, unopposed.
Unopposed.
Now it become uncontested. And result, now there was only two candidates. One is a petitioner number 2 in the earlier writ petition who has only sought for right to vote. And the another candidate is me, Your Lordship. Being eligible candidate, I have challenged their nomination. That came to be stayed.
Now nomination is
Rejected.
accepted or rejected.
Rejected.
ಚಾಲೆಂಜ್ ಮಾಡಿ.
ಅಲ್ಲ ಅವರಿಗೆ ಅದೇ ನಾವು ಸೊಸೈಟಿ ಡಿಕ್ಲೇರ್ ಮಾಡಿ ರೆಡಿ ಇದೆ.
Lordship, one first matter ಅಲ್ಲಿ Lordship kindly peruse the ಇದು ಅದರಲ್ಲಿ 79 members ಅಲ್ಲಿ they are disqualified 75 members. The reason is that Lordship are not attended ಇದು ಅಂತ ಹೇಳಿ and before the previous bench they are considered that Lordship they are not followed 13D order ಮಾಡ್ತೇನೆ ಅಂತ ಹೇಳಿದ್ರು for the re-election. ಅಜ್ಜನ್ ಆಯ್ತು, ಆಮೇಲೆ ಬಂದಿಲ್ಲ, ಅದಕ್ಕೆ ರೆಕಾರ್ಡ್ಸ್ ಕಾಲ್ಫಾರ್ಮ್ ಮಾಡಿದ್ರು, ಸ್ಟೇ ಮಾಡಿ ಆಮೇಲೆ ಆ ದಿನ ನಮ್ಗೆ ಕಂಟೆಸ್ಟ್ ಮತ್ತೆ ವೋಟಿಂಗ್ ಎರಡಕ್ಕೂ ಪರ್ಮಿಷನ್ ಕೊಟ್ಟಿದ್ರು.
ಎಂಟ್ರಿ ಮಾಡಲ್ ಬರೀ ವೋಟಿಂಗ್ ಇದೆ
ಅಲ್ಲ, ಅದ್ರಲ್ಲಿ ಬೈ ಓಸೈಡ್ ಇವನ್ ಮೈ ಸಿಸ್ಟರ್ ವಾಸ್ ದೇರ್, ಶಿ ನೋಸ್ ಆಲ್ ದೀಸ್ ಥಿಂಗ್ಸ್. ಅಲ್ಲ, ಫೇರ್ಲಿ ಹೇಳಿ, ಸಬ್ಮಿಷನ್ ಫೇರ್ ಮಾಡಿ ಅವರೇ ಕಂಟೆಸ್ಟ್ ಮಾಡಿದ್ದು. ಬೀಯಿಂಗ್ ಕೆವೇಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಶಿ ಹಸ್ ಕಂಟೆಸ್ಟೆಡ್ ದಟ್ ಡೇ. ಅಲ್ಲ, ಫೇರ್ ಸಬ್ಮಿಷನ್ ಮಾಡ್ಲೇಬೇಕಾದ್ರೆ, ಇಲ್ಲ ಅಂತಂದ್ರೆ ನಾನು ವಿಡ್ರಾ ಮಾಡ್ತೀನಿ.
ಅನ್ಫೇರ್ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ದಾರೆ.
ಇಲ್ಲ, ಅವ್ರಿಗೆ ಗೊತ್ತಿದೆ ಕಂಟೆಸ್ಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಅಂತ ಪರ್ಮಿಷನ್ ಕೊಟ್ಟಿದ್ರು. ಅಕಾರ್ಡಿಂಗ್ಲಿ ಇನ್ ಸೆಕೆಂಡ್ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಅವ್ರು ಸಬ್ಮಿಟೆಡ್ ನಾಮಿನೇಷನ್, ಇವ್ರು ಹೋಗಿ ಅಲ್ಲೇ ಅಬ್ಜೆಕ್ಟ್ ಮಾಡಿದ್ರು. ಇಂಟರ್ಮ್ ಆರ್ಡರ್ ಅಲ್ಲಿ ಕಂಟೆಸ್ಟಿಂಗ್ ಎಲ್ಲ ಅದಕ್ಕೆ ರಿಜೆಕ್ಟ್ ಮಾಡಿ ಅಂತ. ಅಲ್ಲ ಸ್ವಾಮಿ, ನೆಕ್ಸ್ಟ್ ಅವರು ಇದು ಎಂಟೈರ್ ಇಲೆಕ್ಷನ್ ಹೋಗ್ತದೆ ಅಂತ ನೆಕ್ಸ್ಟ್ ವಿ ಬ್ರಾಟ್ ಇಟ್ ಟು ದ ನೋಟಿಸ್.
Who has the records?
Society has to
Get the records.
13D.
ಅಲ್ಲ, ಅವ್ರು ಫಾಲೋ ಮಾಡಿದ್ರೆ ಅಂತಂದ್ರೆ ಮುಗಿತ್ತು.
13D notices were.
75 ಡಿಸ್ಕ್ವಾಲಿಫೈ ಮಾಡಿದ್ರ?
ಹೌದು.
ಎಲ್ಲ ಶೇರ್ ಹೋಲ್ಡರ್ಸ್ ಅವರು ಇದು ಇದ್ರು, ಏನು ಡಿಫಾಲ್ಟ್ ಶೇರ್ ಹೋಲ್ಡರ್ಸ್ ಯಾರು ಶೇರ್ ತಗೊಂಡಿರ್ಲಿಲ್ಲ.
ಅಲ್ಲ, ಆರ್ಟಿದಲ್ಲಿ ನಾವು ರೆಕಾರ್ಡ್ಸ್ ಕೇಳಿದ್ರೆ ಆರ್ ನಾಟ್ ಸಬ್ಮಿಟೆಡ್.
ಅಲ್ಲ, ರೆಕಾರ್ಡ್ಸ್ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ಓನ್ಲಿ 13D ನೋಟಿಸ್ ಕಳ್ತದೆ, ಐ ವಿಲ್ ಸಬ್ಮಿಟ್ ಬಿಕಾಸ್ ಮೇಲೆ ಅದು ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಇದು ಡೀಮ್ಡ್. ಅದು ರೈಟ್ ಟು ವೋಟ್ ಕೊಟ್ಟಿದ್ರು, ಅದಕ್ಕೆ ರೈಟ್ ಟು ವೋಟ್ ಹಸ್ ಬೀನ್ ಗ್ರಾಂಟೆಡ್ ಬೈ ದಿಸ್ ಆನರಬಲ್ ಕೋರ್ಟ್. ವೋಟ್ ಮಾಡಿದ್ದಾರೆ ಅವರೆಲ್ಲರೂ.
ಅದಕ್ಕೆ ಬೇರೆ ರೆಕಾರ್ಡ್ಸ್ ಕೊಡಲ್ವಾ?
ಅಲ್ಲ, ಎಲ್ಲರೂ ವೋಟ್ ಮಾಡಿದ್ದಾರೆ, ಅವರು ರೈಟ್ ಟು ವೋಟ್ ಸಿಕ್ಕಿದೆ.
Get the record, complete records. The society ಎಷ್ಟನೇ ರೆಸ್ಪಾಂಡೆಂಟ್ ಇದು? Fifth respondent is directed to place the original records that led to disqualification of 75 members prior to the elections on the next date of hearing. List on 6th at 2:30 PM.
So far as the same society is concerned, voting list was granted to us. We have already vote has been.
ಅದು 87 ಅಲ್ಲಿ
List on 6th at 2:30 PM.
May I seek on 31st, because from 1st Your Lordship, administrator has appointed, since the board of members is term is
31st half day, madam, that's the problem.
This one vote now so far as our 87 is concerned, we have.
Illa, we'll post it on 1st Saturday.
please.
List on Saturday first.
87 one.
Same 87 and this on 1st.
On that next date of hearing, Lordship, this honorable court expressed that because of they are not
Date of hearing.
last date of hearing
Next date
and
of
not and the interim order very next date, we brought it to the notice that by oversight my right to contest is not depicted in the order. Then Lordship, there was, because very next day nomination was there, order copy was availed on that date. Lordship, telephonically the concerned officers, but taking instruction, allowed me to submit nomination, Lordship. By taking the advantage of that, Lordship, they objected for my acceptance of my objection.
Ultimately order ತಾನೆ ನೋಡ್ಬೇಕಾಗಿದೆ.
ಅಲ್ಲ, ಅದಕ್ಕೆ ಅವ್ರು ಹೇಳಿದ್ರು, ಅಲ್ಲ ಎಂಟೈರ್ ಇಲೆಕ್ಷನ್ ಹೋಗ್ತದೆ ಅನ್ಕೊಂಡು ನಾವು ನಾಟ್ ಇದು ಅವ್ರಿಗೆ ಹೇಳಿದ್ರು.
Even the court has expressed that ultimately you have not sought for modification of that order ಅಂತಾನೆ express ಮಾಡಿದ್ರು.
ನಾವು ನಾಮಿನೇಷನ್ ಕೊಟ್ಟಿದ್ದೇವೆ ಮುಗಿದೋಗ್ತದೆ ಅಂತ.
Correct ಆಗಿ ಹೇಳಿದ್ರಿ. This court in the next date of hearing.
My only submission is election date is over. Ultimately, both of us have to file the.
Election petition, yes.
ಅಲ್ಲ
ಅದನ್ನ first
ಇಲ್ಲಿಗಾಲಿಟಿ ಎಂಟೈರ್ ಇದನ್ನ
ಅದ್ರ ಜೊತೆ ಹೋಗ್ಲಿ.
Please.
1st February.
1st February.
87 ಇವ್ರು covered ಇದೆ. Only right to vote ಅಷ್ಟೇ ಕೇಳಿರೋದು.
Right to vote 87.
ಅವತ್ತೇ ಮಾಡೋಣ ಎರಡು.
Because same society ಇದೆ, it should be clubbed with, my lords.
First, yes. 80 tag along with 87, list on first.
And there is one more matter along with this.
ಅದೇ ಸೊಸೈಟಿ ಇದೆ.
Please.
ಎಷ್ಟಿದೆ?
That is different constituency, Your Lordship.
Yeah, same constitution.
Counting of the vote.
Same society same.
I'll give that number.
ನಂಬರ್ ಎಲ್ಲ ಕೊಡಿ.
Please.
ಅದೇ ಸೇಮ್
I'll give them.
Continue.
First,
First, yes.
Haldikeri.
ಏನಿದೆ ಇಷ್ಟೊಂದು?
I'm for the petitioners, my lord.
Application for bringing LRs. Applications for bringing
Petitioner
LRs.
number 1. Petitioner number 1 and 3 have died.
ಎಲ್ಲ
LRs.
1 and 3, my lords. Petitioner number 1 and 3 died during COVID, my lords. We have filed IA number 1 to 6, my lord.
Applications are filed to bring in the legal representatives of but deceased petitioners 1 and 3 for the ಎಲ್ಲ ಮೂರು application ಇದೆ for the reasons indicated in the applications seeking continuation of delay of so and so days and abatement and being satisfied and the bringing the LRs on record and being satisfied with the same. The applications are allowed. Yes, so and so nodkoli. Applications are allowed. The petitioner to amend the delay is condoned, abatement is set aside, and the petitioner to amend the cost title accordingly. Yes.
My lords, IA number 6 of 2024, my lords.
Adeno.
Adu additional respondents 5 in the 7th and my lords.
Impleading, what is that 6 to 9?
They are necessary. They are the employer of the petitioners, my lords.
All other applications will be considered along with the main matter, post the matter in preliminary hearing on 14th. Yes.
Much obliged.
Next.
78, Shivasha Nilopan, Lakshman T. Mantegani.
Memo for retirement. Yardidu?
R4.
Who has filed memo for retirement?
ಇಲ್ಲ R4, my lord.
Archana Magdum, my lords.
Archana Magdum.
Mike use ಮಾಡಿ.
ಏನಾಗಿತ್ತು? ನೀವು ಇಲ್ಲ?
Learned Counsel
ಹೌದಾ?
Srimati Archana Magdum has filed a memo for retirement. Who is now representing R4?
Lordship, even the Lakshman T. Matagani name showing, no?
In the light of Lakshman team.
He is also not in panel ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
And who is that? ಹಾಗಾದ್ರೆ ಯಾರು ಬರ್ಲಿ? R4 ಗೆ ಅವರು ಅಂತ ಯಾರು ಹೇಳಿದ್ದು? Lakshman T. Matagani, who is directed to take notice to the 4th respondent, also would submit that he is not in the panel. Therefore, permitting retirement of Srimati Archana Magdum, court notice be issued to the 4th respondent. Yes.
Please.
Next.
79 urgent, seal number 80, Ravi Hegde. Veena Hegde, Prashant Vasu.
2 weeks to do the needful. Yes. Next.
81 urgent, 82, MM Patil.
R24. The registry to print the name of R24 as served, print and show the person as served as he has refused notice. Steps be taken quay. Where ಎಲ್ಲರೂ ಸರ್ವ್ ಆಗಿದಾರಲ್ಲ? The service of notice is thus complete post the matter in preliminary hearing. Next.
12 and 25 ಇದೆ.
83, Patil
ಏನು?
Nandakumar.
ಆದರೆ 12 and 25 ಗೆ ನೋಟಿಸ್ ಸರ್ವ್ ಆಗಿಲ್ಲ.
ಆಗಿದೆ.
Furnishing of PF.
Redirected. ಸರ್ವ್ ಆಗಿದೆಯಾ?
ಆಗಿಲ್ಲ ಅಂತ ಇದೆ. Furnishing of PF to issue notice to R12 and to R25.
ಸ್ಟೆಪ್ ಹಂಗಾರೆ ಅದ್ ಬೇಡ. ಇದು ರೆಫ್ಯೂಸ್ ಮಾತ್ರ ಶೋ ದಿ ನೇಮ್ ಮಾಡಿ. ಆಮೇಲೆ 12 and 25 steps be taken quay 12 and 25. 2 weeks time is granted to do the needful quay 12 and 25. Next.
83, Patil Nandakumar.
Copies to
R1
issue
to 6.
notice
2 weeks to do the needful.
My lord, I'm appearing for petitioner.
Vitalis Daily.
My lord, respondent 1 and 2 institution has been closed, my lord.
Institution is closed.
After withdrawal of the grantee made by the order of present respondent 3, my lord.
ಮತ್ತೆ ಯಾವ ಇನ್ಸ್ಟಿಟ್ಯೂಟ್ ವಾಪಸ್ ಹೋಗ್ತೀರಾ ನೀವು?
My lord,
What are you seeking here?
to fix the liability on the respondent authorities, my lord.
Post the matter, 2 weeks to do the needful.
Please, my lord.
We'll see, yes.
84 Vitalis Daily.
Office objections, council submission. Accepting the submission of the council, office objections stand overruled. List on 31st in the fresh matters list.
85 Sharanappa S. Koliwad.
Same order.
My lord,
86
my lord,
Vishwanath.
in respond number 2 to 5, my lord, Shivraj Bellaki take notice. My lord.
ಯಾವ್ದ್ರಲ್ಲಿ sir?
85, my lord.
2 to 5.
Please, my lord.
Let it come, yes, on 31st next.
86
Connected, please,
Vishwanath
my
Hegde.
lord. And connect, please.
ಅವತ್ತೇ ಮಾಡೋಣ.
My lord, by virtue of the interim order, my lord, the petitioner has participated in the election, my lord, to the respondent number 6 society, my lord. The election is unopposed, my lord. But the returning officer is yet to announce the result, my lord.
ಅದೇ ಸೇಮ್ order.
Same order.
Same process.
Please,
Same
please,
order.
please,
ಎರಡು 86, 87.
please,
87 ಅಡ್ಜನ್ ಆಯ್ತಲ್ಲ. 86 ಸೇಮ್ order.
please.
88 Prasanna Kumar.
Petition lordship in this matter, lordship.
Office objections overruled. Learned AG is directed to accept notice for the respondent. List on 6th in the press matters list next.
1 year ಅಷ್ಟೇ ಆಗಿತ್ತು. 1 year.
Lordship.
Minimum 2 years ಬೇಕು.
Lordship, conviction. ಅಲ್ಲ conviction 3 years lordship in case ಅಲ್ಲಿ.
ಆಮೇಲೆ yes next.
Conviction 3 years only.
6 conviction 3 years ಆಗ್ಲಿ 10 ವರ್ಷ ಆಗ್ಲಿ, you should complete 2 years, yes.
Lord, it become infructuous, lordship.
ಎರಡುನಾ?
89,
90,
91, 92. My lord, 94, my lord, they have to announce the result.
ಅದೇ ಜಸ್ಟಿಸ್ ಶ್ಯಾಮ್ ಪ್ರಸಾದ್ ಅವರ ಆರ್ಡರ್. ಇಲ್ಲಿ ಬರ್ಕೊಟ್ಟಿದ್ದಾರೆ ನೋಡಿ ಪ್ರಶಾಂತ್.
Lord, the petitioners have not participated in the election at all, lordship. That become
To
infructuous.
challenge whatever liberty is given his by his lordship. 92 ವರೆಗೂ ಇನ್ಫ್ರಕ್ಚಸ್. ಇನ್ನು ಮೇನ್ ಬರ್ದಿದಾರಲ್ಲ ಅಲ್ಲಿ. ಎಲ್ಲಿವರೆಗೆ ಪ್ರಶಾಂತ್?
Srinivas Vinayak.
89 ಪ್ರಶಾಂತ್. 89, 90, 91, 92, 93 ಎಲ್ಲ ಇನ್ಫ್ರಕ್ಚಸ್.
Please, lordship. And 94, my lord, they have to announce the result.
ಶ್ಯಾಮ್ ಪ್ರಸಾದ್ ಅವರ ಆರ್ಡರ್. ಆಮೇಲೆ 95,
95, 96, 99, and 100. 96, 99, 100, infructuous.
ಗೊತ್ತಾಯ್ತಲ್ಲ? ಇನ್ಫ್ರಕ್ಚಸ್. 94 ಒಂದೇ ಜಸ್ಟಿಸ್ ಶ್ಯಾಮ್ ಪ್ರಸಾದ್ ಅವರ ಆರ್ಡರ್. ಮಿಕ್ಕಿದ್ ಏನ್ ಬರ್ದು ಕೊಟ್ಟಿದ್ದಾರೆ ಅದು ಇನ್ಫ್ರಕ್ಚಸ್.
Please.
97 also infructuous lords.
97 same order.
Already
98
ಅದು ಸೇಮ್ ಆಲ್ರೆಡಿ ಡಿಕ್ಲೇರ್ಡ್.
98 ಸೇಮ್ ಶ್ಯಾಮ್ ಪ್ರಸಾದ್ ಅವರ ಆರ್ಡರ್.
ಪ್ಲೀಸ್ ಇಲ್ಲ ಡಿಕ್ಲೇರ್ ಆಗಿದೆಲ್ಲ ಅಲ್ಲಿ ರಿಸಲ್ಟ್ ಆಲ್ರೆಡಿ ಡಿಕ್ಲೇರ್ಡ್.
That is kept in separate.
Same.
My lord, I undertake to appear on behalf of respond number 5, my lord.
Yes.
And 6 weeks time to seek appropriate instructions, my lord.
Very good. Yes.
ಯಾವುದು?
98.
ಇಲ್ಲ ಡಿಸ್ಪೋಸ್.
97 ಒಂದು ನಿಮಿಷ ಕನ್ಫ್ಯೂಸ್ ಮಾಡಬೇಡಿ, ಕನ್ಫ್ಯೂಸ್ ಆಗ್ಬಿಡ್ತಾರೆ. 95, 96, 97, 95, 96 ಇನ್ಫ್ರಕ್ಚಸ್ ಗೊತ್ತಾಯ್ತಾ? 97 ಆಲ್ಸೋ ಇನ್ಫ್ರಕ್ಚಸ್. 98 ಜಸ್ಟಿಸ್ ಶ್ಯಾಮ್ ಪ್ರಸಾದ್ ಅವರ ಆರ್ಡರ್. ಆಮೇಲೆ 99 ಪ್ರಶಾಂತ್ 99.
My lord, in 98, my lord, some petitioners are died, my lord. My representative,
ಅಲ್ಲೇ ಚಾಲೆಂಜ್ ಮಾಡ್ಕೊಳ್ಳಿ ಎಲ್ಲ.
my representative have instructed me to seek 4 days, my lord. 98.
ಏನ್ is not covered by that order?
Please, my lord, it is covered.
After election, yes. So and so.
My lord,